So according to my calendar and clock, we have 1 minute. I just want to make sure everything is okay. Miss Heather,
Yes, we're good.
excellent. Good morning, Pete. Good morning, Vice Mayor. Good morning, Commissioner Carrasone.
Good morning.
I see Commissioner Emmerich.
Good morning.
Good morning. Do we have city attorney? Okay, there's city attorney.
How's my volume?
Morning,
It's
Mayor.
good. Is mine okay?
Yes.
Excellent, thank you. Just want to make sure that the people are sound checking while we've got, it's 9 o'clock. So Miss Heather, if you could let me know if we're ready to begin.
We're ready.
Thank you very much. All righty, guys, it's 9 a.m. on Monday, June 15th, and I do call this City Commission special virtual meeting to order. We will go ahead and do a sound check. For those all present, we'll do roll call. Vice Mayor,
Here.
Commissioner Carrasone,
Here.
Commissioner Emmerich,
Here.
thank you. Commissioner Hanks,
He's not on there yet.
one more time for Commissioner Hanks. He's not on yet? Okay. So at this point, I'll go ahead and have him be marked as absent, and I myself, Mayor McDowell, is also here. City Manager,
Yes, ma'am.
City Attorney,
Present.
and City Clerk, I see.
I'm here. Yep.
Thank you. And City Manager, who's our representative police officer for this meeting?
I believe it's the chief.
Fantastic. All righty. So at this time, I will go ahead and announce that we do have a quorum for this special meeting. And Commissioner Carrasone, if you could please lead us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Commissioner Carrasone, for that. At this time, I will go ahead and turn it over to the City Attorney so she can weigh in about the virtual meetings and instructions.
Thank you, Mayor. In accordance with the Governor's Order 20-69 and the City Manager's Emergency Order number 2020-06 revised and number 2020-03, this is a virtual meeting with elected officials, charter officers, city staff, presenters, quasi-judicial applicants and parties and witnesses, all participating through video conferencing using Zoom, which is a form of communications media technology. If there are any technical difficulties that prevent the use of this technology to conduct the meeting must be recessed or adjourned until those problems have been corrected. Due to the ongoing COVID-19 pandemic, City Hall did open to the public this morning, but we are still holding this meeting virtually. Information about ways to watch the live stream and provide public comment are posted on the city's website at cityofnorthport.com/online meetings. That information is also posted on the front windows of City Hall and on the bulletin board and attached to the agenda for this meeting. This meeting is being broadcast live on the city's website, live on YouTube, accessible on video via Zoom, and accessible by telephone via Zoom. To provide public comment, you may submit a written comment via the online public comment form on the city's website at cityofnorthport.com/public comment. That form becomes active at 9 a.m. the day before the meeting and will be deactivated at the end of public comment during this meeting. Public comment may also be made by leaving a voicemail message via telephone at 941-429-1032. Those messages will be accepted the day before each meeting from 8 a.m. until 7 p.m. Required information is referenced on the online form and in the outgoing voicemail message. Comments meeting these requirements that are timely submitted will be accepted and included in the official record of any meeting. Any comment received that does not meet the public comment requirements will be rejected and will not be included in the official record of the meeting. Mayor, it's my opinion that these measures satisfy all applicable legal requirements.
Thank you very much. I appreciate that, City Attorney. All right, so I need a motion, please, to approve the agenda as presented.
So moved.
I'll second.
Thank you. I have a motion to approve the agenda by Vice Mayor, seconded by Commissioner Carrasone. We'll go ahead and take voice vote. Vice Mayor,
Yes.
Commissioner Carrasone,
Yes.
Commissioner Emmerich,
Yes.
Commissioner Hanks, Commissioner Hanks. Okay, and myself a yes. So at this point, we have a 4-0 approval of the agenda with Commissioner Hanks absent. With each vote, I will call his name because he may be having computer issues. So in case he is able to join, City Clerk, when he is able to join, will you please alert me so that way then I can see where we are in the meeting to make sure any communications need to be conveyed to him? for
Yes,
the
he
meeting.
had to restart his computer as well. He emailed.
Thank you very much. Alrighty, at this time, do we have any general public comments for this meeting?
We do have general public comment. We also have some that address the 7-Eleven items. However, they didn't select quasi judicial and take the oath. So we're going to read those ones into general public comment now.
Thank you so much. And the others will be heard when we are in the procedure for the quasi judicial hearing at some point later in this meeting. So right
Yes.
now it's general public comment. So thank you. Go ahead, City Clerk.
The first one is from Judy Leach. I would like to remind our commissioners that you were voted into the position by the citizens of Northport. It is my hope that each and every one of you, when voting today, take into consideration the will of the people who elected you. Some of you may be aspiring to new goals and others may be nearing the end of your term, but let me remind you that your current position as a Northport Commissioner to represent the people you serve today. The next one is from Sarah Harrison. I have lived in Northport for 15 years and am pleased by the growth of the city. However, putting a 16-pump 24-hour gas station in a residential neighborhood is not only unnecessary, but dangerous to the health and water supply of many of the residents surrounding the area. Safety of the residents is also a factor since a 24-hour gas station store can attract loiterers with nowhere else to go during the night. Noise and traffic issues will further inconvenience residents, along with the bright overnight lighting shining into our homes. There are many other places in Northport where 7-Eleven would be a welcome sight, but Cranberry Boulevard and Price is not one of them. The next one is from Sandra Harris. I am against a 7-Eleven at the corner of Price and Cranberry. I vote no. The next one is from Richard Streep. I am opposed to the proposed 24-hour 7-Eleven gas station and car wash at the intersection of Price and Cranberry. Soon we will have to refer to our city as Northport Mall. Enough commercialization already. Use the land for community parks, playgrounds, etc. There are empty commercial buildings all over town. Do we really need another 7-Eleven? The next one is from Marsha Lynch. I am 100% against making an exception to permit and build the 7-Eleven gas station store car wash at the corner of Price and Cranberry because it is not in keeping with the residential nature of this location. Although I live off Chamberlain, several blocks from Price and not immediately adjacent to the proposed building site, I fear increased traffic, crime, noise, and health hazards. I also sympathize with those residing closer to the site and opposed to the building for their same reasons as well as decreased property values. It seems like a move that would really drive a neighborhood down versus enhancing it. When a Northport resident purchases a home in a neighborhood, we expect codes to remain consistent to protect our homes area and not become a major thoroughfare drawn by such a business as a gas station store convenience gas station. Who wants a fuel tanker driving in a neighborhood to make a delivery? Also, most homes in this part of Northport are on wells, so I would hate to see large underground fuel tanks come to this location. Additionally, in spite of well-lighted stores, convenient markets, gas stations are too often targets for crime and easily invited into neighborhood areas with increased traffic. With easy access to a number of gas stations within 1 to 2 miles of the proposed site, I just to not see the need for another one, particularly too close to many residential homes. I also wish to point out there are several home builders along Price with model homes who draw prospective buyers considering Northport for relocation. What kind of impression would you be riding down Price Avenue, where the models are located, and passing a busy gas station in the middle of a neighborhood of seemingly nice homes? I urge you to vote against exceptions to permit this 7-Eleven gas station. Thank you for your consideration. The next one is from Victor Waldron. There are more than enough gas stations in the region of Northport. Community growth will also impact neighborhoods and housing communities. The question is, does this newly very large gas station car wash service station serve the needs of the community, or does it serve the needs of the individual commerce? Putting a building like this in the middle of a multiple established housing communities only brings the opportunity to increase negative impacts on the families trying to live and raise their families. Any business that operates 24 hours a day, bringing in inherent risk for neighborhood safety. If a business like this were established and family made their homes purchase knowing a business like this was there, it would be a choice made by them. Buying a home in a neighborhood that you can plan on raising a family and having your city allow a potential health and safety hazard is not a proper decision to be made by the city council. I ask all parties involved to imagine that you have no right and that any house in that neighborhood could have a business placed where it would directly affect their quality of life. In Northport's history, going back to the General Development Corporation in the 1960s, this area was designed and started for cost-effective housing and family living. When the needs of the businesses out of the way of safety and needs of the families, you have forgotten what Northport, what is today. It is easy to listen to big business and possibilities of more taxation than it is to listen to the working class homeowner that made Northport what it is. I say no to this business being allowed to build in this location. When homeowners leave the area due to new businesses being allowed to come in, what have you created? You will lose me as a consumer of goods and services in Northport if this business is allowed to build at this location. Thank you for listening to me. That's all the public comment for now.
Thank you very much, City Clerk and Ms. Becky. All righty, so at this point, we will go ahead and open up this public hearing. The City Commission special meeting was scheduled and started on May 26th. The Commission approved a continuance of the following quasi-judicial items. Resolution number 2020 R11 for the application SPX 19269. Resolution number 2020 R12 for the application of SPX 19270, and also the Development Master Plan 19-280. That continuance was approved by the Commission for this property that is located at the intersection of Price and Cranberry Boulevard. At this time, I do want to bring in the City Attorney regarding this continuance. City Attorney, the floor is yours.
Thank you, Mayor. As you pointed out, when we left off, the direction was to hold this meeting as a continuance to pick up where the May 26th meeting left off. After having time to do a little bit of research and examine the procedural issues, it's our recommendation that rather than holding a continuance, because the previous hearing was not properly noticed, that the Commission should start today's meeting as an entirely new quasi-judicial hearing. To that end, I have notified all parties of that recommendation. That includes the applicant and staff and the 2 aggrieved parties appearing today of my recommendation, as well as an opportunity to file new evidence under the rules and to have additional aggrieved parties appear. I have also asked the City Clerk to be prepared to enter all public comment received to date which includes public comment received prior to the May 26th meeting. And that if a new hearing is to be conducted today, Mayor, the City Commission must sit as a fair and impartial decision maker, basing its decisions only on what it hears in the hearing today. In doing so, the Commission would have to disregard any information provided in any prior meeting, including the May 26th hearing. This meeting would constitute the complete official record for the applications considered today, and so that is our recommendation.
Thank you, City Attorney. Before we proceed, City Manager, I have to ask, was this meeting for today, June 15th, properly noticed to the citizens and in the newspaper?
Yes, ma'am.
Could you please give me the date that it was advertised in the newspaper?
The notices went out on June 29th, or not June 29th, sorry, May 29th. And it was advertised in the paper on May 31st.
May 31st. Thank you very much. All right, so now we've got the proper notice all cleared up. City Clerk, do we have any aggrieved parties for this quasi-judicial proceeding?
Yes, we do. Maria and John Leslie and Stacy Tracy.
Thank you very much. All right, so based on the City Attorney's recommendation that we hold a brand new, fully vetted quasi-judicial hearing starting at the very, very beginning, I guess I would need to make a motion to hold this new meeting and disregard everything that was presented at the May 26th meeting.
Madam Mayor, this is Jeff Boone, attorney for the applicant. Sorry, we had a little reverberation here. I've been waiting. We've been waiting to see if Commissioner Hanks would resolve his technical difficulties and be present. And it sounded like, from what the city clerk had said, it's not a matter that Mr. Hanks is sick or somehow unable to participate. It sounds like it's a technical issue, and we would request that no votes. The votes that have been taken so far are more procedural. This one we believe is substantive, and we would request that we not go forward. In fact, we would object to going forward at this point without Commissioner Hanks' participation. Hopefully, whatever the technical issues are, they'll be able to be resolved. But we believe, from a due process basis, that we should wait to have the hearings go, not have the hearing go any further until Commissioner Hanks can join us.
Okay, and thank you for that feedback, Mr. Boone. But in the past, if there were technical issues with each of the commissioners, as long as we had a quorum, we were able to proceed. The only time that we were told that we had to stop any commission meeting was if there were technical issues with the server or the public's ability to hear the meeting. So at this time, I will defer to City Attorney to weigh in.
Madam Mayor, you are correct with respect to what the emergency orders require regarding the utilizing the Zoom technology for the meeting. I will point out that if one of the decision makers, one of the members of the decision-making body, a commissioner, is absent for part of the quasi-judicial hearing, then it would not be appropriate for the commissioner to join the hearing midstream.
Madam Mayor, if I may respond.
Hang on, Mr. Boone, hang on one second, please. City Attorney, are you suggesting then that we recess this meeting until Commissioner Hanks is able to either join or say that he is going to be absent for the entire meeting?
That is an option, Madam Mayor. Also, you do have a quorum, so you may proceed without the commissioner, but it is certainly also well within your purview to take a short recess to try to accommodate the commissioner joining the meeting.
Thank you. City Clerk, could you please give me an update on Commissioner Hanks's situation with his technical difficulties?
He said his computer states that he has 3 minutes for the update left on it.
Thank you very much. All right. Commission, let's give Commissioner Hanks and I will hear comments from each of you, but I'm inclined to give Commissioner Hanks 5 minutes to get his computer issues rectified. And then we will continue since we do have a quorum. And I see Commissioner Carrison, you have your hand up.
Yeah, I was just gonna make a motion to do the same exact thing, give him 10 minutes to go ahead and get his computer back up. As someone who just went through this recently, I know how aggravating it is. And because it's a quasi-judicial hearing, I'm a little concerned about not having one of us here, even though he's ready, prepared, and definitely trying to get on. So I would like to give the other commissioner time, at least by 10 minutes, to get back on.
All right, so I will entertain a motion, please, to allow 10-minute recess. Since this is quasi, I just want it done by motion, please.
Yep, move to allow a 10-minute recess due to technical errors.
Second.
And just for clarity, will we be resuming after 10 minutes, even if he has not been able to rectify his computer issues?
I think we'll handle that when the time comes. This is just a recess.
Okay, so I got a motion on the floor by Commissioner Carrison and seconded by Vice Mayor to recess for 10 minutes. Commissioner Carrison, as a motion maker, did you want to speak to it?
I just, this is a quasi judicial hearing. I think as clean as possible is really what we want to do. So.
Fantastic. And Vice Mayor?
Yeah, I'm in agreement. 10 minutes from now to give a recess. Totally agree with the fairness toward Mr. Boone. Glad he brought it up. So yeah, definitely we need to do this.
Fantastic. Okay, we'll go. Seeing no other comments on this, Commissioner Carrison, your vote, please.
Yes.
Vice Mayor,
Yes.
Commissioner Emmerich,
Yes.
and obviously Commissioner Hanks is absent from this, and myself is a yes. So we do have a vote to reconvene at 9:31 promptly. See you in 10 minutes. City Clerk, could you please put a little thing up on the share screen? Thank you. City Clerk, my clock says we have 1 minute. Just want to make sure everything is good.
Yes, and Mr. Hanks, Commissioner Hanks has been added.
Thank you very much. I do not see his name on the
Where did he
list.
go? He was there. Let me see. Give me 1 second.
And maybe because we can only have so many people showing. I don't know.
Hold on. I'm moving him back up again.
There he is. Alrighty, folks, it is now 9:31. And City Clerk, are we?
Computer update, and then I had my internet went down, so I'm creating a hotspot here.
Thank you very much, Commissioner Hanks. Ms. Heather, before we reconvene exactly at 9:31, like I said, I just want to make sure we are recording and everything is good to go.
Yes.
Fantastic. Okay, so since we had to take a recess due to technical difficulties, I will redo roll call. Vice Mayor,
Yes.
Commissioner Carrasone,
Yes.
Commissioner Emmerich,
Here.
Commissioner Hanks, Commissioner Hanks.
He is gone again.
I can see that. Maybe what we need to do is,
I can see him. I just can't hear him.
I can see him, he's moving, his audio just may not be working or he's muted. His hotspot might be failing him, I don't know. City
I thought-
Attorney,
Somebody
Here.
needs to call him. He's back on now.
Commissioner Hanks, could you please announce yourself? He's frozen, I don't think he's here. In light of this situation, I don't know if anybody can reach out to Commissioner Hanks and possibly suggest that if he's able to, come down to City Hall and use City Hall's Wi-Fi. This meeting, we do need to have the 5th commissioner here to avoid any 2-2 votes.
Reminder, he can also join using the Zoom app on his city cell, and he may join by phone as well if he's able to
It's a
see
great
us.
suggestion. So maybe City Clerk can we reconvene for 10 more
I'm
minutes?
here.
Oh, Commissioner Hanks, City Attorney also gave another suggestion. I don't know if you were able to hear that, City Attorney. Could you please repeat?
Oh, I
heard
was just-
everything you guys were saying. You just couldn't see or hear me.
Oh, okay. So you.
So I
Fantastic.
switched off of my phone hotspot. I'm back onto my Wi-Fi, which is working. The problem I had this morning was I turned my computer on and it started updating. And so I had to wait for the update. But I'm here and everything should be working fine now.
Excellent. Okay, so let's start roll all over again just to make sure to keep things nice and clean. Vice Mayor,
Here.
Commissioner Carrasone,
Hey, I'm still here, guys.
Commissioner Emmerich,
Yeah, me too.
Commissioner Hanks,
I'm in the house.
excellent, and myself, I'm also here. So we do have all 5 commissioners present and accounted for. City Attorney,
Yes, ma'am.
City Manager,
I'm here.
City Clerk.
Here.
Thank you very much. So now we are done with our recess. Hopefully we are completely finished with any technical difficulties for everybody involved. City Attorney, since we did have problems with Commissioner Hanks being an integral part of the beginning of the meeting, and this is quasi-judicial, do we need to reread the agenda, public comments, and announcement to your announcement?
No, ma'am. Those were all part, everything that happened before we opened the hearing does not need to be reread. I will just say briefly for Commissioner Hanks' benefit, that once you opened the hearing and announced the items, that I explained that once the city attorney's office had more opportunity to research this issue and the notice problems that we had with the May 26th meeting, that our recommendation is, instead of continuing the hearing and picking up where that hearing left off, that the commission start this as an entirely new quasi-judicial hearing and completely disregard anything from the record that happened before today, meaning that today would comprise the entire record for the proceeding, and that the commission would have to sit as a fair and impartial decision maker, basing its decisions only on the hearing today, disregarding anything else. I also pointed out that I had notified all parties, including the two aggrieved parties, of that recommendation and of an opportunity to file new evidence timely under the rules, and to have additional aggrieved parties appear. And that I've worked with the city clerk. She is prepared to enter all public comment that is sworn and received to date, including the public comment received prior to the May 26th meeting, to enter all of that into the public hearing today during the public comment portion of that hearing.
Thank you, City Attorney. And for Commissioner Hanks's benefit, we will, in that the public hearing just opened and it's not going to take very long, but to keep things nice and clean, City Manager, just to be sure and for the record and for City Commissioner Hanks's benefit, has this agenda been properly publicly noticed, not only to the citizens, but in the newspaper?
Yes, ma'am. As we said earlier, both were done at the end of May.
Thank you very much. And City Clerk, could you please, for Commissioner Hanks's benefit, announce who the aggrieved parties are for this quasi-judicial hearing?
Maria and John Leslie and Stacy Tracy.
Thank you very much. So now back to where before we took the recess, could I please get a motion, if it's so desirous, to continue?
I move that the commission conduct a new quasi-judicial hearings today, and disregard any evidence or any other information provided in the May 26, 2020 meeting related to resolution number 2020 R11 for application SPX 19269, resolution number 2020 R12 for application SPX 19270, and the Development Master Plan DMP 19280.
Second.
I have a motion on the floor as stated by Vice Mayor, seconded by Commissioner Carasone. And before anybody weighs in on this, City Manager, you had raised your hand.
I did. It would be for after this motion is done.
After this motion, thank you very much. So as the motion maker, Vice Mayor, do you have anything you'd like to add?
No, I just believe that this is the right thing to do, most definitely. Thank you.
Commissioner Carasone is the seconder.
Nothing, thank you.
Anybody else have anything to add? Seeing nothing, I agree that this is the proper way to proceed. So anybody's questions and comments, everything, it's starting all over. So thank you for that. We'll go ahead and take the vote to have a whole new meeting, and Vice Mayor is the motion maker. Your
Yes.
vote, please. Commissioner Carasone.
Yes.
Hold on. City Attorney.
Yes, ma'am. It is my recommendation in the script to have to inquire about each party if there's any objection to proceeding in that fashion.
Okay. So as the applicant, do you have any objections to starting this process from the very beginning? Mr. Boone?
Yes, Madam Mayor, for the record, Jeffrey Boone, representing the applicant for the three applications. We have no objection to starting the hearing over today. However, we would object to nothing that has been said or entered into evidence at the May 26th hearing being ignored. We believe that due process, our clients' due process rights would require everybody to recognize reality which is that the saying we lawyers have is you can't unring the bell. What has been said can't be unsaid. What has been heard can't be unheard. And what has been seen can't be unseen. What we want is a fair and impartial hearing today. And we believe that what happened at the May 26th, the testimony and evidence of the May 26th hearing should be part of the record of the proceeding today, recognizing we are starting over again because the city decided to do that because of their concerns over notice. Moreover, and additionally, and what fits in with this objection is that there now appear clearly to have been ex parte communications prior to the May 26th meeting that were not provided to us, to our client, prior to the May 26th proceeding. And had those ex parte communications been properly provided to us, it could have altered what has already been said and what has already been heard and what has already been seen. And again, we believe that it amounts to a due process violation for our client. I would just point out that in a quasi-judicial proceeding, we're supposed to be somewhat like we are in court. And if these types of things, issues had happened at court, in the courtroom, and we would have had to have started over again, a new jury would have been seated. Obviously, that's not practical or possible in a quasi-judicial proceeding before elected officials. You all are the judge and jury. You commissioners are the judge and jury, and we can't seat a new jury or get a new judge. So again, we believe that from a due process perspective, we do have those two objections. Thank you, ma'am.
So just to be clear, are you comfortable with proceeding as a whole new meeting, sir, or is that part of your objection?
I believe that what I've stated is our position. Thank you.
All right, and for staff, are they okay with starting the commission, this quasi-judicial process from the very beginning?
Yes, ma'am.
Yes, Mayor.
Thank you very much. And we have the two aggrieved parties, Ms. Stacy Tracy.
Yes, Madam Mayor, I'm present.
Are you okay with starting this whole quasi-judicial proceeding from the beginning?
Absolutely, Madam Mayor. Yes, ma'am. Thank you.
Thank you. And Ms. Maria Leslie or Mr. Leslie, I'm not sure who is.
Yes, ma'am. We're both here.
Okay. And just for the record, ma'am, could you please state if you are willing to have this quasi-judicial proceeding starting at the very beginning as opposed to continuing?
Yes, that's fine.
Thank you very much. City Attorney, could you please weigh in on Mr. Boone's concerns before we take the vote?
Yes, ma'am. It's our opinion there is no due process issue and completely redoing the hearing. If anything, it's extra due process. And while Mr. Boone makes a bit of a common sense argument about what's already been heard, the ultimate statement is not correct. If there's something that's heard in court improperly, you don't receive a new jury, you don't get a new judge, you simply charge the jury to disregard that, and you sit with the same judge. I think that's the same thing that we're doing here. Everyone will have an opportunity to re-present anything that's already been presented, to present anything differently, to present anything additional. It's a clean slate, and I believe that the commission as a body is more than equipped to start afresh in the hearing. In addition, it has been a couple of weeks since, over 2 weeks, about 20 days since we had that last hearing, so quite a bit of time has elapsed with respect to details and things from the May 26th hearing. I do not have legal concerns from a due process standpoint. with conducting a new hearing today and starting the record completely anew.
Thank you, City Attorney. All right, so hang on one second. City Manager, you still want to wait until after this motion is cleared?
Yes, ma'am.
Thank you very much. All right, seeing nothing else except for Commissioner Carrison, we'll get to you in a moment. We have a motion on the floor, and it's to move that the commission conduct a new quasi-judicial hearing today and disregard the evidence and other information provided in the May 26th meeting related to Resolution 2020 R11, 2020 R12, and the Development Master Plan 19280. As the motion maker, Commissioner Luke, Vice Mayor Luke, what is your vote, please?
Yes.
Commissioner Carrison?
I was going to ask a question and possibly amend it. That's why my hand was up.
Okay.
And it would be to the city attorney. Why can't we just amend it to allow the previous evidence into the record as well as all additional evidence and continue? Or would that not work? I'm not sure. Because I do understand what Mr. Boone's saying is that, you know, you can't undo what's been done. And my concern is that if we don't allow what's been done, it could be a problem in the long run. So that's what my concern is.
City Attorney.
Well, that may not be a problem because we do not have any new parties joining the proceeding. We don't have any additional aggrieved parties. We have the same two aggrieved parties from before and no additional. So if there were no objections.
I thought that there was an objection to not allowing the evidence that was previously submitted. That was what I heard. Not that he didn't have an objection to restarting, but it was the evidence presentation. And so to just say that everything will be null and void from previous meeting was my concern, only that part. Okay, so seeing no other attorneys, would it be, let me ask you this, would it be appropriate if I could just make a motion to allow previous evidence into the record as well as all additional evidence while starting over as intended by the main motion?
I'm going to second for discussion only because I want to make sure that everything is being done according to Hoyle so that there are no future problems. City Attorney, I understand we cannot unring a bell. I understand that there has been 20 days that passes, but if we have this be a new hearing and everything that anybody may have said or will say in this meeting is what we are going to be basing this vote at the end of the meeting on, correct?
Well, it depends on, that's how the motion is currently.
Right.
Commissioner Carrison was discussing. Because remember, not only the documents that have been provided, but the testimony that's been provided. And under our quasi-judicial rules, all testimony is sworn. So that's all the statements of the parties. That's all the statements, and that is also the sworn public comment that is admitted during the quasi-judicial hearing, not the public comment that we heard like this morning that was not sworn.
Will the public comment that was read during the May 26th meeting be entered into the record for today?
It will be read again into the record anew.
From the May 26th meeting?
All public comment received on this item to date will be read into the hearing at the public comment time.
Okay. So I don't see anybody else that has any questions or comments on this. we have a motion, I'm sorry, we have an amendment on the floor to consider and take into consideration the May 26th evidence that was presented to be included with today's hearing. And that was made by the motion maker, Commissioner Carasone, seconded by me for discussion. Seeing no other discussion, we will go ahead and take a vote on the amendment. Commissioner Carasone is the motion maker.
Yeah, Mayor, I just wanted to explain. I think that it's the same as receiving emails, honestly. I think that if you're going to include the past public comment that was sworn in and all the emails that were taken in, that I think it's only correct form of procedure to allow all the evidence in the testimony as well. So.
But and Commissioner Carasone, I know that we have a differing opinion here, but if the applicant, the city staff, and the aggrieved parties have an opportunity to give their presentation and do everything from the very, very beginning, I don't see why we would have to take the May 26th into consideration. This is the public comment is going to be heard. The emails were entered into the record, and they have an opportunity to make their case today at a new hearing.
Well, I'd love to explain it to you, but it's probably just not even going to make sense to you. So,
Vice Mayor?
I understand what she's saying. It is
I do.
kind of like receiving emails, phone calls, talking to somebody. It's more of an ex parte. I see the stuff from the 26 being. I think it all needs to be redone because in my opinion, that meeting was invalid. So everything needs to be articulated again. But I don't mind during ex parte to state that I sat in a meeting on May 26th because I did hear stuff, a discussion on the topic at that point. So I'm going to add it to my ex parte. But to do the meeting over, I think is the only thing that we can do because to me, the other one was invalid. Thank you.
All right, seeing no other hands up, we will go ahead and take the Vice Mayor, you're okay. We'll go ahead and take a vote on the amendment. Commissioner Carasone.
yes.
As the seconder, I am a no. Commissioner Luke?
No.
Commissioner Emmerich?
Yeah, I'm going to be a no.
Commissioner Hanks?
No.
Thank you very much. And the amendment failed 1-4 with McDowell, Luke, Emmerich, and Hanks dissenting. Do you have reasons for your dissent, folks? If you do, please raise your hand so I can recognize you. Seeing none, we will go on and seeing no hands for the main motion. Any further comments on the main motion to continue to conduct a new quasi-judicial hearing today, disregarding any evidence and other information provided in the May 26th meeting related to Resolution 2020 R11, Resolution 2020 R12, DMP 19280. Seeing no other comment, we'll go ahead and take the vote. And I believe, Vice Mayor, you were the motion maker.
Yes.
And I believe Commissioner Carasone, you were the seconder. So your vote, please.
Yes.
Commissioner Emmerich,
Yes.
Commissioner Hanks,
Yes.
and I am also a yes. So we will be starting a new quasi-judicial hearing after, as of right now. So now we have to discuss the time and possibly combination of the items. So I am going to again refer to City Attorney to discuss how we will handle possibly combining these items, or maybe we're going to continue just one at a time. So City Attorney.
Thank you, Mayor. After we spend a decent amount of time trying to discuss this in public hearing, I thought it would make sense to reach out to all the parties to try to see if there would be an agreement to consolidate these three items into one hearing and agree to time limits. Two of the parties did not agree to consolidate the items. It's the commission's practice to consolidate items for efficiency. I think maybe every time that I have seen you had these items that are multiple items relating to one development come before you, you have consolidated them. The city code establishes time limits, as you know, during the hearing of 20 minutes for each party's presentation and 5 minutes for each party's rebuttal and 5 minutes for the closing argument. If the commission chooses to consolidate these 3 hearings into 1 hearing, it can only reduce the time if the parties agree. Without an agreement, when consolidating, the parties should be given the equivalent of the full time for each item. So in this case, that would be 60 minutes for the presentation and 15 minutes each for rebuttal and closing argument. If it were to be consolidated into 1 hearing, each item would need to be voted on in a separate motion. So my suggestion is, Commission, that if there's any interest in consolidating these items and addressing the time limits, that you do that by motion and before voting, that you inquire of each party whether they have any objection to proceed accordingly.
Thank you very much, City Attorney. So do I have a motion to combine these items and address the time limits, please?
I'll move to combine resolution number 2020 R11 for application SPX on 19269, resolution number 2020 R12 for application SPX 1970, and CC Development Master Plan DMP 19280 into 1 hearing, but allowing each party 60 minutes for their presentation, 15 minutes for rebuttal, and 15 minutes for closing argument.
Second.
So I have a motion on the floor as stated by Vice Mayor Luke, seconded by Commissioner Carasone. At this time, before we take the vote and have discussion as a body, I would like to ensure that the parties present are agreeable to this. We'll start with the applicant, Mr. Boone.
We are in agreement, and we would appreciate the applicant being treated the same as the city has customarily treated applicants in the same position.
Okay. And staff?
We're in agreement.
Thank you very much. Aggrieved parties, Ms. Stacy Tracy? Are you in agreement to combining these items, allowing 60 minutes for your presentation, 15 minutes for your rebuttal, and 15 minutes for closing argument?
Yes, ma'am, I'm in agreement to that.
Thank you very much. And Mr. and Mrs. Leslie?
Yes, ma'am.
Thank you very much. Okay, so if commission has any comments to the motion that's on the floor? Seeing none, we will go ahead and take the vote, starting with Vice Mayor as the motion maker.
Yes.
Commissioner Carasone is seconder.
Yes.
Commissioner Emmerich?
Yes.
Commissioner Hanks?
Yes.
And myself, yes. So we will be allowing 60 minutes for the presentation, 15 minutes for rebuttal, and 15 minutes for closing argument. That is the total amount if these items were heard individually. All righty, so now we will go ahead with the hearing, and I will ask the city clerk to please read Resolution 2020 R11 and 2020 R12 by title only into the record.
Resolution 2020 R-11, a resolution of the City of Northport, Florida, granting a special exception for petition number SPX 19-269 to allow for the use of a convenience store with fuel pumps located generally at the intersection of West Price Boulevard and North Cranberry Boulevard in neighborhood commercial high intensity NC-HI zoning district pursuant to the City of Northport Unified Land Development Code sections 53-179 and 53-259. Providing for findings, granting the special exception with conditions, providing for severability, providing for conflicts, and providing for an effective date. Resolution 2020-R12, a resolution of the City of Northport, Florida, granting a special exception for petition number SPX-19-270 to allow for the use of a convenience store with car wash located generally at the intersection of West Price Boulevard and North Cranberry Boulevard in the Neighborhood Commercial High Intensity NC-HI zoning district pursuant to the City of Northport Unified Land Development Code sections 53-179 and 53-259, providing for findings, granting the special exception with conditions, providing for severability, providing for conflicts, and providing an effective date.
Thank you very much, City Clerk. City Manager, I know you had your hand up. You disappeared. I don't know if you still want to speak before we start swearing people in and giving ex parte.
As long as you're not swearing at me, we're fine. But no, you guys you addressed already what I wanted to talk about.
Okay, so we're good to go? All right. So at this point, I would ask the city clerk to swear in all parties needing to give testimony to today's hearing.
Can everyone wishing to provide testimony, please raise your right hand. Do you swear or affirm that the testimony you're about to provide is true and accurate to the best of your knowledge, so help you God?
Well, they're all muted, so we can't hear them. So could you please unmute?
I do.
I do.
I do, Madam Mayor. Thank you.
I do.
Thank you very much. Okay, so now we will move on to ex parte communication. And this is for the commissioners to disclose their ex parte communication. And we will start with Commissioner Hanks. We'll start with you today.
Yes, ma'am. Thank you. As mentioned in the previous one, I did have conversations with the Boone Law Firm concerning this at the very beginning of the process back in July of 2019. Also have received multiple emails, of which I have sent to the city clerk. Any that I have responded to per se, explaining the process is what I typically do, and everything else that I have received, I haven't responded to, has also been sent to the city clerk, and including a couple of Facebook messages have also been sent to the city clerk.
Is that all you have, Commissioner Hanks?
Yes, ma'am.
Thank you very much. Commissioner Emmerich.
Yes, ma'am. As stated before, on, I believe, January 8th of this year, I met with agreed party Stacey Tracy in my office at City Hall. All my emails that I have received have been forwarded to the city clerk, including the emails that set up that meeting between myself and Ms. Tracy. And I was present throughout the May 26th meeting, and I did hear both parties, and I do believe that's all I have.
Thank you, Commissioner Emmerich. Commissioner Caruso.
Yes, all the evidence and testimony that was presented at the May 26th meeting, as well as all emails that have been recorded by the clerk and any other evidence that was placed in our possession as backup for the May 26th meeting. Other than that, no personal contact, no one-on-one or responding emails, and that is it. Thank you.
Thank you, Commissioner Caruso. And Vice Mayor?
Yeah, I had a meeting with Boone & Boone and the developer, a one-on-one, January 22nd of 19. I had a personal meeting with Stacey Tracy, December of 19, and a meeting with Janice Wilbert, January 20th of 2020. I've had a few phone calls and voicemails. I've had a massive amount of emails and one Facebook message. The comments and replies were captured and forwarded to the clerk for the file. I've read a couple of letters to the editor from the Sun newspaper. I listened to the PSAB meeting of 5/7/2020. And of course, listen to the full meeting of 5/26. Thank you.
Thank you, Vice Mayor. my ex parte communication is as follows. First and foremost, I live within 1/4 mile of the proposed development, and I feel that that is very important for me to disclose. I've lived in this area for over 15 years. I've had a one-on-one meeting with the applicant about the development. That was in July of 2019. I had advised my neighbors about the pending development shortly after that one-on-one meeting. I also received a letter about the neighborhood meeting that was held in December. I did attend that neighborhood meeting. I've had various conversations with my neighbors on the status of this project, the code language and processes since the neighborhood meeting and today. I've had a one-on-one meeting with Ms. Wilbert and Ms. Stacy Tracy. I also received the neighborhood 1/4 mile radius letter regarding the PZAB meeting. I did watch the PZAB meeting. I met with neighbors and explained the next steps in the process after that PZAB meeting regarding the code language, public comment process, and gave assurances that the commission has the final authority, not to the PZAB board. I did have a phone call with Ms. DeGray. Unfortunately, I cannot remember the conversation. I've had numerous emails that I received and responded to the citizens. I forwarded those emails to the city clerk for the record. However, based on the quantity of backup materials regarding public emails that were captured, I can't guarantee that all of mine were included. I sent various emails to the citizens to advise them of the PZAB meeting and commission meeting, which were forwarded to the city clerk. I received the letter about today's meeting because I live in that radius. I have a document that I submitted from the Northport PD regarding various gas stations and the Dollar General that was submitted to the clerk for backup. There was a Facebook post that was just captured and sent to the clerk because I am a candidate looking for me to weigh in on this this whole subject. Obviously, I declined, and my Facebook post states that. I also attended and was part of the May 26th meeting, which is now in effect for today's meeting. So I have all that evidence and testimony as part of my ex parte communication. And that's all that I have. Thank you for that lengthy. All right.
Mayor.
So now, I'm sorry,
Mayor,
go ahead.
If I may,
Commissioner
put
Hanks.
up one that was reminded to me as Vice Mayor was speaking. I also had a communication with Ms. Stacy Tracy back in December also.
Thank you. And I just.
Madam Mayor, just.
Hang on, Mr. Boone. Hang on one second. Hang on. I also forgot to disclose that, yes, I read the newspaper. There were articles written about this, this hearing and also editorial. So I am disclosing that as part of my ex parte. Seeing no other hands up for last minute ex parte communication, going once, going twice. Mr. Boone, go ahead. The floor is yours.
Yes, thank you, Madam Mayor. Just for accuracy of the record, and I may have misheard Vice Mayor Luke, but she did accurately recount the meeting that she had with us and the developer. But I believe she said it was February, and I believe that was actually in July. And several of you have also used the July date as well. So again, that was before we had filed the application, and for accuracy of the record, we just want to make sure that gets clarified.
If I did state February, that was definitely a bloop on my part. It was actually July 22nd of 2019. So I may have looked at the two and thought February or something, but thank you for catching that if I stated it incorrectly, but it was definitely July 22nd of 2019. Thank you, sir.
Thank you, ma'am.
All right. All right. So now at this point, we will go ahead and start with our presentations. And we do start, I'm sorry, Miss Stacy
Mayor,
Tracy.
I'm sorry, ma'am, to interrupt. I don't know if it is needed to be put on the record. I noticed this morning that I had accidentally somehow an email that is part of actually and already submitted under the ex parte communication documents. Somehow or another, it was forwarded to the commission or a commissioner, I believe. And I just wanted to bring that point forward. It was not an intentional forward. It was in a group message, but somehow along the line that got in. But it is actually part of the actual, it's already been submitted and it is public knowledge as far as on this. So it wasn't anything that was not disclosed, but I just want to make sure that I brought that up, that wasn't accidental.
Okay, just so you know, ex parte communication is based on what the commissioners have seen outside of this hearing or participated in outside of this hearing. I'm not too sure what you're referencing this morning. So thank you for putting that out there. Thank you.
I just want to be honest. Thank you, ma'am.
All righty, so now we
Madam Mayor?
have Mr. Boone.
Yes, ma'am. Yes, ma'am. Thank you very much. I thought what I understood Ms. Tracy to say that this was not part of her presentation, but was just some other type of communication. Obviously, if it was part of her presentation, it would have needed to have been submitted in accordance with the 5-day in advance rule.
Yes, sir. I'm sure she's aware of that. Thank you for reiterating it. Thank you.
Well, no, could we have a confirmation of that for the record, please, ma'am? Everybody's under oath here.
Yes, sir. It has absolutely nothing to do with my presentation.
Thank you.
Yes, sir.
Okay. Sorry, I was unaware that's what you were looking for, Mr. Boone. I'm sorry. All righty. So now we will go ahead and move on to the presentations, and we will start with the applicant. Mr. Boone, you do have 1 hour, and I understand that just for time's sake, you have an hour for your entire presentation. Obviously, if you don't need a whole hour, we're not going to sit here for an hour just wasting time. So I just wanted to make sure that was known. I have my little timer set for 60 minutes, and sir, you are ready to begin now.
Actually, Madam Mayor, if you could hold that button just for a second. We have several experts who will be taking part in our presentation, and it doesn't appear as though they've been added as participants. So we need to make sure.
I'll wait until until we get the green light from the city clerk, so that way then everybody is on for your presentation. City clerk, could you please let me know when all of his participants have been added?
Heather, we have the names here, if that would be helpful for you.
I have them. Jackson sent them. Thank you.
Okay. And while she's adding them, Madam Mayor, we would never waste your time on anything that's not as far as our presentation goes.
And just for the record, when each one of those people that may be speaking, they just need to state their name and if they have been sworn. If they have not been sworn, then we need to have the city clerk administer that oath.
Jeff, I have everybody except for Jim Collins and Adam Pitts. I don't see them on here.
Neil Campbell needs to be added. Hey, Heather, can you hear me?
Yes.
Oh, Neil Campbell needs to be added as a panelist. Thank you.
Who's that?
Neil Campbell.
He's on there.
I see he's on there now. Thank you.
Jim Collins is not separately. If he needs to participate, he'll participate through the connection Jackson and I are on presently.
Okay. And Adam Pitts, I don't have on here.
He's not needed.
Okay.
Matthew Gillespie's here. Thank you.
Okay, before we begin, Mr. Boone, is all of the people that are helping you with your presentation, have they been added to the screen?
We're looking.
Thank you.
Yes, ma'am.
Okay, so now your time is going to officially begin. Thank you.
All right.
Present away.
All right. Good morning, Commission. My name is Jackson Boone. I'm joined here by Jeff Boone. We are attorneys at the Boone Law Firm in Venice, Florida. We are agents for the applicant Northport Weed and Northport LLC. We have with us today Jacob Mossholder from Creighton, Matthew Gillespie from Kinley Horn, Robert Fletcher from Bass Fletcher and Associates, Neil Campbell from APTIM, and Michael Razor from Razor Transportation Consulting. As you are aware, we have 3 applications before you today: a DMP plan with 4 requested waivers, a special exception for a car wash, and a special exception for fuel pumps. These 3 applications went before the Planning and Zoning Board on May 7th. The DMP and 4 requested waivers received a recommendation of approval. The special exception for a car wash received a recommendation of approval. And the special exception for fuel pumps received a recommendation of approval for 14 pumps. It is important to note that special exceptions are permitted uses by special exception in particular zoning districts. These uses are contemplated by the code as special exception uses for particular properties. We are not asking for exemptions to the zoning code. These are uses that are identified as suitable for a particular property if certain circumstances exist. Additionally, waivers that are requested to the code, and particularly concerning DMPs, section 53.7 of the city code, these are contemplated by the code. That is, waivers to code sections or other city regulations are contemplated by the code, and requesting a waiver and the receipt of a waiver does not amount to breaking the law. The code sets forward that waivers can be requested, and we have waiver requests before you today that you are aware of. You all are aware of where the property is located. It is the northwest corner of the Price and Cranberry intersection. The property is 4.15 acres. It is zoned neighborhood commercial high intensity, and it has a future land use designation of commercial. This property is one of the many vacant neighborhood commercial high intensity properties in the city. The city has actually analyzed the status of the neighborhood commercial high intensity properties and has set forward language in its comprehensive plan concerning the status. The city has recognized that there is importance in developing these neighborhood commercial high intensity properties, not only to provide commercial services that are within a close distance to neighborhoods, but it also provides a tax-based diversification to the city. And also the city has a number of these properties that have been selected as sites for churches and other religious organization properties. And the city has also recognized that for the neighborhood commercial high intensity properties to serve the function to the city really needs to strive to have commercial uses on those properties. At our intersection here, there are 4 corners that each have a 4.15 acre lot with this neighborhood commercial high intensity zoning district. When you go back to 1960, when this part of the city was platted, these 4.15 acre lots were platted and set aside for commercial use. These neighborhood commercial high intensity lots are the only properties with this zoning designation on Price between Sumter and Toledo Blade. And they're the only neighborhood commercial high intensity zone properties on Cranberry between I-75 and US 41. The eastern boundary of our property fronts the collector road of Cranberry Boulevard, and the southern boundary of our property fronts the arterial roadway of Price Boulevard. In Northport, which is the largest city in Sarasota County, Price Boulevard is the major and only east-west arterial roadway in the city other than I-75 and US 41. In fact, I-75, I believe, is classified as a greater arterial. It has a more intense designation, but US 41 and Price Boulevard have the same designation as arterial roadway in the city of Northport. Price is scheduled to be widened to 5 lanes, and due to its central location in the city, this is a true arterial roadway that Northport has today and is planning to serve the city in the future. I'll now pull up our DMP plan. So I'm going to share my screen. Give me one moment, please. Can you all see this plan here? Mayor McDowell, can you see this plan on the screen?
For the record, Mr. Boone, yes, I can see it.
Okay, thank you.
Yes, sir, I can see it. I just want to make sure that everybody else can see screen share.
Yes.
Commissioner Emmerich and Commissioner Carasone, can you see it?
Yes, and we have a copy of it, hard copy as well.
Yes, we do. All right. Commissioner Luke, can you see it too?
Yes, ma'am.
Thank you very much. Screen sharing is working officially. Thank you.
Thank you. What we have here before you today is a unique site design that is offered by our development proposal. We have designed our site to pull our development towards the intersection of Price and Cranberry and leave a large and substantial separation between the residential lots that abut our 4.15-acre neighborhood commercial high-intensity zone property. Aside from the construction of the stormwater pond, we are leaving the remainder of the property between our development site and the residential lots as undisturbed as possible. From our car wash building going to the west, the closest residential lot is 217 feet away. From our convenience store building going to the north, the closest residential lot is 234 feet away. To the south, across Price Boulevard, is another 4.15-acre commercial high-intensity zone parcel that has the Dollar General store, as well as a vacant development pad on that property. To the east, across Cranberry, is another 4.15-acre neighborhood commercial high-intensity zone property that is currently vacant. The setbacks required by neighborhood commercial high-intensity are 30 feet when adjacent to residential. Comparing this 30 feet to the setbacks of 217 and 234 feet, we have a site design that provides a substantial transition from the commercial to the residential in a manner convenient to and yet not disruptive to the adjacent residential areas. We have conducted a professional study to analyze our site design in relation to the nearby residential properties, and I will now turn the presentation over to Mr. Robert Fletcher of Bass, Fletcher & Associates.
Mr. Fletcher, we can't hear you. Could you please make sure you're unmuted?
I am. I just unmuted it. Can you all hear me now?
Yes, sir. Just state your name, and if you have been sworn, if you have not, please let us know.
My name's Robert Fletcher. I have been sworn.
Thank you. Please proceed.
All right. By way of establishing who I am and what I do, I'm a state certified general appraiser. I've got roughly 23 years of experience, run a small firm in Sarasota, Bass, Fletcher & Associates. For this question, I've been hired by Crichton to examine a particular question with regards to the site plan that you've just seen. Specifically, the distance and the buffer provided, are they sufficient to mitigate any impacts to property values for the adjacent properties, the adjacent 11 lots? It is in theory, should be adequate. these kinds of buffers are used routinely between commercial and residential development. However, to actually test the question, what I did was look for natural experiments in the real estate marketplace. That is, I looked for places where existing retail commercial development of high intensity is adjacent to retail single family residential development, but with some sort of buffer in place similar to what is proposed here in terms of distance, the placement of the retention ponds, and lands. I'm going to give you a real brief summary of it and the findings, and I'll be available to drill down on any of the details should the commissioners wish it. In short, I found 5 examples that were similar enough to make a reasonable comparison. All of the examples are locations in South Sarasota County, and they're all for sales of residences that have taken place in the last 24 months. I'm going to list each one of the examples and describe it very briefly. The first one is in the city of Northport. It's the Holiday Park neighborhood. This is generally in the area of the southwest quadrant of Tamiami Trail and Sumter Boulevard. Along Tamiami Trail, there's a strip of retail development, 6, 7, 8 stores. Behind them are their parking areas, storage areas, and delivery areas. Immediately south of those areas is a kind of existing area. There's a drainage canal that runs east and west directly behind the commercial areas that has a good deal of natural growth on both the northern and southern banks. It's about 150 feet wide. Immediately opposite the canal, immediately on the south side of the canal from the retail areas, is the Holiday Park neighborhood. It's a manufactured home neighborhood about 45 years old. What I did was examine the rows of residences that back right up to the buffer and compared those to other residences otherwise similar that are multiple rows into the neighborhood, 2 or 3 or 4 rows behind the buffer, so that the only real difference between them is, do they back up to that commercial area with the buffer or not? Again, briefly, I found 5 sales that backed up to the buffer. They had an average price of $93.78 per square foot. 6 sales in the interior area, a difference of, they had an average of $94.69 a square foot. A different, beg pardon, the difference between the 2 averages is roughly 1%. So it appears whatever effect that the proximity to the commercial, the buffered commercial has, it's 1% or less. Statistically not very significant. Now, a similar procedure was used for the other 4 examples. The next one I looked at was the Watercrest development. This is in the city of Venice. It's a new development at the northeast quadrant of Jacaranda Boulevard and Venice Avenue. The residences are in construction now, and right at the corner, the northeast corner of that large roundabout, there's a 10-acre area that is set aside for high-intensity commercial, a grocery-anchored shopping center, I believe. It's not constructed yet. Who buys in that neighborhood knows that it is going to be. Now, the developer there has purposely placed a roughly 150-foot buffer area between the commercial and his adjacent residences. They've placed their stormwater retention in there, as well as some landscape buffering. So physically, it's similar to what's being proposed here. All the residences that are being sold are brand new. So some of them back up to that buffer and others are 2, 3, 4 rows in. They're physically very similar. I found 4 sales in the last year that are back right up to the buffer area. They average $166 a square foot. 4 other sales, physically similar, also brand new. Within the interior area, they also average $166 a square foot. These are all new construction, so at least the buyers and the developers here feel they don't have to discount the homes that back up to the commercial. Third example I looked at, previously mentioned by Mr. Boone, is the dollar store that is on the south side of this intersection, directly across Price from the proposed building. That store was built in 2014, and the existing open space between the store and the adjacent set of lots is about the same as what's proposed here, ranging between, looks like 185 and 325 feet from the store to one of the adjacent lots. In that case, a lot of the adjacent lots are still vacant. There wasn't enough data there to look at sales of an existing home that backs up. However, there was one recent sale of a lot there just in April of this year that sold to an owner. They paid $12,500 for it. A 10,000 square foot lot, or about $1.04 a square foot. Now I compared that to 2 other very recent sales, otherwise similar, one 2 rows of lots back, one 8 rows of lots back into the adjacent neighborhood. Those lots were a bit smaller and sold for $11,000 and $10,000 respectively. Their prices were an average of $1.07 a square foot. So $1.04 versus $1.07, a difference of about 3% in that case. Fourth example, the name of the neighborhood, I'm uncertain, but in the same area as the first one, near the intersection of Tamiami and Sumter, there's a similar situation on the north side of the road. On the north side of Tamiami are 2 heavily anchored retail centers, one with a grocery anchor, one I believe is a Lowe's. There's a neighborhood, behind the retail, there's again a large drainage canal that has grown up both on the north and south banks. North of the canal is the neighborhood with 150, 200, 300 homes. There's a row of homes that backs right up to the canal with the retail behind them, and then many homes in the interior of the neighborhood. Comparing those two, just parenthetically, the homes there are all about 40 years old. So, a well-established economy there. The 5 adjacent homes sold for an average of $135 a square foot. 5 otherwise similar homes in the interior, similar in size and age and condition, but the only real difference was they were 3 and 5 rows back from the retail. They sold for an average of $131 a square foot. The difference there being plus 3% for the homes adjacent to commercial. Fifth and final example, I looked for something that was as physically similar to what's proposed here as possible. That is a purpose-built gas station convenience store. There is one example like this on Tamiami Trail in Nokomis. There's a Hess station on the west side, just north of Blackburn Point Road. That Hess station backs up to the Laurel Hollow neighborhood. In the case of that station, either by design or by accident, they built it on an extra large, extra deep piece of land. So the station is close to the highway, and they have roughly 200 to 300 feet of open space between the back of the building and a half dozen homes that back up to the station. The retention area isn't placed in there. There's no particular landscaping there. It's simply open space. In the last 2 years, there have been 2 sales of the adjacent homes. They averaged $167 a square foot. There have been 5 sales of otherwise similar homes in the interior of the neighborhood. They averaged $163 a square foot. So the difference in this case is about plus 2% for those that back up to the Hess station. In summary, overall, in these examples, I looked at 39 different sales, 17 of them being adjacent to retail and buffered in a way that is more or less similar to what's proposed here, and then 20 otherwise similar residences between them. And the differences, they varied from -3% to +3%. None of them really showed a pattern of an impact from the impact to the real estate values, at least, from being adjacent to buffered commercial. It seems to me that there isn't a pattern of buffered commercial like this having a negative impact on property values. And that's my presentation. I will gladly drill down on any of this detail or proof if the commission wishes me to.
Thank you, Mr. Fletcher. Continuing with our presentation, I will pull the site plan back up. With our DMP plan, we have the centrally located convenience store. That's 3,454 square feet. There's a 979 square foot car wash building that flanks its western side. Our fuel canopy is located on the southern side of the property, fronting the arterial roadway of Price Boulevard, which contains 8 fueling stations, which equals 16 pumps. Again, when you see the site plan and our unique site design, you can see the setbacks that are provided, which are far in excess of those required by the code. Respectively, this is 7 times greater the required distance to the west and 8 times, almost 8 times greater the required distance to the north. Access to our site is offered from Cranberry Boulevard and Price Boulevard and has been coordinated with city staff as well as the Price Boulevard widening project. Currently, a pork chop channeling device is proposed to restrict the Cranberry Boulevard access to right in, right out. However, should you desire this pork chop channeling device to be removed to open up the access, we can accommodate this request. The height of our fuel canopy, car wash building, and convenience store building vary from approximately 16.5 to 18.5 feet and provide a uniform appearance from the street. The fuel tank system for the fuel pumps is located at the southern portion of the property fronting the arterial roadway of Price and is the modern UST tank system. This system is double walled and monitored by an electronic system and is compliant with all state and federal safety regulations. At this time, I'll turn it over to Neil Campbell to provide a more detailed explanation of these fuel systems.
Good morning, everybody. Can you hear me?
Please be sure and state your name and that if you had been sworn or not.
I'm Neil Campbell, and I have been duly sworn.
I'm sorry, were you sworn, yes or no? You broke up.
Yes. Yes.
Thank you. Just needed it for the record. Thank you, Mr. Campbell. Go ahead, please.
Understood. Okay, so my position this morning is just to present you with the current construction regulatory requirements and standards for these fuel systems that are put in place in Florida. I have a presentation. You want me to pull it up? I'm just checking. Can everyone see that? Okay. Can you see the screen for the presentation? I just want to confirm.
Go ahead, sir.
Okay, thank you.
Yes.
Okay, if you look here in Florida,
Yes, sir, I can see it.
okay, the primary source of drinking water is the groundwater. So Florida has a much more stringent and long-term view towards the protection of that groundwater. So regulated substances such as petroleum products are controlled, and the systems by which they have been controlled and improved upon have changed significantly in the last 20 years. This is an example here that was not in place until recently. This is the requirements that operators of fuel systems have to maintain financial responsibility. In the past, there were many petroleum retail facilities in Florida that were not covered by this. In order for everyone to understand how seriously the state takes this, they put in place a trust fund, which is still funded off of sales of imported gasoline by barrel, and is roughly—
Mr. Campbell?
Yes.
Mr. Campbell? Mr. Campbell?
Yes.
Could you please hold on 1 second? I'm pausing your time. Hold on 1 second. I am pausing your time. City Clerk, could you please confirm that if this was added to the backup materials? This,
Yes, give me a moment.
and I have paused your time, Mr. Campbell, so don't worry about that. I just want to confirm that this document was in the backup materials.
Yes, it was.
Thank you very much. I appreciate that confirmation. And Mr. Campbell, your time is resumed. Thank you.
Thank you. So the state took this seriously and created a trust fund off of gasoline sales, which is being used to go back and clean up those formerly unprotected sites. However, currently, I wanted to show everyone this is the system where they have a financial responsibility requirement for insurance, so that you install, if something happens, you are completely responsible for it. In this presentation, which is in the attachments, there obviously there's above ground storage tanks and underground storage tanks, which is in play for the discussion today. I want to just bring that to everyone's attention. It is a state mandated protection. You cannot operate without this in place. Then I had discussed and looked at a lot of the concerns regarding the vapors at the site, and I wanted to address that. The vapors are a natural occurrence from a petroleum product. It does want to vaporize off. Certain conditions will make that change and be more aggressive. I wanted to go through some of the protections and the conditions under which these tanks and these petroleum products are stored. This has been recognized for quite some time, and if you recall back not too long ago, I think everyone had the experience of struggling with filling their tanks with those funny little nozzles on the end with the expandable accordion system. That was called stage 2 vapor recovery. So this has been looked at for a while. Stage 1 is always in place, and it is a recovery process whereby when you fuel, when the tanker pulls up and dumps fuel, the vapors that are displaced from the petroleum product in the tank are returned to the tanker. They actually go back into that tanker, and that goes back to the bulk fueling facility. 2 reasons. 1, for containment for the atmosphere. 2, it's actually valuable. It's money. The vapor is fuel, and it drops back in and condenses and returns. The stage 2 I discussed that was in place was taken away by the state of Florida under the Federal Register because we didn't need it, because automobiles have been improved, and inside each automobile is a carbon cell that sucks that vapor as you fill your tank. So that has been put in place. Vent stacks on the fueling facilities are put in place to allow equilibrium. They're not designed to vent out. or in as per, a primary function. They are there to equilibrate the fuel. So venting is a strong word that could be, described as like a fuel stack from a chimney or something. That's not the case here. So when you pump gas out of the fuel tanks, you have to have a relief of pressure, otherwise they'll never work. So that's one of their primary functions. If there was any major pressure increase, they're there for that reason too, but that is rare and never really occurs in my experience. The fueling returned, the vapor returns to the tanker, that takes care of that displacement, and the temperatures in the groundwater are predominantly neutral. It's underground. It doesn't feel like your car when it heats up during the day and then cools down at night. They stay fairly constant, so you really don't have that impact that causes the venting. I wanted to go through some of the things, and in my presentation later talks about this. The fact that you've got a liquid, sure, there could be a spill, and humans are handling it. But the system that's put in place has numerous systems to protect that from the environment. And again, this goes back to the fact that Florida has groundwater as its drinking water source. So this has been put in play here. You cannot compare this to other states. You cannot compare this to other parts of even North Florida where the clay is. So I'll tell you now, in Georgia, abutting states, you can't compare this. This is very unique to Florida. So we have a strong enforcement of systems. We have institutional controls, the financial responsibility I talked about. The system is always being monitored all the time electronically. The regulations for the design of the system follow the air quality standards, such as the venting system I described, and everything else is contained. If something goes wrong, everything has to be put out of service, and you'll have seen that before, as frustrating it is when you pull up to the dispenser, and that's why it's out of service. And then they are fixed quickly. The spills have to be reported in 24 hours. There's a format for that. Then they have days to check on if the spill impacted the environment, and then if need be, further investigation takes place. However, the State Watch Office is being put in place by the former governor, and all residents can also report if they see something. So I want to just point out everything is heavily regulated and for a purpose, obviously to protect the environment. This property, of course, we know is not impacted at all. So to take away a bit of the mystery of the fuel systems, underground storage tanks are a lot more sophisticated. Everyone sees just the circle on the top, the guy drops the fuel, but there are a lot of mechanisms put in place to keep these things safe. I want to just point out, this is the stage one recovery I talked about. The tanker would hook up here and change the fuel, the vapor would come back out. There's a bucket surrounding the fuel drop, which protects it from spills. There are strike plates here. These are for if the old-fashioned method of measuring the tanks, you put a stick down to protect the bottom. The pump is at the end and it pumps up through. All this piping is double wall containment. I'll go down further. You cannot install the tanks without having a license. It's not just any contractor you see that can dig a hole. You have to have specific training and licensure for that. That includes their insurance. Again, to reiterate the why do we do this? Here is the aquifer system in Florida. And obviously we're talking about in this area. You can see that it's under the superficial aquifer. So this is where you draw, and I know the residents use that, and that's why this is in place. Here are examples of the systems that were put in place. These have to be in place. You cannot put the tanks in without this. There's double wall buckets in place. There's the vapor line I talked about. There's the fuel drop and the vapor line going back to the tank. There's the sensors, the ball valve. This is the ball valve. It stops the extra fuel from ejecting. If it fills up, it just floats up and blocks it right here. You have sensors put inside the tank to set off alarms. You have sensors put in the double wall containment of tanks to set off alarms. Here are examples of this is what you see as a retail customer, and then all that sophistication is underneath. There's the pump system. As you can see, there's the piping laid out. This is put in a special P-rock backfill by the manufacturer. You cannot put just regular sand for pressure control. Here's underneath the dispensers, the mystery of underneath. This is a containment. It does not touch the soil and ground. The double wall piping exits through these boots, and these are breakaways. As has happened, people drive away and they try to take the dispenser home as a gift. These break off. So I wanted to point out then recently, Congress and the state of Florida adopted a training exercise, understanding that the systems can be sophisticated, but if the operators and the attendants of the station don't understand what the protection requirements are, then that doesn't work. So these are there are Class A, B, and C, and all the people on the property are Class C operated trained to understand what to do in case of a spill or release. And this has all been in place. All the 7-Elevens particularly have this, but any operator has to show evidence of training. Again, all anything that comes in contact with the soil has to be double walled with line leak detectors. And everything has to be inspected on a regular basis. That's one of the things I want to point out here. Piping dispensers every 6 months, double wall tanks. Now have to do these set systems after being installed from 2018 every 3 years for all the containment systems and all the piping. So in summary, the equipment is much more sophisticated. The institutional controls are very strong. That is the most important and most valuable one because it does not allow people to walk away. You can't walk away with bankruptcy. There is someone, the state will come in and do something about it. Everything is monitored 24/7, 365. This is following the regulations. Florida has, I wanted to point out that the regulation for the groundwater is 1 part per billion for benzene. So it's extremely strict. And I wanted to lastly show you this summary requirement from the DEP website. You can pull this down. And this goes through all the different controls that are set in place. And predominantly, if you look, the first one is the registration fee. You can't operate without this in place. Done. Second is the financial responsibility. And then you have all of these inspections devices. These are control mechanisms all put in. And this is a summary that each facility usually can look through and follow just to make sure there are people in operation. And that's really what I wanted to offer is that systems that are put in place nowadays are extremely well reviewed, well maintained, and there is protections in place. Thank you.
All right. Thank you, Neil. And we will continue with our presentation. And I will share the screen. Well, I will go ahead. The lighting for our site is the modern lighting system with fixtures that direct light downwards to limit spillover onto adjacent properties, which means there's no light pollution. Our lighting plan was required to be submitted with our applications and is compliant with the applicable city codes. A professional traffic study was conducted and did not identify any transportation issues that would be generated by a request. And at this time, I will turn it over to Michael Razor of Razor Transportation Consultants, who conducted the traffic study. Thank you.
Good morning. Can everyone hear me?
Yes, sir.
Hi, good morning. My name is Michael Razor, and I have been sworn. I'm a registered professional engineer in the state of Florida with a specialization in traffic engineering and 23 years of experience. I'm with Razor Transportation Consulting and performed the traffic study that accompanies this application. The traffic study was performed in accordance with industry standard methods and procedures as required by the city of Northport, where the specific methodology for the study was coordinated with Benjamin Newman with the city's Public Works Department. The traffic study was performed in consideration of a 3,454 square foot convenience store with 8 fuel pumps, that would be 16 vehicle fueling positions, and an ancillary car wash with access via right-in, right-out connections to both Price Boulevard and Cranberry Boulevard. The trip generation for the site was estimated using the Institute of Transportation Engineers Trip Generation Manual, which is used in nearly all traffic studies undertaken in the city, the state, and the nation. The traffic study estimates a trip generation of approximately 3,200 trips per day. So that would reflect 1,600 vehicles with 1 trip in and 1 trip out. During the morning and evening peak traffic hours, the study estimated a trip generation of approximately 200 trips per hour, which reflects 100 vehicles with 1 trip in and 1 trip out. An important item to note is that only a portion of these trips are new to the roadway network. FDOT has undertaken study efforts in the prior few years to identify that on average, 77% of the trips generated by a convenience gas site are captured from the adjacent roadway network. These are referred to as pass-by trips. with only 23% of new trips being generated. Thus, on a peak hour basis, that results for this site in 46 AM peak hour new trips, 23 in, 23 out, and 52 new PM peak hour trips, 26 in, 26 out. So in more layperson terms, the great majority of trips generated by the project site would be present on the roadway network regardless of development of the project. The new external trips were assigned to the adjacent roadway network based on area development patterns and subsequently assigned to the site driveways. And those captured trips were assigned to the site driveways based on current traffic patterns. The traffic volumes generated by the subject project were added to the background traffic volumes, which are those volumes which reflect traffic counts factored to peak season conditions with 1 year of growth. And it is these total traffic volumes that were used in the analysis. The analysis was performed using highway capacity manual procedures, as is customary and usual for use in traffic studies and as prescribed by the city, and took into consideration the planned improvements to Price Boulevard, including improvements to the intersection of Price Boulevard and Cranberry Boulevard, where Price Boulevard is planned to be widened to 4 lanes in the area of the project site. The results of the analysis indicate that the site access connection and the intersection of Price Boulevard at Cranberry Boulevard, site access connections rather, and the intersection of Price Boulevard at Cranberry Boulevard are anticipated to operate safely and efficiently upon development of the project, with levels of service identified at C or better, which are graded on an A through F scale, where C is actually a very good finding. And of course, I will be available for any questions. Thank you.
Thank you, Michael. To continue with our presentation, 2 fiscal impact analysis were conducted by staff for our proposal. Both of those analyses found that approximately $190,000 of a surplus would be generated to the city within the first 5 years after the development, and approximately $2 million would be generated in surplus to the city in 30 years. A professional environmental assessment was also performed as required for our applications. This was performed by Universal Engineering Sciences Incorporated. This assessment found no listed species on site, as well as no wetland areas. Our DMP plan has been reviewed by staff and meets or exceeds the applicable regulations in the development code. With our DMP are 4 proposed code waivers. The first proposed waiver is for a low-key monument sign to display the gas prices. Should the special exception for fuel pumps be approved, state law, Florida Statute 526.111, requires that this requested monument sign for gas prices be approved. Staff has recommended its approval. The second waiver is for the undeveloped area of our property to serve as a buffer in lieu of the neighborhood commercial high-intensity buffer requirements. The separation of the commercial site to the residential lots is far greater than that is what required by the neighborhood commercial high-intensity zoning district, and it's far in excess of the 20-foot buffer and wall or berm that is required by the code. Staff has also recommended its approval. Third waiver request is for the installation of bollards instead of wheel stops at the parking spaces. Staff has recommended approval of this as well. And the bollards, rather than the wheel stops, actually better protect the store from vehicle crashes into the building. Our final waiver request is to increase the hours of operation from 5 a.m. to 10 p.m. or from 5 a.m. to 10 p.m. to 24 hours a day. 24/7 operation, hours of operation are vital to the functioning and performance of the store and allows the property to serve the demand generated by the patrons in the community and in the city at large. Our site design offers a substantial separation from the residential lots, which allows our proposal to operate at all hours of the day without generating adverse impacts to the nearby residential properties. Again, our site design is in compliance with the neighborhood commercial high-intensity standards, which are designed to ensure harmony between neighboring residential and commercial uses. The code for neighborhood commercial high-intensity contemplates commercial uses that we are proposing today with setbacks of 30 feet, hence the limitations on the hours of operation. However, our site design locates these commercial uses greater than 200 feet away from the residential lots and also provides a conservation area between the residential lots and the commercial uses. On this basis, we believe a 24/7 operation is suitable for the property and meets the city code requirements and the intent of the neighborhood commercial high intensity zoning code. Take the elevation down. Consistent with our site design, we also, or with our DMP plan, there are also special exception requests for car wash and a special exception request for a car wash and a special exception request for fuel pumps. Consistent with our site design, these items have been oriented on the property to limit the impact on surrounding properties and are designed to meet the applicable city codes.
Are we supposed to be seeing a PowerPoint? Oh, there it is.
Now, I'm pulling the site plan back up, Commissioner Carasone. Staff has found that our special exception requests for the car wash and the special exception requests for the fuel pumps are in compliance with the required section 53-259 criteria and has recommended approval of both. Staff, however, has recommended fewer than 16 pumps. Staff has based their reasoning for fewer than 16 pumps on the perceived intensity that this number of fuel pumps generates and their belief of the impact this number of pumps could have on the nearby residential properties. We respectfully do not agree with staff's assessment on this matter and believe our site design more than adequately mitigates any potential impact the 16 pumps would have on the nearby properties. We believe 16 pumps, as opposed to fewer, better serves this location. Similar to the requested modification for 24-hour operation, this proposal before you today is unique and one not likely contemplated by the neighborhood commercial high intensity zoning code. The fuel pumps are located on the southern part of the property, fronting Price, greater than 200 feet away from the adjacent properties. The pumps are shielded from the lots to the north by the convenience store building, which allows it to serve as an additional buffer structure. And the conservation area provides a buffer to the adjacent lots more than 6 times the required buffer distance established by the code. The location of our property is on Price, which is the city's major east-west roadway other than I-75 and US 41, which is also set to be widened to 5 lanes. The Price arterial roadway handles a large volume of traffic and will be handling more traffic as the city continues to grow. Our traffic study found 77% of the trips to the site are pass-by trips that are already on the road. 16 pumps allows the property to efficiently capture the pass-by traffic. Fewer pumps means fewer people can get gas, and those who can't get gas will have to stay on the road and drive a further distance and spend more time on the city's roadway network to get gas. Our particular property in the neighborhood commercial high intensity zoning is another factor that supports 16 pumps at this location. The Price Cranberry intersection is in the middle of the city along one of the city's busiest roads. There are 4 commercial properties at this intersection, and they allow the city to achieve a goal of planning, which would limit the average vehicle miles for those who are driving to go to commercial uses. The location of these 4 commercial lots at this intersection provide the potential to serve the commercial needs of the surrounding neighborhood, as well as those who travel along Price, the city's major east-west road other than the interstate or US 41. Northport is already the largest city in Sarasota County, and as you know, it will surely continue to grow. I believe Northport is about a third of the way built out if you're looking at the platted lots that are in the city today. This property is centrally located and it provides the potential to serve many people today and the many more Northport residents to come in the future. There is demand for the fuel pumps today. That is why we have a request before you, and there will be an even greater demand in the future, especially after Price is widened to 5 lanes. 16 pumps also serves for the property to function efficiently, properly, and safety when considering the day-to-day operations on site and the movements of people who are visiting the site to not only get gas, but also to get drink and food products. 16 pumps prevents any queuing issues of cars waiting in line to get gas, parking in the drive aisles or parking spaces around the building. This allows for better movement of vehicles on site and allows those who are visiting the store for food and drink items to utilize the parking spaces provided around the building, while those who are visiting for gas can pull into an available fuel pump under the canopy. With 16 pumps, the site can operate smoothly, safely, and better serve the needs of the community. Thank you for your attention to our proposals before you today. Again, we have a DMP plan with 4 requested waivers. We have a special exception request for a car wash, and we have a special exception request for fuel pumps. All of our requests before you today are compliant with the Unified Land Development Code, meet the applicable criteria for each request, and are consistent with the city's comprehensive plan. We respectfully request your approval. Thank you.
Mr. Boone, just for the record, are you finished with your presentation?
Yes, ma'am.
Thank you very much. Appreciate that. All righty, so now we will move on to staff. And let me know when all of your staff are on the queue here to talk. That way then I can go ahead and start your time. And just a reminder, whoever is going to be speaking, just state your name for the record and that yes, you had been sworn, or if you need to be sworn.
Thank you. Gillis for the record, and I have been sworn, and our attorney Jennifer Cohen will be starting off our presentation.
Thank you very much. Your time has started. Thank you.
Good morning, Mayor and Commissioners. I have been sworn. My name is Jennifer Cowan, and I represent the city staff in this matter. Today, I will provide you with a brief introduction of the project and then a quick overview of the task before you. This item is the 7-Eleven full-service convenience store. Next slide, please. As you have just heard from the applicant, Jeffrey Boone, on behalf of Wheaton Northport LLC, they are requesting the approval of the Development Master Plan, or DMP, and 2 special exceptions. Next slide, please. The DMP and special exceptions are for a 7-Eleven full-service convenience store with fuel pumps and a car wash on a 4.15 acre site located at the intersection of Price Boulevard and Cranberry Boulevard. Next slide, please. Today, you will need to decide 3 main issues: whether or not to approve the DMP with its waivers, and whether or not to approve the 2 special exceptions. 1, the special exception for the car wash, and the second, the special exception with regard to the fuel pumps. Shortly, Nicole and Allison will go through each of these items in much more detail. But at this time, I just want you to keep in mind that there are separate criteria that must be considered for the DMP and its waivers versus the special exception. First, the DMP and the waiver request. Section 53-7 provides the City Commission, after receiving the Planning and Zoning Advisory Board's recommendation, shall vote on whether to approve with conditions, or deny the proposed development. Also, Section 53-118 provides that in connection with the DMP, the City Commission may modify or waive certain requirements in its Unified Land Development Code, including those provisions found in Chapter 25, Parking Regulations, Chapters 29, Sign Regulations, and Chapter 53, Zoning Regulations. The DMP and waivers may only be granted where there is a finding that they are consistent with the comprehensive plan, consistent with any criteria made specifically applicable by the regulations or conditions of approval, and that they would not adversely affect the public interest. Now, you've heard from the applicant, and in a moment, staff will provide testimony related to the DMP in each of the 4 waivers and whether or not they have met the criteria I have just identified for you. And then you'll be asked to either grant the DMP with conditions and grant all waivers, approve the DMP with conditions and grant certain waivers while denying other waivers, or to deny the DMP and its waivers. As for the special exceptions, those requests have many more criteria. So as you're aware, a special exception is a use that would not be appropriate generally or without restriction throughout the zoning district, but which, if controlled as to the number, area, location, or relation to the neighborhood, would promote the public health, safety, and welfare. Those uses are only permissible in a zoning district when the specific provision for such special exception is made in that zoning district. Here, the applicant's property is zoned NCHI, meaning Neighborhood Commercial High Intensity District. And pursuant to section 53-179 of the city's Unified Land Development Code, a convenience store is a principal use, and fuel pumps and a car wash are special exception uses. So therefore, today, in determining whether or not to grant the special exception, you must consider whether or not proper notice was provided and whether there were legal requirements, whether the legal requirements of your code were met. As to proper notice, you find that in section 53-258, and it provides that notice must be provided to the property owner through mail. Notice of the public hearing shall be advertised in newspapers of general circulation in the city at least once and at least 15 days prior to the public hearing, and that notice shall be given by mail at the petitioner's expense to all of the owners of property within 1,320 feet of the property. In a minute, Nicole will go through how each one of these criteria for notice have been met. Then you must look to the legal requirements of your code, which are found at section 53-256. Before any special exception shall be approved, the commission must determine that granting the special exception will not adversely affect the public interest, health, safety, or general welfare, that the specific requirements in the schedule of district regulations governing the individual special exception, if any, have been met, and that the 16 standards that are identified in section 53-256 have been met. Those 16 standards include whether the proposed use is consistent with both the comprehensive plan and the intent of the zoning district, whether the density and intensity is consistent with the intended future use of the designated land use area which the property is located. It must not be detrimental to the health, safety, welfare, appearance, or prosperity of the neighborhood or adjacent uses, and it shall be an economic benefit to the economy of the city. The intensity of the proposed use must be harmonious with the character of other uses in the neighborhood, the heightened orientation of the proposed structure compatible with existing structures and uses. The parcel must be adequate in shape and size to accommodate the use and provide for appropriate separation between neighboring uses. Must be adequately screened and buffered. The loading and refuge areas must not impose any negative visual, odor, or noise impacts on abutting uses or thoroughfares. The signs must be in compliance with Chapter 29 and compatible with the character of the existing neighboring uses. The exterior lighting must be harmonious with the character of existing neighborhood uses. The ingress and egress not adversely affect the traffic flow, safety, or control. The access and internal circulation must be adequate in the case of fire or emergency. It must not adversely affect traffic flow or safety, safety or control on the surrounding roadway system. The proposed potable water systems must be adequate for the use and not adversely affect neighboring systems. The wastewater systems must be adequate for the use and compatible with the drainage condition in the area. And it must not cause or intensify flooding of neighboring uses. After considering all of those standards, if notice is proper and the standards have been met, then we respectfully request that you approve the request today. If notice is proper and the standards have been met or could easily be met with appropriate conditions, then approve with conditions. And if the notice is not proper or any of the standards have not been met, then we ask that you deny. If you deny the request, then you must state your reasons for doing so. Now, you've heard from the applicant as to why he believes proper notice was provided and the standards met, and now staff will present their evidence as to why proper notice has been achieved and that the standards were met or could easily be met with certain conditions. Nicole?
Thank you, Jennifer. So I'll go through the application. We'll start with the development master plan proposal. As the applicant has presented, we are.
Nicole?
Yes?
Miss Nicole, could you please, I'm sorry, I don't remember if you said that you were sworn or not.
I did. I have been sworn.
Thank you for the clarification.
So the development master plan proposes a full service 7-Eleven gas station with a 30,454 square foot convenience store, 16 fueling stations, and a 979 square foot car wash. Surrounding that is a 2.24 acre conservation area to be dedicated to the city as a buffer area for the property. The zoning district is neighborhood commercial, high intensity. This zoning district is intended to provide for customary and traditional conduct of limited trade, retail sales, and commerce in a manner convenient to, and yet not disruptive to, adjacent residential areas. So the intent of this is to really provide for those daily needs of the residents with minimal disruption to their daily lives. The special exception applies for the fuel pumps and the car wash component of this plan, which allows for a use that would not be appropriate generally or without restriction, but if controlled, can promote the goals of the zoning district. The convenience store is permitted by right. So that part is not subject to one of the special exception questions. In their application, the applicant has requested 4 waivers to the Unified Land Development Code. These are to include a freestanding monument sign to advertise fuel prices, to increase hours of operation to 24 hours a day, 7 days a week, to donate land to the city in lieu of a wall in the buffer zone, to provide bollards instead of wheel stops. So the first waiver, in terms of permitted signs, generally speaking, the freestanding monument sign is not permitted in neighborhood commercial zoning districts. However, Florida statutes preempt local governments from imposing restrictions on signage advertising gasoline pricing. So if the fuel pump special exception is approved, staff supports this waiver. If the fuel pumps are not approved, then staff does not support this waiver. The second is 24-hour operations. The neighborhood commercial zoning district limits hours to 5 a.m. to 10 p.m. The applicant is requesting for 24/7 operation. Staff feels that this operation could be more disruptive to the adjoining residences with increased noise and traffic and does not support this waiver. The third is the buffer zone and landscaping. The neighborhood commercial zoning district has a higher standard of separation between this use and residential neighborhoods. And the applicant is proposing, instead of the traditional buffer that is required by code, to donate the lot surrounding their property, which is about 2.24 acres, as a buffer instead of the traditional 8-foot wall or berm. This will provide the required visual and sound barrier to adjoining residences, and the potential for a future park creates an additional amenity and improvement for the community as well. Finally, the fourth waiver is to have bollards instead of wheel stops. The bollards provide the same function as wheel stops and reduce the possibility of storefront crashes, which enhances public safety, and staff supports this waiver. Staff evaluated the proposal for consistency with Florida statutes, the comprehensive plan, and the Unified Land Development Code. Lost a sheet of notes. So from the Florida statutes, there are two statutes that regulate gasoline pricing signage. So Florida Statute 553.79 restricts local governments from regulating signage for gasoline, and Florida Statute 526.111 provides minimum size requirements for advertising of gasoline pricing. So with the approval of waiver number 1, if the fuel pumps are approved, this proposal is consistent with Florida statutes. In terms of the comprehensive plan, the future land use element maximizes, has a goal of maximizing the economic benefit and reducing the threat to health, safety, and welfare. So the proposed project allows for a greater use on the property than if it had been left as residential, and does so while maximizing the economic benefit. It also is a goal of the future land use element to encourage targeted development, which this is again, you know, these neighborhood commercial pieces are intended for diversifying the city's tax base. And so this is intentional for these properties to be developed with non-residential uses. The transportation element requests that we increase pathways for pedestrians and bicyclists and provide buffers along arterial and collector roadways. The proposed park that could potentially be built here would provide an additional means of transportation for pedestrians or bicyclists, getting them off the busy roadways at this intersection of Cranberry and Price. And the property would be required to put in the required buffers along Cranberry and Price, which is a 10-foot buffer. The conservation and coastal management element encourages the staff design or staff development review committee to promote green design practices. The park component does, and natural buffer component provides this while reducing the potential intensity of the site. If the 2.24 acres was not donated, even if it is not improved as a park, that could potentially be developed with a much higher intensity than is currently being proposed for just the fuel station. The recreation and open space element includes passive recreation in its definition of open space. The closest existing park is about 1.23 miles away off of Salford Boulevard. And so the need for park space east of that is very high. There's one park that is east of Salford, and that's Atwater Park, which is much further east. So having these little infill and pocket parks are a very desirable amenity for our communities. This element also promotes development that is privately supported, neighborhood-based park system. So again, this is being donated from the developer, so it helps reduce that cost burden of park development from the city to the private sector. And then our economic development element wants us to promote balanced and orderly economic growth, and this falls in line with those policies. So staff finds that the proposal is consistent with the comprehensive plan. The Unified Land Development Code, staff reviewed the proposal against all chapters of the Unified Land Development Code. Some of the items that we'd like to discuss today, Chapter 25, the parking regulations. There's a waiver for the bollards, and if that waiver is provided, then it meets this chapter. If that waiver is not provided, the applicant would have to amend their plan to provide wheel stops in order to be consistent with this chapter. Chapter 37, roadway design and construction standards. The park shifts the pedestrian burden off of the regular roadways. And so that's definitely a goal of this chapter. And it meets all other requirements of chapter 37. Chapter 53 is where it discusses the development master plan requirements, the neighborhood commercial high intensity zoning district, special circumstances. There's a separate area just for fuel pumps, and the proposal has been evaluated to be consistent with all of these elements. The proposal was also looked at for economic impact and shows a positive $188,298 impact over the first 5 years. And over 30 years, this is a $2,097,239 positive fiscal impact for the city for our net operating budget. The staff development review team evaluated this. And I'll just kind of briefly go over what each of those departments reviewed. So solid waste reviewed that the commercial dumpsters must be placed inside of a corral and found that this project has proposed to properly manage and handle waste disposal. Stormwater and environmental. The proposed wet detention stormwater pond footprint is sufficient for the development master plan phase submittal, and more detailed analysis will be required in the major site and development phase. And there have been several conditions recommended in association with that. And the wetland wildlife survey indicates there's no wetlands on the site and does not indicate that there's protected wildlife species. However, this is a general wildlife survey, and a more detailed one will have to be provided with the major site and development phase, and then again before land clearing. In terms of transportation, the project engineer reviewed the traffic impacts for additional trips onto Cranberry and Price Boulevard. So it found that 77% of the trips were pass-by trips and did not create adverse impacts onto our roadway network. It was evaluated for internal configuration of the proposed development, for drive aisle widths and parking stall sizes, site lighting, pavement markings and striping, regulatory signage, and pedestrian connectivity. Utilities reviewed the project and has the capability to provide utility services. There's a connection on the west side of Cranberry for a 12-inch water main, and a connection for sewer service on the south side of Price Boulevard to either an 8-inch or 12-inch force main. Police reviewed the project and recommends parking lot lighting locations covering the area to pump gas. The hours of business will determine the calls for service and additional patrol checks when the business is closed. They recommend surveillance cameras and who has access to it. So they just want more information which will be provided during the major site and development phases. Fire reviewed the project in terms of access to the structure. So in the initial submittal, the project was difficult to access. However, they made significant changes to accommodate fire apparatus being able to reach the structure and the property. They provided guidance and information relevant to the project, and will continue to review during future phases. Parks and Recreation evaluated the potential to utilize a portion as parkland. So that there potentially, if the project is approved, we've have a draft working through the legal department of an agreement that would allow the developer to potentially build the park and to be reimbursed from the city, or to have a funding agreement of sorts to be paid from park impact fees. So additionally, the park stated that National Recreation and Park Association studies indicate that well-maintained, improved parkland help deter unwanted behavior and improve home values. And finally, it's been reviewed by our city attorney's office for the resolutions have been reviewed as far as form and correctness. The final part from the Unified Land Development Code is a special exception criteria. And so Jennifer mentioned these briefly, and I'll go into how each project meets or doesn't meet these requirements. So the Unified Land Development Code, the first criteria is that it is consistent with the comprehensive plan. It strives to ensure compatibility and strives for balance. Staff finds that with the fuel pumps, this is not met. It could be met with less intensity or fewer pumps. So it meets the general intent here, but does not, but could be done with a modified plan. For the car wash, staff did find that it was consistent with the comprehensive plan. For the second criteria is consistent with the future land use of the area. The future land use on this property is commercial. There is no separation between commercial and neighborhood commercial when it comes to the future land use. So both the fuel pumps and the car wash are consistent with the future land use of the property. The third criteria is that it's not a detriment to the health of the community and that it provides an economic benefit. So the health risk potential is there with the underground storage and the potential for fumes. However, the EPA safety standards and state and federal guidelines provide very strict regulations for this type of use, and staff finds that that this risk is minimized by those and finds that it is consistent with the fuel pumps and the car wash are consistent with this criteria. For the intensity being harmonious with other uses, the fuel pumps, again, it's very similar to the first criteria where this could be met with fewer pumps. So the intensity could be lower to increase the harmony with the surrounding neighborhood. We find that this is not met with the car wash as proposed because it is the intensity is not harmonious with the character. However, if the applicant would consider changing the site layout to move the car wash to the south or east side of the property and or reduce their operating hours, it would decrease the intensity of the use, and this could be consistent in that situation. So the height and orientation of the proposed use being compatible with the surrounding neighborhood. The surrounding neighborhood has a height limit of 35 feet for residential structures. The fuel canopy is proposed at 17.6 feet. So the height compatibility of the fuel pumps is consistent with this criteria. The proposed car wash has a height of 16 feet 8 inches. So again, less than half of the permitted height in the surrounding district. So staff finds that the car wash is also consistent with this criteria. For the next criteria, it's that it has sufficient size to provide buffering and provide separation. The proposed site layout has a 2.24 acre L-shaped piece that would be donated to the city. And this provides for more than an adequate buffer for this use. The required buffer from our Unified Land Development Code would be around 40 feet. And the proposed buffer is about 130 feet in most places. So staff finds that for both the fuel pumps and the car wash, this special exception criteria has been met. The next one is adequate light, traffic, and noise to be buffered. The applicant has shown a lighting plan that shows that the light will not spill over onto the adjacent properties and that it meets all criteria of our code in terms of lighting. The traffic and noise is again buffered by the surrounding 2.24 acre property. And so staff finds that this criteria has also been met. The appropriate signage with the waiver as requested by the applicant, signage is met for the fuel pumps. The car wash is only proposing a few minimal signs that are exempt by our code. So our signage standards are met with that as well. The next criteria is for harmonious exterior lighting. As I stated with criteria G, the lighting plan has been submitted and reviewed by staff and shows that the foot candles on adjacent properties does not exceed 0.2 foot candles. And so this criteria has been met for both the fuel pumps and the car wash. K, ingress and egress do not affect traffic flow. Both our fire department and public works agree that this standard has been met. They have demonstrated this with auto turn exhibits that show a fire truck being able to maneuver through the site. Two means of ingress and egress. Access for emergency agencies is the next criteria, and the property does show two means of ingress and egress and is acceptable for fire and police. Effects on surrounding roadways, as I mentioned during the discussion from our engineering department, 77% of the trips are pass-by trips, meaning that they're trips that are people who are already driving past this site. So there will be no adverse impacts on our roadways. For N and O, willingness to serve from potable water and wastewater systems, our utilities has provided confirmation that they are able to provide these services. And then finally for P, to cause or intensify flooding. This is a requirement of the Unified Land Development Code that all stormwater and be managed on each site and not cause any effects on surrounding properties. So they will have to meet this during the major site and development review, and they will also have to have approval from the Southwest Florida Water Management District for that stormwater management system. So as I stated, these petitions have been reviewed and approved with conditions by the applicable city staff. Those conditions are found on page 30 of the staff report, and staff does request inclusion of them into the motions if recommended for approval. Resolution 2020-R-11 and 2020-R-12 have been reviewed and approved by the city attorney's office for form and correctness. All public hearings were advertised pursuant to all applicable state and local regulations. And I'm going to go into that just a little bit more. So in this slide, you'll see the buffer map that shows the properties that were included into the notice requirements. The first requirement in section 53-258 is to notify the property owner by mail. And this was done on May 29th. That was sent out. The second is the notice of public hearing to be advertised in a newspaper 15 days prior to the hearing. And this was advertised in the Northport Sun on May 31st. And then finally, for properties greater than an acre, notice must be given to property owners within a quarter mile of the boundary line, 1,320 feet. So this map shows all the properties within that boundary. If the boundary crosses a property, those properties were also notified. And those went out on May 29th as well. I'd like to point out, just for the community's benefit for those listening, that these notices do go to the property owner as listed with the Sarasota County Property Appraiser's office. So if you are a renter, you would not receive this notice. Additionally, if you are a part-time resident and your address with the property appraiser is in another state, that's where the notice would go as well. So I just wanted to point out those key facts for that as well. So staff recommends that the commission approve with condition number 1, resolution 2020-R-11, special exception 19269 for the fuel pumps. but staff recommends that there be fewer than 16 pumps as part of this. In our research, the 7-Elevens that are surrounding in other areas of our community that are zoned general commercial have 12 or 16 fuel pumps. So staff feels that because this is neighborhood commercial and supposed to be less intense, we feel it should be fewer than 12. Staff recommends approval with condition number 1 of resolution 2020-R12 SPX 19270 for the car wash, with the caveat that we would prefer to see the car wash on the east side of the building instead of the west side of the building. And then finally, staff recommends approval with waivers number 1, 3, and 4, and conditions number 1 through 5 of Development Master Plan 19-280 for the full service 7-Eleven convenience store, and denial of waiver number 2. If modifications are made to the special exceptions requests, then those modifications would also need to be shown on the Development Master Plan. And that's all I have.
Thank you, Ms. Nicole. And just for the record, you are finished with your presentation, ma'am?
Yes, I am.
Thank you very much. All right, it is now 11:45. I don't know if we need to take a health break for 15 minutes or 10 minutes. And I also need to find out what we're going to be doing about lunch, because staff and applicants, we are approaching that 12 o'clock hour, and we have 1 hour presentation for each of our aggrieved parties. So I'm just kind of throwing it out there. City manager, it's your staff.
We're on live here.
Mayor, I have no doubt that my staff would enjoy having a lunch break.
All right, commissioners, do you guys think right now would be a prudent time to break for a half hour, grab some lunch, come back, and continue on with our aggrieved parties?
Yes.
Yes.
I'm good with that.
Okay. All right. So at this point, let's recess. It's now quarter to 12-ish. Let's reconvene after lunch at 12:15. That'll give you just over 30 minutes for lunch, health break, stretch your legs, clear your mind, and then we'll persevere again when we return. So as of right now, we are in lunch recess until 12:15, when we will reconvene promptly at 12:15. Thank you.
Debbie, I want to make sure my voice is not muffled the way it was in that other meeting.
I can hear you just fine, ma'am.
Okay, because the last time I had to actually go out of Zoom and back into it to correct
I do
it.
remember that. Yeah, you were definitely garbled the last time. So yeah,
and
it's fine now.
it was like a half-hour break back then too. So just checking. Thank you.
You're welcome. City Clerk, we've got about 1 minute to go. I just want to make sure everything is good at your end.
Yes, it is.
Thank you very much. We'll just wait until 12:15 and then we'll do roll.
Mayor,
Yes, ma'am.
may I suggest when we reconvene that we again go through ex parte disclosures to see if there have been anything additional to disclose during the break, and also a statement from each commissioner that they have not discussed the case with any of the parties.
No problem, ma'am.
Thank you.
Thank you. All right, City Clerk, it's 12:15. Are we ready to reconvene?
Yes.
Fantastic. We'll go ahead and do roll call before we get started. Commissioner Emmerich?
Yes, ma'am, I'm here.
Thank you very much. Commissioner Hanks?
Yes, ma'am.
Thank you. Commissioner Caruso?
Here.
Thank you. Vice Mayor?
Here.
And myself, I'm here. So we do have all 5 commissioners present. Let's double check on Charter Officer, City Manager,
Yes, ma'am.
City Clerk,
Yes, ma'am.
and City Attorney.
Yes, ma'am.
Fantastic. Since we did have a break and we are in the middle of a public hearing on a quasi-judicial procedure, I'd like to poll each one of commissioners to ensure that they had to state if they had any ex parte communication during break, and that confirm that they did not or did talk about this hearing that we're right in the middle of. So we'll start with Commissioner Carasone.
Absolutely no.
Nothing for you. Okay, Commissioner Hanks.
No, ma'am.
Thank you. Commissioner Emmerich.
No, ma'am, I was busy eating a sandwich.
How about you, Vice Mayor?
Nothing to report either. Thank you.
Thank you. I too was busy scarfing down my lunch and taking a quick health break. So I believe, City Attorney, that answered your concern and we addressed that. And at this point, we are all set to go. So I will turn this.
Madam Mayor, may I ask a procedural question, please, ma'am? And I
I'm
tried
sorry,
to.
yes, Mr. Boone.
Yeah, I'm sorry. I tried to catch your attention before the break, but this will work just fine. I just want a confirmation because different local governments do this differently. But in the procedure in Northport is that cross-examination or questions being asked by parties to other parties, that occurs does that occur during the rebuttal stage, or does that occur after the presentation, immediately after the presentation's been made?
Okay, so the way that it works in our quasi-judicial procedure, sir, is that we are in the middle of the first step, which is the presentations. Then it will go to rebuttal, where each person will be allowed the 15 minutes. And then it goes to public comment, where we hear all public comment. And then we will go on to questions by commissioners. And then after questions, it will be the closing arguments.
Yes, ma'am. Yes, ma'am. Thank you very much. I'm very aware of that. I'm just asking the cross-examination that's allowed by Florida law in quasi-judicial hearings. When does that occur? That's my question.
Madam Mayor, if I may, Mr. Boone, this is available to you in our code. These procedures are in section 2-83, and subsection 4B states that cross-examination may be made during rebuttal.
All right, that just wanted to confirm that. Thank you very much.
No problem. Thank you, City Attorney, for your legal expertise on that. Rebuttal and cross-examination is one and the same based on the sheet that I have in front of me. So thank you for that. All righty, seeing nothing else. And thank you, Ms. Stacy. Please make sure you unmute your mic. And ma'am, you do have 1 hour for your presentation. Thank you.
Thank you, Madam Mayor. I would like to share my screen, please, for my PowerPoint presentation in which I submitted 6 days ago prior to the hearing.
I'll go ahead and pause your time while we get that share screen up and we confirm that you can see it.
All right, I have it up. Can everybody see it?
Okay, I can see it.
I can see it.
Quick yes or no, guys? Quick.
Yes.
Yes.
Hearing
Yes.
no. Okay. Seeing nobody. All right. We're all set. Your time has been resumed, ma'am.
Thank you, ma'am. Once again, good afternoon, commissioners, representatives, and those in the community who have joined this session today. As I've previously mentioned, I've been a resident and member of our community for over 20 years. As an aggrieved party, I ask again that commissioners listen to my concerns and the continued research that I have prepared for you today. Northport is a city represented by rapid development, curbside appeal, and mass residential and growth opportunities. It is the place myself and many of you call home. I have witnessed the development of numerous gas stations, and new developments are popping up everywhere you look. 7-Eleven wants to develop a convenience store that is nearly 3,500 square feet, a 979 square foot car wash, and up to 16 gas pumps with the intention of operating 24 hours a day, 7 days a week. The claimed purpose for this development, which has been stated in abundance of times via representatives of the developer, is to, and I quote, serve the needs of the community and create a harmonious environment. I would like to highlight that because all development should be designed and placed to serve the needs and the desires of our community. That being said, the aspects of this development don't serve need and rather disruptive instead of harmonious. I want to make it clear once again that I am not anti-development when it comes to the property next to my home. I understand the lot is zoned for neighborhood commercial and eventually will be built upon. Current zoning came into play in 2003 with the intent to allow for goods or services, but with guidelines to prevent developments that cause negative impacts to residents or devalue the nearby residential properties. My grievance is not because someone wants to develop on this property. It's because a 24-hour gas station is what is proposed. So many residents have reached out to me over the past few weeks. A majority of residents don't understand the specific requirements regarding codes for what is directly permitted on this commercial lot. I have shared my research and have had to step up and be the voice for those who can't in our neighborhood. In order to go through with their development, 7-Eleven requires special exceptions for more aspects of their development than they can build without them. I have never claimed to be a professional within zoning and developing. However, I still don't understand why a development like this is even being entertained when every aspect of the development requires some sort of special exception, special consideration, or special privilege. You will find the bulk of residents feel the same way as I do. The gasoline require a special exception to be built. The car wash requires a special exception to be built. Even the convenience store, which is the only main aspect of the development plan that zoning directly permits for the property, requires additional privileges or waivers to be able to operate 24 hours a day, 7 days a week. All of this information is directly stated under the City of Northport Unified Land Development Code Section 53-178 and Section 53-179. Look at this from the utmost simplistic point of view. If a development isn't directly permitted in our code and the plan requires this much special privilege in order to go through, does it really belong there? The practical answer is no. If a gas station was really meant to be developed at this location on that property, they wouldn't need to go through all of the extra considerations or hearings. There are reasons why Northport doesn't have gas stations in the middle of residential zones. It's because, quite simply, they don't belong there. There are issues with so many aspects of this development, all the way down to the traffic patterns. The traffic flow pattern of Price Boulevard with entering and exiting the premises is insufficient and will cause disruptions among commuters and residents that will suffer from the illegal cut-throughs on their streets. While convenience stores can serve quality of life impact when allowed too close to homes and other inappropriate locations, convenience store holdups, account for about 6% of all robberies in the nation. Convenience store employees suffer from high rates of workplace homicide. Many in our community may not know this, but there was an electrical fire at the new 7-Eleven on Cranberry and Toledo Blade on January 25th of this year, 2020, which caused a major shutdown of traffic. The official report stated that rodents attracted to the garbage and mess spill from the on-site dumpsters ate through the electrical wires, which started the blaze. The National Fire Protection Association reported that U.S. fire departments respond to an average of over 5,020 fires on gas station properties per year. These fires are exponentially more dangerous given the runoff fuel from tanks and cars that spreads across the surroundings on the properties. Don't add fuel to the fire. Also reported is that one local Dollar General store was involved in an armed robbery where 2 employees were tied up, cash was taken from the store's safe. 4 local residents were arrested and charged with robbery with a firearm, kidnapping, aggravated battery, and obstructing justice. This information was in the local Sun newspaper. There has been witness drug activity on Price and Cranberry Boulevard Dollar General property, as well as drug paraphernalia found in the parking lot and on the residential property behind it. Surrounding property owners, have experienced a huge rat problem since the business was built a few years back and continue to drain money and efforts to fight off the problem. Just one occurrence of rats invading residential property can cost over $500 to address. Residents have suffered significantly reduced property values, multiple instances of trespassing, attempted robbery, and property damage that never occurred until this development. Litter and trash have been left on residential property by trespassers and passively from dumpsters. Residents are forced to install security systems and video surveillance to try to protect themselves and their property. All of this has resulted simply from just the convenience store. The recently developed 7-Eleven on Cranberry and Toledo Blade also has a recorded police response of over 154 occurrences for various reasons from 2018 to April of this year. These kinds of development clearly attract crime and suspicious activity that doesn't belong in the backyards of residents. The proposed park that the developers want to donate to the city is filled with unanswered questions regarding development plans, safety monitoring, and maintenance responsibility. I'd like to point out a few additional facts that the Commission may be interested to hear. Last month, a 4-year-old found what a police reported to be a suspicious baggie in a local Circle K bathroom. January 18th of 2020 at the Circle K, a recent robbery at 2:28 a.m. occurred. Suspect wore a black ski mask and held up the store with a handgun and was never caught. Last seen speeding down Toledo Blade Boulevard. May 28th, our neighborhood has witnessed individuals attempting to break into personal property, which has been caught on residents' surveillance videos during late night, early morning hours. On May 24th, West Price Boulevard once again had a vehicle lose control and end up in a resident's front yard. Luckily, no one was injured. Another occurrence like this was on February 28th, 2020, when a bicyclist on the sidewalk was seriously injured when he was struck by a hit-and-run vehicle. I can go on and on as the list is long, but these are all facts that are very accessible via the Northport Sun paper or the Northport Police Department. Growth and traffic management agencies have an obligation to prevent traffic from reaching the point where it lowers quality of life or threatens public health and safety. Now let's talk about some of the other risks and threats that present when you add fuel pumps and a car wash into the picture. The United States National Library of Medicine has written multiple articles related to public health and safety. They state gas stations can pose significant hazards to people. As people fill up their tanks, diesel fuel or gasoline may drip from the nozzle onto the ground, and vapors may leak from the open gas tanks into the air. This can lead to air pollution and soil pollution. The attorneys have stated that they have no reason to believe fuel tanks and systems would have any impacts to the atmosphere and state that, and they are approved by FDEP and EPA standards. But what do you smell at and around the station? Fuel. Now think about it. What happens when you finish pumping gas into your car? Does the pump stop completely? Nope. I previously even made a joke that you have to dance around the fuel pump when you're filling your tank to avoid the mess. But all jokes aside, that dribbling gas spills onto the concrete below, and this happens every single time somebody pumps gas. The spillage builds up, and as it gets washed away by rain or other running water, it permeates our stormwater drainage systems, retention ponds, and nearby soil. Facts published with the CEDS state each proposed pump at a gas station generates about 100 to 130 customers per day, by pump meaning fuel position. The convenience store will generate about 800 to 1,200 trips per day per 1,000 square feet. Thousands of cars generating toxic spillage is unavoidable regardless of how many regulations are put in place. The unfortunate truth is that many people don't want to notice and pay attention to the seemingly small things like leaky pumps. There's no way that the station can stop human error and accidents from happening, which means the damage is inevitable. Air pollution is created when fuel evaporates, emitting toxic fuels, or when motor vehicles are running, which can travel 328 feet. Soil pollution can result in fuel that spills to the ground, builds up, and seeps into underlying soil and groundwater. This can contaminate local well waters. Underground pipes or tanks that rust, split, leak, malfunction can also release contaminants into surrounding areas. It is important to note that the CEDS studies on US gas stations show in 2019 high levels of colorless toxic liquid hydrocarbons. Hydrocarbons, especially toxic to children. The National Library of Medicine expands on the harm associated with the fume exposure. People filling, people filling vehicle tanks at the gas station are at risk for exposure to diesel fuel or gasoline, either by breathing its vapors or by spilling it directly onto their skin. People who live or work near a gas station at least 500 to 1,000 feet may be exposed to toxic chemicals in the air, soil, and drinking water. Children, the elderly, and people of all ages who have lung conditions such as asthma are at even higher risk for harm. A study documented a significant relationship between childhood leukemia and living near gas stations. Gasoline contains harmful chemicals, including benzene, which causes cancer. The World Health Organization states that there is no safe level for exposure to benzene. Running motor vehicles produce carbon dioxide and particulate matter, which is toxic to humans as well. Idling engines, particularly those in large diesel trucks, emit a larger quantity of these said toxins. The underground storage tanks that will be placed in the ground if this development proposal goes through will be larger than the size of the average household swimming pool. I had followed up with multiple 7-Eleven locations for their average 16 pump development sites. Underground storage tanks range in size to have the capacity to hold between 10,000 to 20,000 gallons of gasoline each and are placed 20 to 30 feet in the ground. Refill shipments follow absolutely no regular schedule, which means they can show up at any given time on any given day. On an average, shipments for a 16 pump station are anywhere between 3 to 4 times a week, or could be as frequent as twice a day, according to the locations. I interviewed both local and non-local. This is an enormous amounts of gasoline transfer, 40,000 gallons of toxic chemical transfer between shipping trucks that can show up at any given time or day is anything but beneficial to our residential community and is not neighborhood friendly. Furthermore, this violates the Northport ULDC hours of operation that clearly state 5 a.m. to 10 p.m. to prevent noise and disturbance in nearby residential zoning and homes. All of the houses surrounding this property, aside from my own, use well systems for water in their homes. The residents don't deserve to have their primary water source placed at risk for contamination. More than half of these homes belong to families raising small children. Naturally, one would assume that companies as large as 7-Eleven need to have policies and damage control regulations because there should be some sort of accountability present. However, it doesn't change the fact that they cannot false promise the local residents and members of our community that their presence does not pose real risks and threats to the health and safety. Damage control only gets put in place when you know there is a real possibility for damage. All they can promise at this point is revenue. Why should residents suffer and unwillingly risk their health and safety for a gas station that they didn't ask for, located on a property that it isn't designed for, all for just a shiny green dollar? I would surely hope that the leaders of our city don't value dollar signs above the health, happiness, and safety of their own people. A petition of over 300 names has been submitted. Hundreds of letters have been emailed to the city and countless public comments have been sent. I am pretty sure the voice of our residents has been very clear. No. We don't need this, not here. Northport is a large and fast-growing city with endless potential. There are plenty of commercial areas that are not surrounded by families and homes that would suit this development. I am asking all of you commissioners to protect your local residents, the young, the old, the ones that have been here for decades, and the new ones to come. Your mission statement is to achieve community outcomes by strengthening the community's economic vitality and diversity. Please protect us by making the practical decision to deny this development proposal and put it somewhere it belongs today and in the days, months, and years to follow. These are some comments from our local neighborhood that have been posted online that I have submitted. I'd like to just give you an opportunity to browse over some of them and hear their voice. While you're reviewing that, I feel compelled to highlight a written document that was submitted on May 19th to the commissioners and attached to Nicole Galehouse, who supplied the actual PZAB board members with the information. PZAB member Thomas Nicholson stated that during the May 7th meeting, on one or more occasions, he personally asked for clarification from staff if this gas station was a quote unquote permitted use, and he was told yes. Mr. Nicholson also noted in the meeting that if it's a already permitted use, then we are just here simply to discuss the car wash and the number of fuel pumps and hours of operation. Given the assumption that the convenience store and fuel pumps were a permitted item, as stated by staff. So with this being said, were the board members ever in clear understanding to what they passed through to even get us to this point? Because based on this letter, it appears there once again has been a big disconnect. Without the proper understanding as to the nature of what they were voting upon, there is a large potential that the PZAB meeting decision and recommendations could have went in a very different direction. Even with the confusion, they did not recommend the 24 hours of operation. I would like to highlight.
Madam Mayor, Madam Mayor, that I have to raise an objection because that is incorrect. The PZAB did recommend the 24-hour.
You will be able to make your rebuttal when it's your turn to rebuttal. This is her presentation now, sir.
No, ma'am, this is not rebuttal. This is a quasi judicial hearing, and this is a proper objection to testimony that is factually incorrect, dealing with a prior meeting that's part of this overall process. Thank you.
PZAB meeting is what City Attorney, just for the record, Ms. Tracy, I paused your time.
Thank you, ma'am, Madam Ma'am.
City Attorney.
Yes, ma'am. The code allows rebuttal to provide the parties to allow testimony and evidence, cross-examination, and impeachment. So if any question about that, then the other parties can address it at that time.
At that time. Thank you very much. Ms. Tracy, please continue.
Would you like me to?
time is-
Thank you, Madam Mayor. Do I need to repeat that official letter that has been supplied and is part of evidence that's in this?
It's your presentation, Ms. Tracy. You're welcome to do with what you need to, and rebuttal time will address whatever concerns anybody else may have.
Thank you, ma'am. The reason I feel so compelled to bring this point to the matter is if in fact the actual board members did not understand that, yes, this property is zoned neighborhood commercial, but needed special exceptions for the actual gas, fuel pumps, the car wash, and then the waiver on the 24 hours, 7 days a week. This letter, at least by one board member who, may I add, did vote yes to pass this through, is clearly stating in this letter that he is of a different understanding. Not my words, not my written document, official document submitted to all city commissioners and to Nicole. That's all I'd like to add at this time for my presentation. I'm finished. Thank you, Madam Mayor.
And like I've done with the other presentations, I just want to confirm that you are finished with your presentation.
Yes, ma'am.
Thank you very much, Ms. Tracy. All righty, so now we will move on to Mr. and Mrs. Leslie.
Yes, ma'am.
All righty. Ma'am, we can hear you and your time has started.
My husband and I are homeowners on Price, almost directly across from Dollar General. In the Unified Land Development Code, neighborhood commercial high-intensity districts are permitted hours of operation, including deliveries, no earlier than 5 a.m. to no later than 10 p.m. To quote the special exception application for the city commission may approve special exceptions subject to appropriate safeguards. When appropriate, the city may waive or modify special regulations contained in the Unified Land Development Code on a case-by-case basis. To ensure that the special exception will promote the public health, safety, welfare, morals, order, comfort, convenience, appearance, prosperity, or the general welfare. Nothing about this plan has anything to do with what was just quoted from the city. A gas station does not promote public health in the least. There are major environmental and safety hazards that accompany a gas station, especially with many pumps and open 24/7. Every time someone pumps gas, vapors are emitted into the air. The many adults and children that live in close proximity to this proposed plan are at constant risk to those harmful chemicals in the air, soil, and drinking water. Even with the current safety precautions in place, the residents closest to this plan are not expendable guinea pigs. Many of Northport's residents are elderly as well and already have underlying lung conditions like asthma and are already at high risk for harm. All of the vehicles that would be at this site at all hours produce carbon monoxide. These constant emissions are absolutely harmful to anyone living in close proximity to a gas station. Fuel tanks in the ground house tens of thousands of gallons of fuel each. Most homes closest to these fuel tanks are on well water. We understand that there are safety precautions, but what happens when they fail? The entire neighborhood is at risk. Accidents happen all the time. How many oil spills, fires, gas leaks, runoff, soil and water contaminations have occurred even with precautions put in place. Things happen, and I wouldn't want to be raising a family right next door to find out. This proposal is far more appropriate elsewhere, not smack dab right in the middle of and directly up against residential homes. With that being said, safety is also a major concern with this proposal. The convenience store will undoubtedly draw in pedestrians. More people utilizing the sidewalks in a high traffic area means more adults and children at an elevated risk for traffic-related accidents. Cranberry Elementary is just down the road. There are many homes in the area surrounding the development plan that have young children. High volume traffic, illegal turns, vehicles speeding down residential streets next to and across the Cranberry and Price intersection are already something that the abutting residents are familiar with. Adding a large gas station, convenience store, and car wash will increase all of this, putting public safety and welfare at a huge risk. These types of businesses are inappropriate, unsafe, and highly inconvenient in a residential neighborhood. So not only is the public health and safety at a monstrous disadvantage with this type of business next door, the residents' welfare, comfort, and prosperity are at risk as well. Crime and other unwanted activity is higher near convenience stores and gas stations. Living near a business that is proven to be associated with increased chances of robbery, drug use, homelessness, loitering, and more does not in any way make the immediate residents feel comfortable, safe, or prosperous. Not to mention the amount of trash and debris that already accumulates on properties along Price and Cranberry. More will wash up onto immediate properties, as will pedestrians at all hours, walking by the local homes. Hearing people argue and yell near Dollar General is something audible from inside my own home. I can only imagine what my home and the surrounding homes will be subjected to with added traffic on the streets and sidewalks at all hours. One should feel safe in their home, not frightened as to what health hazards they're being needlessly exposed to right next door, or who will be lurking around their home at night. All of these things can be easily avoided by developing a more practical business in this proposed area. Northport is a city on the rise. There are 13 gas stations within 2 to 7 minutes from the proposed site. An identical 7-Eleven gas station, convenience store, and car wash was just built on the corner of 41 and Toledo Blade. How many of the same businesses in one city is enough? Gas stations, convenience stores, and car washes don't add any aesthetics to a residential neighborhood. They decrease property values, increase insurance rates, decrease public health, safety, comfort, and prosperity. The neighborhood will be less desirable, at unnecessary risk for additional crime, and at increased risk for health hazards, abundant light pollution, and rampant noise pollution. Nothing about this plan is convenient or prosperous for this or any neighborhood. With 300 signatures on a petition created by residents for residents and over 200 letters and emails opposing this plan, the neighborhood has spoken. This is not an asset to a primarily residential area. These residents are loudly voicing their opposition on all outlets: email, social media, public comment, letters, and in person here today. We're not anti-development, we're pro-community, health, safety, and welfare. Please, by all means, develop that land, but develop it into something that will better the community and its surrounding neighbors. Something appropriate and harmonious, like a park, coffee or ice cream shop, a walk-in clinic, or small mom and pop shop. Something that is not a direct threat to a residential community's health, safety, welfare, comfort, convenience, morals, order, appearance, and prosperity. The community deserves to prosper along with its city. Please give us that chance. Thank you.
Ms. Leslie, I just want to confirm also, I believe your thank you is a sign that you are finished. I just need confirmation that you are finished with your presentation.
Yes, ma'am, I am.
Thank you very much. Before I move on to city attorney, city manager, you had your hand, you wanted to speak, and then I'll get to city attorney.
Yes, ma'am. The recent speaker didn't say whether or not they were sworn, and I know that we'd stopped staff right at the very beginning of the presentation, and we need to make sure she's been sworn.
Yes, I was.
Thank you. If you could
It just
state
wasn't
your-
verified.
Thank you. Ms. Leslie, if you could state your name and that you were sworn.
I am Maria Leslie, and yes, ma'am, I was sworn in.
Thank you. I saw you get sworn in at the beginning, so I appreciate the double checking on that, city manager. City attorney, you had your hand raised also?
Yes, ma'am, for the same reason.
For the same reason, thank you. All righty. So we got that little bit taken care of. I appreciate that. So at this time, now that presentations have been concluded, at this time we will go ahead and go on to rebuttal. Each person will have 15 minutes for their rebuttal, and I will strictly adhere to that 15-minute mark. So Mr. Boone, are you ready?
Yes, ma'am.
Excellent. You do have 15 minutes, sir, and your time has now begun.
All right, thank you. We will begin with Matthew Gillespie, project engineer.
Yes, Matthew Gillespie, project engineer, Kimley Horn, and I have been sworn in. This is in response to some of the comments and continued talks with Elizabeth Wong with the city. We are in an agreement with providing a conservation area easement for the remainder of the property. The DMP plan that's shown has a property line through the wet pond that will be removed, and the conservation easement will be dedicated once the exact limits of all the design for the stormwater pond has been completed. The other item was a oil and water separator with a trench drainage collection system will be investigated by the developer to help prevent surface spillage around the fuel tanks and the fuel pumps. The developer agrees to provide structural BMPs for surface spill control, as that was some of the concerns that was brought up during the past communications. And we also will develop a spill prevention plan, which 7-Eleven has a standard spill prevention plan that will be provided to the city during the next round of review process. And concerning the odors and vapors from the fueling of the vehicles themselves, a secondary recovery system that was mentioned by Neil Campbell earlier will be added to the fuel pumping system. So this will be a secondary vapor recovery nozzles that will be added to the fuel pumps themselves to recover any vapor that may be emitted during fueling of the vehicles. And that is all. Thank you.
Thank you, Matt. First, we would like to ask staff to correct the statement that was made about the PZAB hearing on May 7th, and would like that to be corrected for the record, please.
For the record, Nicole Galehouse, planning manager, and I have been sworn. Yes, the statement about the Planning and Zoning Advisory Board vote was not correct. They did vote for to recommend approval for the 24/7 operation. The only modification they made was to reduce the number of fuel pumps to 14. And in terms of the rest of that conversation and that email, I'll address that during my rebuttal.
Okay, thank you, Nicole. We also would like to just make some comments about the evidence that was submitted by Ms. Tracy. Just moving real quickly, I'll go through some of the crime that she cited in her evidence or exhibit evidence. She has a last example, which is the crime everybody fears, is the arrest with guns and drugs. This occurred at a strip plaza in Port Charlotte that had no gas station within half a mile of the plaza. The plaza directly abutted residential, and some of the units within that plaza were the Charlotte County Democratic Club offices, a tailor, a market, and a church unit. There was a convenience store robbery she cited in Charlotte County. Again, convenience store is a permitted use here for the property. There's a bike hit and run, which has no relationship to the commercial development of our property. There was a theft of a wallet at a Publix. There was the Carly Brucia abduction from the Evie's restaurant in Sarasota, which is a restaurant, a bar, a driving range, a mini golf course, and a car wash on Bee Ridge Road that occurred in 2004. There was a police stop, not at a gas station, resulting in a drug and weapon arrest where the officers saw the car at the gas station and then decided to follow it. And then there was a body of a homeless man found along Sumter Boulevard in the Heron Creek Town Center, which has the Publix and multiple other retail commercial units. The electrical fire she mentioned, that was a fire caused by rats chewing on or nesting in an electrical box. The fire was put out by the Northport Fire Department, and comments also alleged that the fire was caused by the building not being up to code. There was the armed robbery at the Circle K that she did mention, which is crime that everybody is worried about when you think about bad crimes, safety issues with the neighborhood. However, there also was the same armed robbery at the Dollar General store, which is at a permitted use allowed in this zoning district. So that goes to show you that the gas station in itself is not a generator of more heinous, more violent crime than other uses that are permitted in the same zoning code. And lastly, she cited a gas leak that occurred in Sarasota, and we looked into it. This gas leak was actually a natural gas leak. It had no association with a gas station, and it occurred in Sarasota on the stretch of US 41 in between Field Avenue and Walt's Fish Camp up by the old Sarasota Plaza Mall there. I would like to ask a question of Ms. Tracy. I will share my screen. Ms. Tracy, this picture that you used on the beginning of your presentation, do you know when this picture was taken? Ms. Tracy?
Am I required by law to pitch actually when a published 7-Eleven picture is relevant?
I'm just asking if you know when the picture that you chose for your presentation was taken.
Yes, and I'm asking.
I will just assume you don't know when it was taken, so I will move on. My next question is, do you know where this store is located?
Again, I would ask the city attorney if my right is to answer such questions. It's irrelevant to as where this is. It's just a picture of a 7-Eleven.
I will just assume you do not know where the store is located. My final question then is, would you be surprised if this store is located in Taiwan and the picture is taken from 2008? I assume the answer to that question is yes, and that is all I have for this picture.
Thank you, Mr. Boone. Appreciate it.
Just one final thing. There was a crime sheet introduced into the record that it had police call data for selected convenience stores, gas stations, and also the Dollar General. And looking at the crime sheet, it is important to note that the crimes that people are worried about, the violent crimes and so on, those occur at the same rate at the Dollar General store, the permitted use in the zoning district, as it occurs at the gas stations. In fact, one of these calls listed as a public service call, and we had talked with former police commissioners to find out what exactly a public service call is. That actually is a non-criminal call. That's a call to the police for assistance for a matter that's non-criminal. And when you crunch the number of the stats that have been entered into the record, those occur at a greater frequency at the gas stations rather than at the selected convenience store, which again is a permitted use for this property. And with that, I am done with my part of the rebuttal. I'll turn it over to Jeff Boone.
Thank you.
Mayor
Madam
McDowell,
Mayor.
excuse me.
Madam Mayor and members of the commission, a lot was made about special exceptions and waivers, and I do want to address that. I think, as you all know, that I'm a licensed attorney in Florida, have been practicing land use law since 1983. I've been deemed qualified by judges in state courts in Florida to give expert testimony, including matters involving the city of Northport at one point in time. And I'll tell you that a special exception, and this is very much misunderstood by the general public, but a special exception is a permitted use in a zoning district as long as the use meets the criteria set out in the code. The uses that are never permitted in zoning districts are prohibited uses. And if you look at the list of prohibited uses for this zoning district, gas pumps are not listed as a prohibited use. Waivers are similar. All local governments, cities and counties, allow waivers to their code restrictions. It actually allows for the local governments to be able to make decisions to make sure that you don't have a situation where something is form over substance ends up blocking something from happening that would be good. So there's nothing illegal or improper in any way about a waiver or a special exception. We have an alternative development plan that we would like to show you. Do you have that, Jackson, to bring up? We could have some time to bring that up, Madam Mayor, like we allowed Ms. Tracy. We'd appreciate it where it wasn't on the clock.
I'll go ahead and pause for the time being.
Thank you very much.
I've paused your time.
Thank you.
Sorry, Madam Mayor, how does an additional proposed development fit into this hearing right now? How is this relevant information as to something that they're like, oh, we have another great idea?
If I could respond to that, Madam Mayor, and this is off the clock, obviously.
Ms. Tracy, you'll have to, Ms. Tracy, hold on, guys. Whoa, stop. Ms. Tracy, you'll have to wait for your time for rebuttal. Mr. Boone has the floor right now. Thank you.
Thank you, ma'am.
Mr. Boone, your time is resumed.
Thank you, ma'am. Commissioners, what we have before you is a general commercial center on this very site, prepared by our licensed professional engineer to meet all of the Northport City Code standards. The uses that would be in this strip center could be restaurants, could be any types of uses that are permitted by the city code, tattoo parlors, massage parlors, those types of things. Could also be restaurants with outdoor, not outdoor entertainment, but restaurants with outdoor dining, any convenience stores, any types of stores. And you'll notice that the rear of the buildings, which allow for deliveries in the rear, and also allow for traffic to be in the rear, dumpsters that are in the rear for garbage pickup and all those sorts of things. This is a development that could occur on this site without any type of special exception or anything. And we believe that what we are proposing is clearly superior to what the code would allow. And as Jackson Boone pointed out earlier, the crime statistics were just convenience stores are the same, if not more, than for a gas station. And now you have more uses generating more potential crimes than you would if you just had the one use, which is the gas station. Our traffic that would be associated with the code
3 minutes,
compliant
Mr.
development.
Boone, 3 minutes.
I'm sorry?
3 minutes.
Oh, okay. Thank you. The traffic associated with this code compliant strip center would be significantly greater than the traffic that we're proposing for just our one use, which is the convenience store with gas pumps. And again, we want to reiterate that the traffic that we are collecting here is traffic that is, by and large, over 3/4 of it is already on the road to begin with. and it prevent that same traffic from congesting other intersections in the community. And we are talking about, as far as the additional traffic in the morning, every hour, just 23 vehicles over the entire peak morning hour, and in the peak evening hour, 26 vehicles. That's the additional traffic that we're being called for here. It's important, and we would remind everybody to please think of Price Boulevard not as the Price Boulevard of today, but as the four-lane road with a center turn lane, being, in other words, a 5-lane wide road running east and west through the city of Northport, the major east-west road that's a city road, not a federal highway, but the major east-west arterial in the largest city in Sarasota County. One of the planning board members actually referred to Fruitville or Veneva, referring to some streets in Sarasota that are major they run east and west as well, major east-west roads in the second largest city in Sarasota County. And that, for now, concludes our rebuttal. Thank you very much.
Mr. Boone, you have 1 minute left. I just want to confirm you are finished with.
Yes, ma'am. Y'all know me. I'd love to talk for another minute, but at this point, I'm done.
Mr. Boone.
Yes, ma'am. Can you hear me?
Okay, now I can. Yes.
Yeah, I just said, you all know me. I'd love to talk for another minute whenever I have the opportunity, but at this point, I'll pass and we can move on.
Thank you very much. All righty. So I have your time stopped. Thank you. All righty. Now it's staff's turn. Staff, you also have 15 minutes that I will strictly adhere to, and your time begins now.
Thank you. So I'd like to start by taking a minute. Mr. Boone touched on this briefly, but it was brought up that this goes against our land development codes, and with so many special exceptions and special privileges, why is it even being considered today? And so I just want to take a brief moment and kind of explain that. Our code does allow the convenience store by right. The fuel pumps and the car wash are special exceptions. What that means is that it's not a prohibited use that we're sometimes allowing. It's a use that, when properly managed, and that's what the special exception allows, is for the proper management of that use, is potentially compatible with the neighborhood. And so at some point in time, the commission that put in this code determined that for the neighborhood commercial high intensity land use, that the special exception and car wash could be compatible if the circumstances were right. And so that's what today's hearing is to determine, if those circumstances are right for these uses to be permitted on this site. Again, the special privilege, I believe this is referring to the waivers, and our code does have a process for waivers, allowing, if the commission were to allow 24-hour operations, that's not violating our Unified Land Development Code. It is using a process for waivers that is put into our code, and that waiver ensures compliance with our land development regulations. So I just want to make sure that the procedural parts of this are understood. This kind of ties in a little bit with the concern that was raised about our Planning and Zoning Advisory Board member not understanding what was said. It was asked of me at that hearing if the use was specifically permitted. It was asked if the convenience store use was permitted, to which I responded yes. The staff made it very clear at that hearing that the fuel pumps and the car wash were special exceptions. They were not permitted by right. I think I probably said that at least 3 times during that hearing, and the video and audio are available if anybody needs to go back and watch it. It's unfortunate that there's a misunderstanding with our board member, but we did try to make that abundantly clear. The last thing I just wanted to point out, we do have police who is available to speak to any of the crime issues and the incidents that are in the city to clarify some of those points if needed. And then finally, the conceptual plan that was shown at the end of the previous rebuttal is not in compliance with code. Just from a very quick glancing of that, there's uses in there that are greater than 5,000 square feet, which is a limitation of this zoning district. And this zoning district also limits to 1 row of parking along the roadways. That being said, it does illustrate a potential different scenario, but I just wanted to be clear that the scenario as presented is not necessarily code compliant. And I believe that's all I have for right now. Thank you.
And staff, I just want to confirm you are finished with your rebuttal.
Yes, I am.
Thank you very much. All righty. Ms. Tracy, your time. Are you ready to begin? Your time begins now. You have
Thank you,
15
Madam Mayor.
minutes.
Based on the information that I submitted regarding the crime that Attorney Boone has tried to discredit, this was all information pulled off of the Northport Sun, as well as police public record. And I quoted all information that was stated. I will say that as far as the letter in question provided after the PZAC meeting, that there was some misconception as far as with the zoning and what was going to happen, future, present, past. Again, that's obviously no fault to Nicole, as I do recall she stated these things, but at the end of the day, there's still written communication submitted into the commission that states that one or possibly more board members who did vote on this were under a little bit of a different understanding, and that just should be something that's pointed out, obviously. I feel like the additional proposed development of this strip mall, quite honestly, is just a scare tactic from Mr. Boone to try to intimidate residents and say, look at the sweeter deal, very similar to as they did with trying to offer this additional piece of acreage to the city, which again, nobody really seems to have a solid idea of who's going to pay for what, maintain what, secure what. I'm not quite sure if from the gentleman who is the state appraiser, I'm sorry, I do not recall his first name, that represented Mr. Boone. He verified lots of properties. If you paid attention, I'm very aware of Venice as well. And most of those properties that he compared are on US 41. We're not US 41. US 41 is commercial zoning, US 41. So sure, I don't see how it's relevant to our back neighborhood. And then the lots that he did give in our area, again, a mobile park home, which is again off of US 41. He gave a generalization of some vacant lots behind our local Dollar General. Well, those are vacant lots. So how do we know how the future possible owners that may purchase that property, if a gas station goes in, will those lots even be built upon, quite honestly? So, I mean, okay, the value of the property is there and we know how much that lot costs, but there's nothing that states in writing that was provided that says, well, how do residents actually feel like regarding living close to commercial development. As far as the traffic situation that he claims is not of relevance, it's, sir, of relevance when actual pedestrians are being struck by vehicles due to congestion and cluttered roads already, and just being distracted for one or more reasons, and they have happened literally within the Cranberry and West Price location in question to where your client wants to build more distraction and on top add more safety concerns. Provide commercial services at close distance, tax-based diversification. Cities need to strive to develop commercial. Residential lots approximately 250 feet from residential homes. I've already stated that toxic fumes and emissions such as benzene, petroleum, and carbon monoxide can travel up to or over 300 feet. The appraiser stated buffer in theory should be adequate to not cause reductions in home values or cause disruptions. However, I specifically had my home appraised for the impact for this development and was guaranteed at least 10% decrease in overall property value instantaneously and a significant increase in my homeowner's insurance. My insurance agency informed me that I should not have to be a customer with them for as long as I have. Their policy would not drop me as a customer altogether due to the increased hazard exposure and increased liability as a client. The experiments of the appraiser conducted based on a 45-year-old properties involve mobile homes, not stationary properties offering hundreds of thousands of dollars of worth and value potential. This is clearly not an accurate comparison, as I have consulted with appraisers and actual on potential ones. A pretty big fact that I would like to mention is the equipment containing prevention and monitoring systems in the fueling stations are Boone has stated that they are very sophisticated. It's been stated that there is even an automatic shutoff and additional containment area along with venting systems to control air emissions. They've also stated that vehicles have a built-in system. I've actually come across information that states in 2015, automobiles are not made to have any additional system to help with these vapors. However, benzene emissions from under the ground storage tank vents still show high output for constituted health concerns. Recent findings with regard to the vapor recovery and harmful emissions from gas station storage tanks. They are released at the pump during fueling. Vapor recovery at the nozzle can cause vapor release at the storage tank. Because some vapors recovered are directed back into the storage tank in turn can breathe and release recovered vapors immediately or at a later time. That tank sucks in relatively uncontaminated air as the liquid fuel drops in the tank due to the vehicle refueling, and it releases vapors through the vent pipe at a distance of 518 feet. If this didn't exist, then the pump could not dispense gas against the vacuum. Emissions were 10 times higher in some areas and recommended to determine how close schools, playgrounds, and people living near gas stations should be. The US EPA recommends screening sites for potential health risks when located within 1,000 feet of gas stations. These are all facts by the EPA. Facts, factual stuff that states the harm that's caused. These systems are not 100% not faulty, and accidents do happen. Sumps, things that can cause a sump failure is corrosion for one, bacteria growth for two. Living in Florida, we have high levels, obviously, of moisture, the amount of rain. It causes condensation on these metal fittings, which can corrode, which will make them faulty. If any amount of water is left or detected in the sump, it can actually deactivate the sensor that would say that petroleum is leaking. These are facts in the EPA that I have found. Facts. They can song and dance all they want, but they cannot, without a shadow of a doubt, sit here and tell me that there's not health risks. And on top of it, if you were to ask them where they live or if they would purchase a home next to a gas station in years to come, I would guarantee they would say, oh, no comment, or I guess their no comment I can take for yes, no, they wouldn't, nor do any of us. Thank you. Oh, I'm sorry. And one more thing. There's in the evidence of the ex parte, there's a full police record, so we don't really need additional verification. It's for everybody to see here of all of the actual occurrences in local Northport. This is everything, y'all. Pages of them. So whether it's, you know, significant or somebody got mad at somebody at a gas station, there is drug cases, there is robbery, there is felony, there's several. The list is long. By all means, feel free to pull it up because they can't lie about that. Thank you, Madam Mayor. I am finished.
So just to keep everything nice and clean, you have 4 minutes left. Are you specifically finished with your rebuttal?
I am specifically finished. Yes, ma'am.
Thank you very much, Ms. Tracy. All righty. So at this time, we will let Miss and Mr. Leslie go ahead with their rebuttal. And folks, you also have 15 minutes. Are you on and unmuted?
Yes, this is John Leslie speaking.
Okay, sir, you have 15 minutes.
Just want to be clear, I was sworn in.
Thank you.
All right. The appraiser stated that they had little reason to believe that placing the gas stations impacted nearby residents, which prompts me to ask, did they actually go out and ask or interview the residents as to their experiences living near a gas station? Did you ask about their day-to-day lives or what they go through? A qualitative study is designed to focus on experiences, feelings, and testimonies of people influenced or affected by outside source. These types of studies are extremely important when conducting research and predicting the experiences of those to come. Where are these testimonies? Where is the proof that we will be okay? There is none. We can only hope. Hope isn't enough when our safety is at risk. Neil Campbell stated there is a trust fund based on sale of gasoline implemented by the state showing real damage caused by stations. If something happens, they're responsible. This statement validates potential for harm. He also validated the presence of petroleum at these stations and in the tanks. Recovery process of petroleum gas cannot guarantee safety. He mentioned that cars are safe and don't emit these toxic fumes. However, as of 2015, cars are no longer legally required to have these filtering systems, meaning the sense of security you're pitching is false. The systems monitoring and fail-safes are not perfect designs, and as stated, can go wrong, resulting in a shutdown of the facility. Spills may have to be reported within 24 hours. However, once fuel is spilled, it can't be unspilled and will cause exponential damage. Take the BP oil spill, for example. Our planet has still not recovered from that disaster, and all BP could say was that they were sorry. We as residents are not guinea pigs. We are not expendable. Can't say I'm sorry when one of our kids gets cancer from benzene or our drinking water becomes toxic. You can't say I'm sorry if a fire breaks out and our homes and irreplaceable personal belongings are damaged and destroyed. Your trust funds and false promises can't buy our silence or make up for the damage you bring. I'd like to mention traffic-related impacts to wetlands, streams, rivers, lakes, and tidal waters result from building new roads within 100 feet of these aquatic resources or from the pollutants washed from road surfaces by stormwater. Groundwater is another aquatic resource which can be impacted by covering the land surface with asphalt, concrete, or other impervious surfaces. These impervious materials prevent precipitation from soaking into the earth and recharging groundwater systems but traffic pollutants can also be carried into adjoining soils and cause well contamination. This gas station is not needed in this area. Over the years, Comprehensive Economic Development Strategy, CEDS, has researched the effects of many proposed convenience stores, gas stations, and vehicle repair facilities. With regard to gas stations, the market area usually extends 0.5 to 1.5 miles. It takes about 3,000 to 6,000 people living or working within the market area to support a single gas station. There are 5,500 parcels within 1 mile of this property, of which only 2,800 homes have homes currently. Also mentioned, my property in particular is slighted when it comes to the generous buffer and the driveway on price. We would only receive about half of the buffer that all the other properties are proposed to have. And no other property is so very close to a high traffic driveway, not to mention that my home is also closest to overly gratuitous amounts of fuel pumps and tanks. This proposal directly contradicts the Unified Land Development Code, which is supposed to ensure that the special exceptions will promote the public health, safety, welfare, morals, order, comfort, convenience, appearance, prosperity, or the general welfare. That's all I have to say.
Mr. Leslie, I don't know if Ms. Leslie is going to finish up your rebuttal. You have approximately 10 minutes left, or are you completely finished?
I'm finished talking.
I think that we are set.
Okay, thank you very much. I just wanted that confirmation too from you folks. Thank you very much. All right, so now that rebuttal period is over at this time, I will turn it over to City Clerk so that she can read all of the public comments into the record, stating their name and what their comments are.
First public comment is from Keith Brown, and he writes, as full-time residents of Northport, my wife and I are adamantly opposed to the granting of critical exemptions to the 7.
Okay, hold on, stop.
Gas station at Price in North
Miss Laura, Miss Laura, could you please stop?
City officials had the good sense to ban
Oh, hold on a second.
I'm sorry, we're getting massive amounts of feedback.
I can't hear a word you're saying, Mayor. Oh, go ahead.
I'm getting massive amounts of feedback from her reading public comment. I cannot understand. I have a feeling if she's
We'll start over again.
Is she in the same room with you?
Yeah, I'm gonna mute mine.
Thank you.
Yeah.
That's probably what it was. Thank you.
Okay.
We'll try it again. If you could start over, please.
The first comment is from Keith Brown, and he writes, as full-time residents of Northport, my wife and I are adamantly opposed to the granting of critical exemptions to the 7-Eleven Corporation so they can develop a mega gas station at Price in North Cranberry. Years ago, Northport city officials had the good sense to ban large and highly trafficked businesses from locating in residential neighborhoods. Since then, most businesses of this kind have been established along large boulevards in commercial business parks and Publix retail clusters. Exemptions downside: noise. With 24-hour service and a car wash, it will never close and always produce varying amounts of noise. Vermin. Convenience food refuge attracts vermin to trash bins and dumpsters. Vagrancy. The proposed park-like setting will promote loitering, vagrancy, and create the ideal setting for crime littering. Littering will be a constant problem for those living nearby. Traffic congestion. Traffic and congestion will likely increase. Environmental damage. There is a potential for damage to land, water, and wildlife. Property value declines. Property values will likely be negatively impacted in the immediate area, and it sets a negative precedent. The exemptions upside: convenience. Conveniences will increase marginally over what is already available nearby. It will create higher city tax revenues if successful. Countless studies confirm the damage of this type as development causes to a variety of parties. To move forward with exemptions and development is senseless, nothing less than an egregious dereliction of duty as elected leaders. Increase city revenue, yes, but at what cost? Stephen Harrison writes, as a homeowner less than a block from the location of the gas station, I am concerned and opposed. We have a 3-year-old and are planning on another child, and I worry that the traffic caused by this store would put my family and property at risk. Additionally, there are known health risks to which children are vulnerable from gas fumes and possible petroleum ground penetration. Finally, as a resident of Northport, I can tell you for certain the last thing we need is another gas station / car wash. We have too many as it is and 3 already on Price Boulevard. If this store is to be built, I believe we should have some concessions, including but not limited to environmental impact studies, soundproofing wall barriers around the property, and added lanes on both sides of Cranberry at the intersection, along with the new traffic light to make sure everybody is safe while traveling. Jennifer Laffo. One of our biggest concerns is that all roads leading to this location are strictly residential and should not have semi-trailers driving through them to deliver fuel. We have lived here since 2013 and I have never seen a semi-trailer in our neighborhood, and we would like to keep it that way. We don't need and do not want the extra traffic and business so close to our kids and homes. While we understand that the property is zoned for commercial use, we feel that this was an oversight and that the original commissioners who zoned this never intended on having 16 pump gas station just hundreds of feet from residents. A gas station brings with it many environmental and health issues that will affect everyone living in the area. Nearly every home relies on wells for our drinking water. These precious underground resources literally run underneath the proposed site. The dangers above ground are just as scary. The gas fumes, the light pollution, and the potential drug paraphernalia are just a few concerns. As planners, the most important thing to consider is that there are no takebacks. Once this is built, it will always be a scar in our residential neighborhood. There are plenty of major arteries nearby where gas stations make perfect sense. This location is not wise, and we urge you to accept our point of view.
Janice Wilbert. January 2020, I met with 4 commissioners regarding a 24-hour gas station, convenience store, and car wash. My concerns were contamination of wells, traffic, children, noise, drugs, smell of gas, diesel, garbage, and lighting. I personally showed the commissioners my findings of gas stations in the area and gave them a copy of my findings for their reference. My findings: Cranberry and Price to Sumter, 3 gas stations, 1.5 miles. Cranberry and Price to 41, H2 gas stations, 2.8 miles. Cranberry and Price to Toledo Blade, 1 gas station, 1.7 miles. Cranberry and Price to Toledo Blade and 75, 1 gas station, 3 miles. How many gas stations do we need in this small area? February 3rd, I attended commission workshop regarding the ULDC and neighborhood commercial zoning. A particular topic came up: a 24-hour gas station, convenience store, and car wash in a residential neighborhood. Discussion by commissioners and much time was spent with many questions regarding each item, along with special exemptions. A vote was held and the commission voted unanimously not to have a gas station, 24-hour convenience store, and a car wash in a residential neighborhood. All of these had special exemptions. I agree with commission that a gas station of any kind, a 24-hour convenience store, and car wash is not to be in a residential neighborhood. Today, I ask that you remember how you voted on February 3rd, 2020, and vote no on these 2 resolutions. Thank you for your time and consideration. Janice Wilbert.
Catherine writes, as a homeowner in city limits, I absolutely protest the ignorant ideas of a gas station at the corner of Cranberry and Price. The fact that this was proposed plan would even come to the stage a possibility shows the flat-out disregard by the public servants voted into office on behalf of our wants and needs. The gas station is neither a want nor a need for this community. The EPA implications, because we are all on well water, is only the beginning of this problem. The social impact of having a gas station, especially a 24-hour one, is prevalent in every city area of a residential neighborhood that turns into a slum, mostly in rural areas that grow too fast for themselves, and documented social economic facts showing that it brings drug deals, late night transients or travelers, displaced wildlife such as rats, among dropping property values, creating a true cesspool of poverty in a slum neighborhood. Will Northport soon look just like the trash parts of Sarasota or Fort Myers, or even Port Charlotte, that made the same mistakes of allowing these sorts of businesses in residential neighborhoods? Northport should be better than that. Northport should take a different stance that does not cause economic divide throughout our community larger than it is. We are growing so fast, we have to be thoughtful in how we grow for a better future for decades to come. I beg you to stand up for the people of the city and make sure we grow to be beautiful and that we stand for something. Stand for a community that loves their tree city and its wildlife and loves our youth and wants to leave them in a city that is successful. We should make a good example of Florida and the West Coast and what we can truly create. We don't want to create another Florida slum that produces nothing but negativity on the news and a trashy environment that ruins the lives of those around it. Please instead propose a strip mall with boutiques, a gym, a daycare, thrift stores, and a mom and pop restaurant. Something that gives the neighborhood kids their first jobs. Gives that mom around the corner a break to shop at a trendy thrift or not cook without going to a chain. I'm begging you to raise the bar for what this city can be, what us citizens deserve, and what the great state deserves from its civil servants. It deserves prosperous communities, not government agencies willing to cut corners and make exceptions for big business like a 24-hour toxic gas station that is out of place and unnecessary to pop up in our backyard. Lastly, if you make the mistake of ignoring the wishes of us citizens, you'll have a new problem on your hands. The disdain for the mismanagement of this city has been growing, and I promise you this gas station will be a tipping point of our complacency if it is approved. Thank you.
Thomas Germain. Mayor, Vice Mayor, Commissioners, I live behind the Dollar General. I know firsthand about noise, fumes, lighting, drug activity, trash, and rats. Any store that sells food of any kind throws food away, which cause a rodent rat problem. I'm also aware of drug activity and drug paraphernalia, such as needles left on my property. What will you do if a neighbor of this convenient store, gas station, car wash steps on a needle, or a child should pick up this paraphernalia that could cause them serious health problems? Is the city willing to accept a lawsuit because of drug activity that comes from convenience store, gas stations, or car washes that are not properly monitored? Let's read between the lines. This developer owner only wants to give back unneeded property so they don't have to pay taxes on this unused property and not having to maintain the property for a park, which will only bring in homeless and drug dealers. What family with children wants to be at a park on price? Let's go to the park so we can hear the car wash, smell the fumes, see and watch the homeless, and witness drug activity. Is our neighborhood worth this development?
Alice White writes, when this property was rezoned maybe about 15 years ago to allow for current zoning, it was with the understanding as relayed to the residents at that time that development would be limited to small stores. Gas stations would not be permitted with the rezoning that was proposed and eventually approved. Special exemption provisions are put in place to allow for the flexibility to reassess the changing needs of the community versus how the property could meet these needs. The surrounding area is residential with neighborhoods of families and children. A gas station would be a harsh intrusion on the quality of life for the number of people who have now taken up residence in the adjoining neighborhoods, an intrusion that even 2 acres of parkland could not ever diminish.
CJ Baker. My household opposes the granting of critical exemptions to the 7-Eleven Corporation for the development of a mega gas station at Pricing North Cranberry. The downsides include noise. A 24-hour business means noise disturbance around the clock. Toxic chemicals, gasoline fumes, and car wash fragrances. Chemicals being released in residential areas is a health hazard. Vermin, convenience foods refuse attracts pets of all kinds. Litter. Litter is already a problem around the city due to the increased number of businesses. This will add to the problem. Traffic. Traffic on Price has been a long-standing issue, and this will add to the congestion. Environmental. Removing natural landscapes puts wildlife at additional and unnecessary risk. Property value declines. Property values will likely be negatively impacted in the immediate area. It also gets negative precedent.
Joanne Butenhoff writes, please do not allow gas station insurance backyards on Cranberry and Price.
Gabe Tracy, this is such a sad state of affairs that we are even faced with such rubbish. I can't even begin to believe or understand as to why and how this community is faced with deciding if whether or not it is appropriate to allow a gas station in the middle of a residential community. This vote needs to be voted down as a unanimous no. I am completely appalled that this position has ever been allowed to be passed throughout the advisory board.
Stephanie Posey, I just want to comment that it has been mentioned that the traffic is already there. The cars are already going by. There is a big difference between cars passing by your house versus congregating near your house.
Jennifer Laffo, our family strongly opposes the construction of the 7-Eleven with all the extra special exemptions at the corner of Cranberry and Price Boulevard. One of our biggest concerns is that all roads leading to this location are strictly residential and should not have semi-trailers driving through them or to deliver fuel. We are Northport residents since 2000 and have lived in this house since 2013. I have never seen a semi-trailer in our neighborhood, and we would like to keep it that way. We don't need or do not want the extra traffic and business so close to our kids and home. While we understand that the property is zoned for commercial use, we feel that this was an oversight that the original commissioners who zoned this never intended on having a 16-pump gas station just hundreds of feet from residents. A gas station brings with it environmental and health issues that will affect everyone living in the area. Nearly every home relies on wells for our drinking water. This precious underground resource literally runs underneath the proposed site. The dangers above ground are just as scary. The gas fumes, the light pollution, and the potential drug paraphernalia are just a few concerns. As planners, the most important thing to consider is that there are no takebacks. Once this is built, it will always be a scar in our residential neighborhood. There are plenty of major arteries nearby where gas stations make perfect sense. This location is not wise, and we urge you to accept our point of view and think of our family and your family.
Jason Katia, I am commenting in opposition to the special exemptions requested by the convenience store at West Price Boulevard and North Cranberry Boulevard. If the development requires a list of exemptions to the current zoning, then it simply does not belong there. The small city charm that Northport used to hold has now been replaced by gas stations, car washes, and auto parts stores as far as the eye can see. The commission has favored development over its residents for a long time. As evidenced by the outcry on this issue, the citizens are tired of being trampled on by overdevelopment. Your individual votes will proclaim loudly whether you either stand for the residents of your city and sensible growth or will continue to allow unrestrained commercial growth without concern to the effects on citizens. This stance will be an important point for voters to understand in the upcoming elections. Therefore, I encourage you to oppose the special exemptions for this development.
David Ianetti. Hello, commissioners. Approving a 24-hour, 7-day-a-week gas station and car wash on a neighborhood commercial zoned parcel goes against the letter and spirit of the city code. Section 53-178 intent. The neighborhood commercial NC districts are intended to provide for the customary and traditional conduct of limited trade, retail sales and commerce in a manner convenient to and yet not disruptive to adjacent residential areas. 53-179, and shall hold hours of operation, including deliveries, no earlier than 5 a.m. to no later than 10 p.m. A 24-hour, 7-day-a-week business does not meet the state intent of limited trade. A 24-hour, 7-day-a-week gas station with car wash does not meet the stated intent of not being disruptive to adjacent residential. Should such exemptions be granted, it would be effectively making the city's neighborhood commercial zoning designation meaningless. Such a precedent would undermine city code incredibly while disregarding residential property owner reasonably expectations to prosperous enjoyment of their property.
Jennifer Perry, please deny the special exception for the 7-Eleven gas station at the corner of Price and Cranberry. This type of business does not fit the zoning in the area. A 24/7 gas station in the middle of a residential area brings safety issues to the area. There are multiple gas stations and car washes within a 3-mile radius, so there is no need for an additional one in this area, which it is not zoned for.
Cameron Burkhart. Although gas stations follow strict health and safety guidelines, there is still significant hazardous material that pose a risk to the nearby community. Ozone pollution is a problem at gas stations and have been known to cause an array of environmental issues. Polluted water, air, and soil. Besides the ecological factors, nobody should have to live next to an eyesore gas station. The city has enough gas stations in the area, numerous within a mile away. So the excuse of providing service to the areas is not a justified reason for the gas station. If the great city of Northport cares about its community residents and environmentalists, they will do the right thing and oppose the idea of the 7-Eleven.
Alexis Marie, hearing that a development as unnecessary and ill-fit as a gas station is proposed to go on the corner of Cranberry and Price is enough to blow my mind. Just because a piece of land is zoned commercial doesn't mean you can or should just put anything there. City code and zoning has very specific and well-balanced allowances for what that plot of land can be used for, and nowhere in those ordinances are fuel pumps, car washes, or 24 hours of operation permitted. If this developer is solely interested in placing a convenience store with regular hours of operation on that land, then so be it, as it is written plain as day in our codes that it is allowed. However, they can take their toxic gasoline tanks, leaky pumps, and unnecessary car wash elsewhere, as it belongs nowhere near homes and families. Just the mere aspect of a 24-hour operation is disruptive to the peaceful environment that our town offers its residents at night and invites nothing worthwhile to anyone except 7-Eleven's bank account. There's not a single person that lives within a regular usable distance from this proposed development that needs it. There is a difference between convenience and abundance. This area of Northport has more fueling stations than it genuinely needs, and adding another one in the middle of a residential zoning is distasteful. Property value will suffer, and residential and curbside appeal will decrease as current residents are outraged and future residents will not want to purchase homes. The plan for development is astronomical with the future of Price Boulevard widening project as drivers can efficiently access the property, which will result in illegal turns, cut-throughs using the neighboring roads, and will instigate traffic accidents, violations, and threaten the already suffering residents surrounding the would-be development. This proposal is a mess and should never be entertained. Northport relies on its officials to make decisions to benefit and protect residents. Approving this development would place residents in harm's way and set the stage for other developers to try to come in and misuse other available lots. Our commissioners need to listen to science and to their residents' begs and demands for this gas station not to be allowed.
Carl Hilbers. Gas stations have no business being anywhere near houses. Even at their prettiest when they're first built and the paint is fresh and the landscape is maintained, they are unattractive and the fumes are horrible. Traffic is disruptive and the owners don't keep up with the maintenance, causing an eyesore. I have been keeping up with this project and seeing the articles in the paper and all over social media. Stacy Tracy is right about all of her research debunking the pretty claims that 7-Eleven makes to try and disarm people about the obvious dangers associated with gasoline and gasoline stations. Without all of her hard work in informing the public, there would be so many others like me and my wife that had no idea about this. A proposed development as disruptive as a gas station, especially when they need special exemptions, should be made more readily known to the public. I have friends that live 2 streets away from this land that to this day on 6/14 still have not received a letter informing them of what was happening. That's not right. I am grateful to Stacy for her hard work and how much she has opened the eyes of the community. I can only hope that the commissioners will support the voice of people and vote no to this development.
Marissa, placing a gas station near a home has many risks. This can contaminate local well water. Underground pipes or tanks that rust or leak can also release contaminants into surrounding areas. Gasoline is highly flammable and releases many toxins. If you place this gas station close to many homes, you are putting lives at risk, possibly causing lung conditions, and later on, this can be a lawsuit that you should avoid.
Stephen Harrison. As a family living with the radius of the proposed 7-Eleven, I am concerned. We have a 3.5-year-old and are planning a second child. We are on well water and would be affected should there be a leak in the petroleum tanks. Furthermore, increased traffic due to a convenience store, gas station, car wash would negatively impact us. We live on a road that is essentially an unofficial roundabout, and people may use our road to circumvent traffic. This could be hazardous to our child or children. I'd oppose this location for a gas station. I submit that we have another between Toledo Blade and Sumter. I submit that we have enough between Sumter Boulevard and Toledo Blade. Additionally, if there were to be approved, at the very least, we would require a full-on environmental impact study. I also find that the gas station's promise for a park and a barrier for residential neighborhoods to be inadequate. Just because they are offering more than they have to does not ensure that the safety of the citizens who inhabit the area of the proposed gas station.
Diane Harrison, I'm very concerned about being in close vicinity to this proposed gas station. There's absolute no need for a 24/7 gas station in this area. There are stations in every direction in under 5 miles. There's a Dollar General right across the street for convenience. I foresee if this goes in, we will see higher traffic, which will put my child at risk when she would like to play outside. Am I going to have to look my child in the eye and say, sorry, it's not safe to bike outside the house anymore?
Kenneth Laffo. I do not have a law degree and I am not involved in public office. However, I have forced myself to read about each of these exemptions and I am baffled that we're even debating this. Under Section 53-179 of the Unified Land Development Code, special exemptions should be required for more than the city is deliberating. As a layman, I found 2 exceptions that were overlooked or ignored, which should apply to this proposed 7-Eleven. Number 1, package store to sell alcoholic beverages. Do not intend on selling alcohol, ? Check cashing, currently not permitted according to Code 53-79. 7-Eleven offers check cashing. Why have these 2 exemptions not been added to this proposal? 7-Eleven claims to be an everything store. Should it not have to follow code for everything it aims to do? My next point, safety. I run up and down every road surrounding this location. I see young kids riding bikes, playing on driveways, playing basketball, and treating their streets as typical residential streets. During the last meeting, Vanessa Carasone revealed a stark picture of just how dangerous the consequences of the 7-Eleven would be. The proposed traffic pattern has only 2 options for ingressing and egressing the property. This ridiculous design will at some point have deadly consequences. I urge every member of the commission to analyze and review how these 2 ingresses and egresses will affect driver behavior. For example, exiting drivers who live north of Price will have to turn on Waconia Street, subsequent back roads to make their way to Cranberry in the northbound direction. These are the roads I run on and where children are constantly at play. Number 2, exiting drivers who live east of Cranberry will likely attempt to follow a similar pattern from example 1, because there isn't much distance from the 7-Eleven exit to the intersection, and drivers will need to get into the turn lane, which will be hard. There are very few examples where an ingress and egress do not put lives in danger, and this leads me back to Northport codes and articles on special exemptions. These are the criteria that City Council must review and must adhere to. Section 53-259, item K, the ingress egress to the subject parcel and any structure involved shall not adversely affect traffic flow, safety, or control. Section 53-259, item M, the proposed use shall not adversely affect traffic flow, safety, or control of the surrounding roadway system. This council needs to look any further for reason to object to this proposal, as these two items clearly, irrefutably instruct you to deny these special exemptions. Traffic will adversely be affected. Think about it. No other gas station in Northport drives through residential neighborhoods. Trust me, I have checked every one of them. Those surrounding communities are safe. This one is not. I urge you to do the safe thing and not create a tragedy.
Laura Stuck, I do not think we need another gas station / car wash at Price and Cranberry. We have so many now within a 5 to 10 mile radius. It will bring the value of the homes around this area and cause a lot of unnecessary travel through this area, even if streets are widened. Need the gas stations, car washes closer to exits to Northport. Please take this comment into consideration when you are determining your vote. Thank you.
Sarah Hayes. I strongly oppose the 7-Eleven gas station on the corner of Price and Cranberry. Our home is less than a mile from this location, and it is completely inappropriate for a 24-hour gas station and car wash. I realize those 4 corners are zoned commercial. However, a 24-hour gas station and car wash is not even remotely neighborhood friendly. There are currently several gas stations within a 5-mile drive from that location. Traffic on Price is already very difficult during heavy traffic hours, and there have recently been several accidents, and this will just add more traffic and noise in our quiet neighborhood. There will be many other negative impacts on our neighborhood from environmental safety and decreased home values. You need to consider the direction you are taking our neighborhood and our city.
Ryan Hayes, I strongly oppose the 7-Eleven gas station on the corner of Price and Cranberry. Our home is less than 1 mile from this location. There is no need for a 24-hour gas station with a car wash this close to so many residential homes. There are currently several gas stations within a 5-minute drive from that location. There will be too many negative impacts on our neighborhood. Some of the impacts from this gas station will be decreased safety for our children, increased traffic and noise in our neighborhood, decreased home values, and possible environmental concerns. Considering the majority of these homes in this neighborhood rely on well water, please reconsider.
Nancy Fearn. The land is already zoned commercial, and the place could put in 12 pumps, but not a car wash. Do we really need another car wash? No. Northport needs to follow the plan set forth for the city, but professionals in the city planning. Not every business should be given exemptions. The business should want to abide by already in place plan in order to be set here. Northport should not bend. It is the businesses should bend for Northport.
Deborah Mays, I oppose the building of the 7-Eleven gas station at the corner of Cranberry and Price. There are numerous gas stations within a 3-mile radius of this site. There's already a heavily congested area, and I feel this business will add to problem. We are a residential neighborhood, and most of us are on well water. The gas storage tanks could leak and pollute our water. If you give this business the variances they are asking for, what will prevent a similar gas station from building on the other 2 commercial lots? Please vote no.
Dennis Burkhart. We own the property on 3057 Lakaya Street. My wife Jennifer and I purchased this house as a retirement home, believing it was a quiet neighborhood, far enough off Price Boulevard, with possibly homes being built on Price in the future. We never imagined a busy convenience store with gas pumps, car wash, overhead lighting, busy traffic 24 hours a day in our backyard. Please tell us this is not going to ruin our hope for a quiet neighborhood. I know we do not stand much of a chance against big money like 7-Eleven, and city government seems all but ready to rubber stamp the project. We would hope you would consider our plan for retirement in the near future. We love Florida and the Northport area. We once lived in Pinellas County and do not want to relocate back there from Pennsylvania because of the growth and congestion and traffic. We found Northport to be just the place for us and purchased a small retirement home, 3057 Kaya, several years ago. We are also concerned about the increased traffic bringing crime into the neighborhood. We currently have the home on Lakaya rented, but hope to have the renters move out so we can renovate and relocate to the home ourselves. Again, please consider our hope to keep the area residential. Thank you for your time. Thank you for your time this morning and reading our comments. We hope and pray that our feelings would be considered in making this decision for the future of our Lakaya Street and the city of Northport.
Kristen Padalecki. I live in the area of Price and Cranberry, 2 blocks from where the proposed 7-Eleven gas station may be built. Please know that I am not in favor of this. I understand how important it is to have development in our city. However, I do not understand why we need another gas station, especially at this intersection. Leaving from this neighborhood, there are 7 gas stations at 4 nearby intersections. If you are to leave the Price Cranberry neighborhood and head east, there is a gas station at Toledo Blade and Price. If you are to leave and head north to the interstate, there is a 7-Eleven at Cranberry and Toledo Blade. If you are to head south, you will find 2 gas stations at Cranberry and 41. And if you were to head west, you will find 3 gas stations at Price and Sumter. Please explain to me why we need one at Price and Cranberry. How is putting a 16-pump, 24-hour gas station in a residential neighborhood a good thing? I understand that Price Boulevard is an east-west connector for our city, but this is the middle of the residential neighborhood. What kind of crime will be invited here with the 24-hour gas station? A preserve with a paved path will provide a buffer between the gas station property and the homes surrounding it. It's not much of a preserve when you have refueling trucks driving by at all hours of the day or night, and the bright lights from the gas station will surely cause disruption to the wildlife in this preserve. Who plans on paying for the upkeep of the preserve? I really hope you don't count on 7-Eleven paying for that. The city will need to add the upkeep of the preserve to their budget. 1 block from the gas station is a school bus stop at Cranberry and Alessio Avenue. This bus picks up and drops off for Cranberry Elementary, Huron Creek Middle, and Northport High School in the mornings and the afternoons. There are no fewer than 50 kids that use that bus stop every single day during the school year, many of them walking or biking to that stop. To add additional traffic in and out of a gas station during the morning and afternoon commutes is a tragedy waiting to happen with these children and the bus stop. Most of these houses in the neighborhood are on well water. I understand that 7-Eleven intends on putting double-walled gas tanks in the ground, but what about the gas that is spilled on the ground at pumps? Where does that go? And when it rains and the water mixes with gas, where does that go? It runs off into our groundwater and into our wells, which poses health risks of great concern. Understand, I am not opposed to development at this intersection. The type of development is what I am opposed to. There is no need for a gas station, especially a large 16-pump 24-hour one at this intersection. Ask for yourselves, if this development needs all the special exemptions, does this really need to be here in the first place? It is zoned as it is for a reason, not for some developer to come in disrupting this area.
Jennifer B. Burkhart. My husband and I purchased a home that we have been renting until we can retire in a few years. 3057 Lakaya, Northport, Florida 34286. This convenience store will be directly behind our house. We bought it because we love the area and the quiet neighborhood. We were never told that this could be a possibility. This addition of a noisy convenience store will ruin this lovely neighborhood. It will devalue the property located behind it, and it is not fair to the homeowners. It will drastically decrease the quality of life for the residents in this neighborhood. We plead with the court to see from the perspective of the residents of this area. Respectively, Jennifer and Dennis Burkhart.
Joanne Butenhoff. I live on the block of the special exceptions request for gas station pumps and car wash on Cranberry and Price. We, the people of the neighborhood, do not want a gas station at this location. This would be literally in my backyard. I have never imagined this would be considered. When Boone sent me a letter for his first meeting about this, I threw it away thinking surely this is a scam. I've never in my travels have seen a gas station between houses where people live. I have one question for the commissioners. Would you want a 16 pump gas station in your backyard? Think of the reasons you would not want this in your backyard. This is how we feel. They can have a convenience store or Pizza Hut, but the special exceptions they are asking for are not allowed and should by no means be allowed at this location. The tankers to bring the gas would have to go right through the housing neighborhoods in any of the 4 directions heading to this location. This is not legal. Let's keep the gas stations on the main drags and not next to our bedroom windows, please.
CJ Baker. If you're disregarding all the statements from the last meeting, please reread public comments from the last meeting into the record. It's not fair to us who commented previously to be ignored now because your staff messed up with the notices. And his previous comments were read.
Richard Shriek. I am opposed to the proposed 24-hour 7-Eleven gas station and car wash at the intersection of Price and Cranberry. Soon we will have to refer to our city as Northport Mall. Enough commercialization already. Use the land for community parks, playgrounds, etc. There are empty commercial buildings all over town. Do we really need another 7-Eleven?
Judy Leach. I would like to remind our commissioners that you were voted into your position by the citizens of Northport. It is my hope that each and every one of you, when voting, take into consideration the will of the people who elected you. Some of you may be aspiring to new goals and others may be nearing the end of your term, but let me remind you that your current position as a City of Northport Commissioner is to represent the people you serve today. Thank you, Judy Leach.
Mayor, that was the last public comment.
All right, thank you very much for that. At this time, it's about 2:15. The next item that we would be doing is commission questions. I am going to recess this for 10 minutes, give us all a health break so we can delve into the questions that the commission have and then hear closing arguments. So at this time, it's now 2:11, and we will reconvene at 2:21. Thank you. Holy shit, 43 emails.
So glad it wasn't me. Just
Yep.
saying.
Yes,
I
we
was-
all heard that.
Yep, wasn't me either. Not this time.
Holy crap, did the mayor just say that?
Yes, he did. I wasn't going to name names, but I did recognize the voice.
That's 2 meetings in a row.
Mayor,
Yes,
can we do the same procedure? that we-
absolutely. I figured you'd want me to do the same, even if it was a break. Thank you. righty, we got 1 minute. Miss Heather, is everything working?
Yes.
Fantastic.
Can you test my volume, please?
You seem fine. Alrighty, Miss Heather, it's 2:21. I just want to make sure you're recording and everything's good to go.
Yes, we are.
Fantastic. At this point, we will go ahead and do roll call. And like the last break that we took, I need you to please disclose if you had any additional communications with anybody about the hearing that we're in, or any additional ex parte communication, just for the record. So we will start with Commissioner Hanks.
No, ma'am.
Thank you. And Commissioner Carasone.
No, ma'am.
And Commissioner Emmerich.
No, ma'am.
Commissioner Luke, Vice Mayor Luke.
I am here and actually had the city mail run, and there was one letter in it from a James and Alice Gilly standing in opposition. So I did read that letter. Thank you.
Thank you. So I am also present, and I don't think this counts as ex parte communication, but you all heard my absolute shock at 43 emails since 8:30 this morning. I did not read any of them, so I just wanted that to be disclosed. All right, so we do have our quorum. Let's make sure our charter officers are here. City Manager.
Yes, ma'am.
City Attorney.
Yes, ma'am.
And City Clerk. Obviously, I believe you're here, but for the record.
Yes, I'm here.
Thank you so much. Okay, so now we are going to move on to commission questions. If you have a specific question and you would like it directed to a specific person, please state that, and I will go ahead and take questions. If you would please raise your hand so I know who to call on. Vice Mayor. Please unmute yourself.
Yeah, I did. Thank you. I've got a couple. One of them is in regards to the buffering or the parkland. And I know staff spoke to that more today about being a park more than Boone has. Actually, I see Boone's presentation being a little more accurate when it comes to the zoning, because he did not add parks in as an approved usage, because park is not in the list of neighborhood commercial as an approved use. So I'm wondering what the staff, how they view this, or are we just to be viewing this extra 2.4 or 2.1, whatever it was, to be just simply buffer and it not being given to the city as a park? That's my first question.
So again, for the record, Nicole Galehouse, Planning Manager, and I have been sworn. So for today's hearing, I think it's important to consider this as being undeveloped buffer space, knowing that it has the potential to be a park or other improved facility, and that's what city staff would like it to be. There's a few different ways this can be achieved from a zoning perspective, and so we'd have to explore those when we finalize an agreement on how that would be done. One way is that if it remained under ownership from 7-Eleven, but was provided to the city via easement or some other agreement, it would be accessory to the fuel station, in which case the open space is permitted. Alternatively, the city could rezone it to government use and own it outright. So there's a few different ways we could go about accomplishing it. But for today's purposes, at the very least, we know, above anything else, the applicant has committed for it to be undeveloped space for the purpose of a buffer.
So a buffer, and if we ever looked at it being changed, there's a lot more would have to go on because that's not even an intended use into the zoning of neighborhood commercial, especially knowing neighborhood commercial is supposed to be bringing commercial, a light footprint that's definitely not the same as what our forefathers and mothers were trying to get. Another thing that was listed in there, and I did not see it, and I know we talked about neighborhood commercial, especially February 3rd, and one of those things that we wanted to get rid of was public art in neighborhood commercial, because right now, as it stands, there has to be. So was that ever discussed with the developer, public art?
I don't recall that being discussed. I'm not sure. Bear with me for 1 second.
Sure.
I apologize. My iPad is being very touchy right now.
Seems to be the common theme with technical difficulties.
There we go.
Or live mics.
Luke, just for the record, it's Jackson Boone here. We do not recall discussing public art with staff, and also staff statement about the conservation easement area is correct.
So the reason that we haven't discussed public art is it's not a requirement for the neighborhood commercial. And that's what I just wanted to pull up the code and double check. 59.4, the applicability is that it applies to new developments in all activity centers and all petitions filed as development master plans, subdivision construction plans, or major site development plans located within activity centers. So it doesn't apply to neighborhood commercial property.
There's another section, and I don't have it written right here, that it does talk to neighborhood neighborhood commercial, because we discussed that on February 3rd also, of removing that. Because personally, I was the one that brought it up. I didn't think it was fair that somebody in a neighborhood commercial would have to supply public art. And it may be under the public art code rather than.
I was in the public art code where I just read, what I just read to you was from the public art code. Let me see if I can.
Well, it's probably under the neighborhood development then. I just read it again last week. So it might be under at 153.
We're looking for it. I'm not sure that I'm familiar with a place that requires it.
There you go.
You got it?
Yeah, 53, 183.
Okay. Okay, yeah, you're right. It is. It's in 53, 183. As a part of pedestrian amenities.
Right, that was what it was listed under, the pedestrian amenities. So that was not discussed with them. Okay.
No, not at this point.
All right, Mayor, I'm going to cease with my initial questions right now. Thank you.
Okay. Does anybody else have any questions? Commissioner Hanks?
Yes, ma'am. Thank you. I would like if the Boones and also if Miss Gail House could both. My computer was breaking up a little bit. They both went into the special exception. They both went into, had to do with like by rights and what's prohibited, what's not, waivers. If both of them, because they were both breaking up halfway through it, and I'd just like to hear from both of them what they were saying, just so I can get fully.
Sure, Commissioner Hanks. What I had said, and this is Jeff Boone. Commissioner Hanks, what I had said is that first of all, just by way of credentials, in order for me to give my opinion, I've been practicing land use law in Florida since 1983. My law firm here, my dad, the law firm here, in fact, incorporated the city of Northport in 1959. I've done a good bit of my work over the years in the city of Northport. I've been qualified as an expert witness in the courts of the state of Florida to give expert opinion on land use and zoning matters, including cases involving the city of Northport. And therefore, I know that there is a great deal of understanding in the public about what special exceptions are. A lot of people think because of the term special exception, they're not things that are allowed, but it's exactly the opposite. Special exceptions are permitted uses in zoning districts that that you have to qualify for the criteria in order for that use to be allowed. So a special exception is a permitted use. It's just a use permitted by special exception, and that the only uses that are specifically excluded from any zoning district are the prohibited uses, and nothing we are asking for today are prohibited uses. And Commissioner Hanks, I also made a comment, similar comment without a whole lot of detail about waivers, and that is that waivers, they may have different names in other cities in this part of Florida and other counties in this part of Florida, but waivers that allow for specifics about development proposals that are permitted uses, waivers are something that every local government allows a property owner or an applicant to ask for. So again, there's nothing improper or illegal about waivers. No code can hit the target 100% of the time, and it's just the flexibility that allows for local governments to be able to make their decisions. Thank you.
Thank you. Ms. Gilhouse, can you go ahead and say what it was you said too, please?
Absolutely. So just from a basic zoning explanation, there's permitted uses in a zoning district, which are allowed by right. And then as Mr. Boone explained, there's, the special exceptions, which a lot of times get the perception that it's something that shouldn't be allowed. And that's not really the case. The consideration is that they can be allowed as long as they're especially regulated on a case-by-case basis. And so the special exception process gives us the ability to determine on a case-by-case basis what how the use is managed and make sure it's appropriately managed for that purpose. And so at some point in time, the commission that established this code determined that fuel pumps and a car wash would be permitted on a case-by-case basis if properly managed. And so that's what the point of today's hearings for the two special exception items is, to determine if the proposal by the applicants is properly managing those uses to be able to permit them. They are not prohibited uses. And then as it relates to the special privilege that was mentioned several times, I believe that that's referring to the waivers, and the waiver process is outlined in code. It is permitted by code. So something, for example, if the commission were to approve the 24/7, which, staff isn't recommending that, but if you were to approve it, it doesn't violate the Unified Land Development Code. That's something I've heard a few times, is that the waiver, the 24/7 operations would violate the Unified Land Development Code. And it does not, because the waiver process allows for that request to be made. And the waiver itself ensures compliance with the land development regulations.
Okay, thank you, Mayor. That's all I have right now. Thank you.
Thank you, Commissioner Hanks. Commissioner Emmerich? Just be sure and unmute yourself before you speak, Commissioner.
Can you hear me? Can you hear me okay?
Now I can, yes, sir.
Okay.
Yes, sir.
for Mr. Boone or Ms. Nicole as well. It has to deal with staff recommended fewer gas pumps. My question is, with the fewer gas pumps, if they were approved, would they still be using the same size storage tanks underneath the ground?
Mr. Emmerich, if that's an excellent question. If you'll give us a minute, we need to check with our experts on that. Give us just a second. Yes, Commissioner Emmerich, we've checked with our experts, and the answer is yes, it would be the same size tanks.
Okay, thank you. That's all I had. All my other questions were answered. Thank you very much.
Commissioner Carrasone?
Okay. First and foremost, I know that there was a picture that showed the gas pumps and how they were going to be actually presented. Do you have that PowerPoint picture by chance, Mr. Boone?
Yes, Commissioner Carrasone, give me 1 second, please. I'll pull it up.
And let's see here. And you, just for planning's sake, you guys, I heard that this was zoned commercial sometime in the 50s. And can you give me a date when the neighborhood commercial, light and heavy and all those lovely things came into play?
The neighborhood commercial zoning district was established in 2000. And that's when the property was changed from general commercial zoning to neighborhood commercial zoning.
Okay, you gotta say that again because you broke up.
Okay. So the neighborhood commercial zoning districts were established in 2003. And that's the point where the properties were changed from general commercial zoning to neighborhood commercial zoning.
Mm-hmm.
And hang on 1 second, Commissioner Carrasone. Hang on 1 second, Commissioner Carrasone. The picture that's up on the screen, is that included as part of the backup material? Because I didn't see this.
Yes, this is actually part of the application materials. This was in both the May 26 and this meeting today's backup material.
Okay. Thank you. Go ahead, Commissioner Carrasone. Sorry for the interruption. I just wanted to double check.
All good. And Nicole, did you say I thought you said another date?
I don't believe so.
Okay. All right.
Yeah, I'd have to look back and see like how far back they were originally zoned as commercial. I know it goes pretty far back. I think I found it back into like the 70s or 80s. So it was general commercial for quite a long time.
Yep. Okay. Thank you. I wanted to make sure. All right. Back to the Boone and Boone and Boone and Boone and Boone. Pork chop access. Oh, wait. The pumps. So we're looking at one of these stalls is actually for pumps. Can you clarify, please?
By stall, are you talking about the profile to the left?
Okay, so the profile to the right, is what you would see from the roadway, correct?
Yes, ma'am.
Okay, so that one line, which looks like there's a gas pump on each side, is that indicate 2 pumps or does that indicate 4 pumps because there's one behind it?
This indicates the 8 fueling stations, which equals 16 pumps. There is 1 pump on each side of the fueling station.
So
Okay.
there's not one behind it, Commissioner Kirasan. These represent the 16 pumps, the 8 fueling stations.
Correct. And the side to the east and west elevations to the left of this show what the side profile view would be.
Okay. And is there a reason why we didn't design the 2 pump idea, which is in many gas stations where there's one in the front, one in the back, and it's usually like 4 and 4?
By utilizing this longer rectangular shape, we can actually locate our building closer to the intersection corner and move it farther away from the adjacent residential lots to the north.
Ah, okay, that makes sense. Okay. All right. Next question. You talk about the access, the right in, right out. I have a huge problem with that. In fact, that's like one of my big issues. Has there been any development on that? Because I think that at the very least, the Cranberry Boulevard, there needs to be both a right and left turn in and out.
Yes, ma'am. It is my understanding, and our engineer can discuss this in further detail. It's my understanding that this pork chop channeling device was a staff-led device to be added to the plan. We indicated earlier in our presentation that should you all desire that pork chop channeling device to not be in that access, we would be amenable to removing it from the access itself.
Okay, so do we have a engineer to tell us whether it's whether we're able to remove this and allow a right and left in and out? I know we heard from the city engineer, which we may have to do that again, but I'd like to hear from your engineer as well.
Yes, ma'am. The civil engineer or the traffic engineer? Matthew Gillespie. Civil.
Whoever the ability to do that.
Okay. We'll have Matthew Gillespie, our civil engineer.
Thank you.
Matthew Gillespie have been sworn in, and as stated previously, you could have a left in. It is some restriping may have to be done of the turn lanes and stuff to accommodate for it, but it does occur in other places. But again, this was requested by the city for us to add, so it would require some modifications to the striping to accommodate it.
Okay, so there would have to be some modifications, but after those modifications were completed, do you see a safety issue?
No, based on the traffic volumes, does not appear to be problematic with the proposed left turns across Cranberry into the site.
Okay, and talking about traffic patterns, you looked at the current trips that this would not add any trips?
I'll let Mike Razor, who is the traffic study engineer, speak to the specific trip generations.
Am I on?
Yes, we can hear you. Please state your name.
Great. So this is Mike Razor again, and I have been sworn. So in regard to trip generation, we didn't indicate that there would be no new trips. We indicated that the majority of trips that would enter and exit the site to make use of the fueling and convenience portions would be already on the road network. They would be captured. So folks that are traveling on Cranberry, traveling on Price, popping in and out to grab the gas and convenience items at an average rate of 77%.
Okay. All right, so next question. Is it possible to add pumps later? Say that it was decreased to 4 pumps per se. Then 4 years down the road, you choose that you want to add another 4 pumps. And when I say 4 pumps, that would mean 8. And then 4 years later, another for? Like phase it in? Is that even possible?
Let us check with our experts on that. That's not a lawyer question. So give us a minute, please.
Okay. All right. Let me know when you do. Let's see, what else? You refueling trucks. We talked about the traffic of refueling. Is there a consistent time frame that they would be coming? Is there, I mean, is it just an as needed basis? Is it how does that work?
We're also going to need, I can partially respond to that, but we also going to need to check with our experts on that. That's sort of a similar question that was asked by, I believe, Commissioner Emmerich. And, you know, the larger tanks allow for more volume, which means fewer fueling trips in total. But to specifically answer your question, give us 1 second, because I think we have the answer to your previous question too.
Okay.
Commissioner Carrison, thank you for, and thank all of you commissioners for being patient here with us. These Zoom hearings can be a little challenging. The answer on the adding fuel pumps would be, it would not be possible without redeveloping the site. So I think the answer is that that's just not it's not something that practically could be done. The number of pumps, the number of pumps needs to be, whatever the number is, needs to be approved at once and developed at once. And quite likely staff might even say we'd have to go back through some sort of special exception process all over again. We don't know that, but that's likely. As far as the delivery hours would vary based on deliveries to other gas stations in the same delivery area, which we believe would be larger than just the gas stations in the city of Northport. So theoretically, they could occur at any time during the day.
Okay. All right. Now,
Commissioner Carrison, let me just add this. It's not the same. I know why you're asking the question. It's not the same situation where if you have just a general commercial center that has a variety of different types of commercial businesses, where they tend to get their deliveries, you know, early in the morning, 6 o'clock in the morning, 7 o'clock in the morning, that kind of thing. It can be spread out during the day if we're talking about a gas station.
Yeah, I'm more worried about the traffic with large trucks going down the roadway, because I guess that we could always make sure that there was a no through truck on Cranberry at certain times because of the kids in the school zone, you know. But that's my concern, where I was going with that.
Commissioner Carrison, let me, because I think these are really good questions you're asking here. You know, the city would be in a position to set delivery hours. I don't think you could actually say it has to be at a specific time every day, but you would be in a position to be able to set reasonable parameters on when deliveries could be made. And something to think about because, all four corners of this intersection are zoned for commercial use. And there are going to be large trucks coming to this intersection for deliveries because there's all sorts of different commercial uses that could be, we made that mention on our alternative development plan. There could be large delivery trucks literally right in these folks' backyard on a normal, typical commercial center.
I believe we did that in a previous neighborhood commercial, but I'll have to think about what those, I would add it as a part of the exception, I would think, not something, a condition of some sort. Okay, so anyways, back to, I think I have one more, where is it that you plan on putting the dumpster?
Let's let our civil engineer, Mr. Gillespie, answer that.
Ms. Gerson, Matthew Gillespie again. The dumpster is the northwest corner behind the car wash. If you look on the screen, there's a rectangular box with a couple of doors next to the stormwater pond. It has a leader pointing that says dumpster enclosure. It'd be up to the left. If you look at the car wash, it'd be behind it.
Right, I see it. Okay. Okay. I'm trying to determine, well, you have the retention pond directly north of that. And then there looks like about 10 feet until you reach that next roadway. Is that true?
I think, are you referring to the sidewalk going around the pond?
Oh, see, I see yours is a lot bigger. I was looking at, hold on, I gotta change maps. There we go. Okay, retention pond. So you're talking about, I'm trying to figure out the distance between the dumpster and the car wash to property boundaries. That's what I'm trying to figure out. 30, 40, 50. It looks like at least 60 to 70 feet, correct? Would that be a good assumption?
From the dumpster to the car wash itself?
Nope. From, say, the dumpster to a property boundary.
Oh, okay. It's way more than 60 feet. It's 217 feet or so to the corner of the car wash to the property line. So it's, I don't have it right in front of me, but it's at least 150 feet from the property line to the dumpster.
Okay.
It's a significant amount. It's not, the pond itself is about 80 feet wide for just the pond.
All right. Is there a route, you don't have a delivery route kind of indicated on your maps, like where your deliveries will be entering and exiting? I guess it all depends on how that right left turn thing goes, huh?
Yes, ma'am. Yeah, it does depend on that. And we had discussed previously about, certain roadways being restricted uses. The last we talked about basically using Cranberry, but only traveling to the intersection, not traveling northbound on Cranberry for the deliveries. But that will depend on what, if the pork chop island exists there or not.
Correct. Okay. All right. I think you don't have a proposed, oh, did you include it in the backup? The proposed picture of your sign to be presented?
Yeah, Jackson, can you pull that up?
That's the monument sign.
Yeah.
Mr. Carasone.
Mm-hmm.
Okay, let me believe I have it in one of these here.
There you go.
This is the monument sign. Yes, ma'am.
Mm-hmm. And since this is not an activity center, there are no color schemes, correct, staff?
So for, even though it's not in an activity center, it is supposed to match the nearest activity center or be Mediterranean, I think. There's a couple options. When it's a neighborhood commercial, however, the gas station signage is pretty much exempted out from our regulation because of Florida statutes.
So if we were to see if the applicant would proffer meeting the nearest activity centers, what would you call it? Their
design standards?
Yeah, I just had a brain fart. Design standards, then we would be okay, even though the state statute doesn't allow it. Is that correct?
If they offer to do it, I believe so.
Okay.
We can't regulate it.
Right.
Commissioner Carasone, our client obviously is listening. He's indicated to us that they would be agreeable to offer what you had just discussed, provided that, and this is I think understandable and very typical for everybody, as long as their client colors, in other words, the color of the gas station operator, because that's part of their brand and their trademark,
right?
That would be allowed. But otherwise, they would be willing. They would offer to meet the design standards of the nearest activity center.
Okay, thank you. Next is the conservation land, the or park, however we want to talk about it. This conservation / possible park that would be donated back to the city at the city's cost. How would that work?
At this time, we are proposing this to just be a portion of property that has a conservation easement over it. We believe it's clear based upon the meeting we had with you all on May 26th that there's not a desire for it to be a park area. So we again are open to meet your desire for that area. However, we believe right now it'll be a conservation easement area.
Okay, excellent. Geez, I had one more and now I can't even remember what it was. Oh, sidewalks. The sidewalks there, while I know they're there, will you be making sure they're, because I would assume during building, you're going to be tearing some sidewalks up. You'll be replacing them and fixing them. And let me just explain where I'm going with this, because those sidewalks, as you know, Mr. Boone, back in the day, were kind of put in there almost like a temporary measure. So they need to be lifted due to the flooding in the area. And I'm just wondering if the sidewalks along the property edge of that corner will be lifted as part of this construction.
Yes, ma'am. It's Matthew Gillespie. Again, the some of these sidewalks are being replaced with the Price Boulevard widening plans as well. So on the south side, the sidewalk is being modified with those construction documents. And on the on Price, on Cranberry, we are showing tying into the existing sidewalk, but if it does not meet ADA, they will be, they can be upgraded and corrected. Right now, we are showing cutting in and matching up to the existing sidewalk on the east, on the Cranberry side. And again, the Price Boulevard sidewalks are proposed to match the Price Boulevard widening improvement plans.
Okay, I'm just concerned that they're just going to be placed exactly like they are today when that's not the appropriate
No, right. No, ma'am. Everything will be ADA compliant per Florida statutes and per 711's design standards. Everything will be ADA.
I'm not worried about the ADA because that's usually just smoothness and the width. I'm more concerned about the standing water and flooding that occurs along that sidewalk. You see what I'm saying? It's going to need to be raised in order for that to be prevented.
Yeah. The final engineering and stuff will be done post the DMP process. So those items, if there is flooding concerns, will be discussed and worked with Elizabeth Wong with the city during the permitting process of the final full construction documents.
Excellent. Okay. All right. Lighting. You talked about the lighting. And I know that when we did lighting for the ball field or for something, I think it was the ball fields, we thought that we were in the appropriate luminant that was going to not affect nearby residents. And it was actually quite a distance, probably very similar to what you're proposing. Do you have shields on your lights? Is that how you'll prevent them from being, reflecting into neighborhoods? What exactly, beyond the luminant amounts, what other precautions will you be taking to make sure that they don't, shine where they shouldn't?
Commissioner Carazone, we will let Matthew Gillespie speak to that. If you will give us 1 second, we will pull up the professional lighting plan that was submitted with our applications.
Yes, Matthew Gillespie here again. The lighting plans that are prepared are done per the city lighting standards, and with the equipment, the specific devices. The old devices used to have what they called baffles. Now with the newer innovative technology, they have directional lighting with the prisms and everything. So they shine directly downward. The way the internal housing is actually made now, it prohibits backlight basically from going backwards behind the light fixture. So it does have, with the newer advanced technologies, still accomplishing the same directional lighting controls. You just don't see like a metal shield hanging down that used to be there with the old metal highlight light fixtures.
Okay. And is this and I guess this would be for staff, is this the same type of lighting that's over across the street?
I would have to pull those plans. It would.
Yeah, that's all right. I'm just curious because I don't know how new this is, the LED area light, Okay. All right.
But it is designed to minimize light spillage per the city standards.
Right. And is there a way that you can reduce the brightness by timing? Is there a way to, so for instance, like they do on 41, you have 8 lights, you reduce it to 4, so that it's not so bright. Is there a way to reduce it that, say, after 11 p.m., the lights go to 0.5% or 60%?
Let me check with the 7-Eleven client first, because that's not something I'm familiar with. Hold on 1 second.
But listen, if it doesn't exist and someone actually goes and creates something like that, I do own rights to that idea. Just going to throw that out.
We would need to investigate further with the lighting vendor to see, what, based on 7-Eleven standards and lighting equipment that they use, we would have to investigate to see if that would be something that they would be able to be function with.
I just think it would be really great for any of these neighborhood commercial areas, but
Commissioner Carazone, this is Jeff Boone. Just, as I know, but just to make sure everybody who's following along here understands, And approval today does not mean, ground gets broken tomorrow. And there are still site planning issues that have to be approved by the city. So the issues that you've just been discussing about lighting would be something that would be worked out between the developer and staff as the plans are reviewed and approved before anything can be built.
I understand, Mr. Boone. It's just really good to get it out there so staff has it in their head. And then we talked about the pond, the retention pond. This retention pond is not going to be part of that property that would then become a conservation donated conservation overlay, correct? Or would it?
No, ma'am. The direction we're proceeding with now, the line that was there on this DMP plan that shows going through the pond would be removed, and the exact limits of the conservation easement would be determined at the final engineering design. But basically, it would be on the back side of the sidewalk area that you see, just in general planning efforts at this time.
Okay. I think the height of the building is, comparable to a home. Is it the same size? Is it a little shorter?
It's about 17 feet and as brought in the staff's presentation as well. So it's similar in keeping to residential homes for 2-story houses.
Mm-hmm. Okay.
Permitted height in the zoning district is 35 feet, so it's well below the permitted maximum height.
Correct. A 2-story home, residential home with a roof, you'd be looking at 10-foot first floor, 9-foot second floor, 19, another 8 feet of height. So you'd be looking mid-20s for even a 2-story single family home.
Okay. And again, the roadways would not be essentially impacted because hopefully the left and right, the left and rights combined would help with that. Question, the potable water, you would be on septic?
No, ma'am. This would be sanitary sewer system. We're proposing a lift station at the northeast corner of the building behind the curb line at the corner of the pond, and potable water is provided along Cranberry. So we'll be on potable water, and sanitary sewer service is actually being done on the south side of Price Boulevard is where the closest sewer main is. So we would be going under Price to make the connection.
So staff, can I ask you a question that and this might be someone in water, if that corner is going to connect under the roadway and why aren't we running a line so that it can also allow an expansion of the neighborhood?
So we do have Daryl Smith on the line if we want to ask questions about utilities. If we make him a panelist. And what's his name again, Nicole? Daryl Smith? Daryl Smith. Okay.
Do you want me to restate the question?
Can I interrupt a second? The mayor has a problem with her computer, just like Commissioner Hanks had earlier. So can we freeze this, stop this right now and give her 5 minutes to get her computer running again? She has IT with her.
Oh, okay.
I think we have to.
Yeah. City Attorney, is that all right to wait 5 minutes for her to get her computer going again?
Yes, ma'am. In fact, it'd be preferable. We need all decision makers to attend the entire hearing.
Okay, she has IT with her, and we'll
I
wait
move,
we'll
I
wait
move recess the meeting for 10 minutes.
Okay, I'll second that. Commissioner Hanks, are you okay taking a break for 10 minutes while we bring her back up? And Commissioner Amrich?
Yes, ma'am.
All right, we'll have a 10-minute break. We'll come back again at 3:20. I apologize.
Thank you.
And then just like kind of test it.
Okay, so.
I'll jump on so you can test.
Okay, thank you.
And actually, I think we need to check if the sound is.
Okay, I see you.
Okay, can you hear me okay?
Oh, wow, loud and clear.
Okay. So we need to, how'd you lower the sound?
Oh, she might have to lower her sound.
No, I don't know. Because
she's hearing low.
Are you here? Am I like loud?
No, you're fine. You're
Okay.
fine. It's just
Thank
louder
you.
than normal right now. You're fine.
All righty. And it's been determined that the reason I was having technical difficulties is I was using city Wi-Fi. And there's a lot more people using Wi-Fi right now in the building. And that's why I was having problems that I've never had before. So thank you guys. I'm back. What time did you recess, Vice Mayor?
We're recessed until 20 after. We recessed at 3:10 for 10 minutes, so 3:20.
Okay, so 3:20. Thank you. Thank
Yes,
you.
ma'am.
I appreciate it. I
I
think
want
you're
to
all
walk
set.
away slowly.
Just walk away really slow.
I'll stay with you at
Okay.
least until it starts back.
Sounds good. And
Okay. Is there any way for me to test this one? Like this one while let me get just okay. Okay.
that's mine.
Okay.
We're set up. I'll just do it this way. It's
Okay.
a little less, it's a little more difficult for me, but I'll get through it.
Okay.
Thank you.
You too.
All righty, Miss Heather, can you hear me?
Yes, I can.
Fantastic. And sounds okay from your end?
Yes.
So it's, we have like less than a minute. Sorry about that.
Who had the technical?
righty, it's 3:20 and City Clerk, are we ready to go ahead and resume?
Yes, we are.
Fantastic. Okay, and we will go ahead and do the roll call and also disclose if you've had any ex parte communication or talked with anybody regarding this during that technical difficulty break. So we'll start with Vice Mayor.
I'm here and there's no more ex parte.
Thank you. Commissioner Hanks.
No, ma'am, nothing.
Thank you. Commissioner Karras.
Nope.
Commissioner Emmerich.
I'm here and no.
Fantastic. And myself either. I didn't discuss anything with anyone. I was too busy trying to get my technical difficulties resolved. So we do have all of the commissioners present and accounted for. So let's make sure we have our charter officers. City Clerk.
I'm here.
City Attorney.
Present.
Thank you. And City Manager.
I'm here.
Fantastic. Folks, I'm sorry, I don't have the benefit of knowing what y'all were talking about probably the last 3 to 5 minutes of the conversation. If maybe Vice Mayor or some City Attorney or somebody could give me a quick little summary so we don't have to go over it, I would be grateful.
Commissioner Carazone still had the floor and she was asking questions based mainly toward Mr. Boone. So I believe Commissioner Carazone can catch you up.
Thank you very much for that, Vice Mayor. Commissioner Carazone, please.
Glad you think I can. Maybe the city clerk has notes that she could refer to. I know it had to do with traffic count.
I didn't hear anything about that.
I apologize, but due to the way we're doing the meetings, I'm not doing the minutes. That's Ida. She's all the way over on her desk, which doesn't have audio.
So
okay,
if I
trucks and we talked about setting hours for that. Did you hear that?
I heard something about possibly having a condition when deliveries are made, and that point is when I started having problems with the computer.
So then you didn't miss much. Then they did talk about the conservation land or the land being donated, that it would have a conservative easement, and that it wasn't donated. It would just have a conservative easement. We did talk about the sidewalks and that they would, meet the requirements of the price sidewalks and then build the sidewalks on the Cranberry side as appropriate to the current standards and ADA. Let's see here. We were in the process of talking about my question for expansion of utilities. That's what it was. They were talking about the water connections and that they were going to connect to the city water and sewer, and that then my question was to staff whether were we going to utilize this to expand utilities in the neighborhood, essentially. But Mr. Boone, can you think of anything that I missed?
Yes, yes, ma'am, Ms. Carazone, you did an excellent job of remembering. My notes indicate that, and Mayor McDowell, if you heard this, just stop me. But our client agreed that they would have the gas signage be even though there's no outright requirement, they offered to make it consistent with the design standards for the nearest activity center, provided that they could retain the client colors, their brand, their trademark. They also, we had a discussion about lighting and how the lighting would be directed downward, and that there's a design, modern design lighting standards prevent it from spilling over. But the bottom line there was that if the applications today are approved, there will not be construction starting tomorrow. There'll have to be a plans review and approval process with the city, and the lighting, the spillover and no spillover issues, et cetera, would be worked out with city staff as part of the plans review process. And then the last thing that I have is that the height of the building we're proposing would be 17 feet. And that's well under the maximum height allowed in the zoning district, which Jackson is
35 feet.
35 feet. And it would be that's perhaps a couple feet or so taller than a single family home, but less in height than a two-story single family home. And I think those are the only things that Commissioner Carasone did not mention.
Thank you very much. City Attorney, during that discussion, I saw you had your hand up. Did you want to weigh in on anything?
Ma'am, I think they covered it. I just would encourage any commissioner, if you get tossed offline or can't hear for any reason, to notify the clerk immediately so that we can kind of put a stop to things and know where we are.
Yeah, I let her know I was having problems, but it happened kind of quickly. So thank you. Thank you, Vice Mayor, for filling in. And Commissioner Carasone, I understand it's still your floor, so please go ahead and continue. And I do apologize for the delay.
The clerk was bringing Daryl Smith in to answer Commissioner Carazone's questions in regards to utility. Just that's where I then interrupted the meeting.
Thank you very much. All right, so we're back to utilities.
That's it. We're waiting on the answer.
Oh, okay.
I'm here. This is Daryl Smith. I haven't been sworn yet.
City Clerk, could you please swear in Mr. Smith?
Sure can. 1 second. Can you please raise your right hand? Do you swear or affirm that the testimony you're about to provide is true and accurate to the best of your knowledge, so help you God?
Yes. Vanessa, I think your question was, were we looking at the developer to extend water and sewer lines for future expansion?
Well, not really. I was wondering if their connection would allow the sewer lines and the water lines to be brought to that development and then allow for a little bit easier connection for the neighborhood. I mean, I help, if anything.
Yeah.
Is that
right now we have a water main on Cranberry and on Price, and the one on Price is actually going to get completely replaced with the Price widening. As far as sewer goes, we tried working with the 4 quadrants of Cranberry and Price back when Dollar General was built in 2014 to get them all together to put a master lift station in so we could expand out into the neighborhoods. And of course that didn't work out so well. So they're right now, they're going to put in exactly what the Dollar General put in, which is basically a private lift station that they will operate and maintain, because to put a lift station there for that northwest quadrant, it wouldn't work for the neighborhood. We'd have to go out in the middle of that neighborhood for it to work for the whole quadrant.
So now they pay, they pay water and sewer they pay water capacity fees. They don't pay an impact fee, do they?
They'll pay both water and sewer capacity fees, and then they will install their own lift station.
And then they'll get a refund on those fees for the lift station or not?
No, that lift station will be a private lift station that'll only serve that site. It's the way those quadrants are set up. It's very hard to expand anywhere out of that area.
I'm just wondering if the capacity fees could go to be utilized to create that one master station like you were talking about, that would then help to expand the water and sewer for the neighborhoods. That's kind of where my thought process was.
And I'm sure that's what would happen with those capacity fees, you know as well as I do. The capacity fees goes towards actually the plant capacity. You know, when they pay their sewer capacity fees, that goes towards improving the water plant and wastewater plant.
Right, but they can also be used for infrastructure, correct?
I believe so. That would be more a question of for Jen DeRozier, but I believe they can be used. So, and yes, in a way, when they pay for the capacity fees, they can be used for a lift station at a later date for that south or northwest quadrant.
Okay, I was just making sure that this wasn't going to impede the expansion of the water and sewer in that area, and essentially maybe even help it. That's where I was going with that.
No problem.
Okay, I promise I only have like 2 questions left, guys. let's see here. I need to ask about kind of safety. We talked about there being safety measures for leakages and air for gas pumps. But what about runoff for the car wash? Do we have anything that will be in place that prevents the car wash runoff going into the neighborhood? What is it that's going to be put in place that would prevent an effect of the surrounding area?
Yes, ma'am. This is Matthew Gillespie again. The car wash has a recycling system. Everything that is graded for as the surface drainage around the car wash drains away from the car wash, being that as a car enters and the wash cycles go on, everything during the wash cycle is captured and it's sent to a recycle reuse system. And then there is an overflow. Basically, about 85% of the wash water is recycled water. There's about a 15% makeup water that is fresh water being brought in from our water main. The overflow is the water gets too dirty and can't be reused, which is part of the recycle system. It overflows and goes to the sewer system. It does not go to the stormwater system. So there'll be no contamination for any, car wash runoff water that would go into the storm water piping system. Everything would go to the wastewater system.
Okay. And then my last question is for staff. The noise ordinance allows construction to start at a certain time. I think it was like 7 a.m.
Yes, 7 a.m.
7 a.m. to what time? Do we have that?
I believe it's 10 p.m. I deal more with it starting earlier than it going later. I can pull it up for you. Hold on just 1 second. It is 9 p.m. and 7 a.m. to 9 p.m. On weekdays and 7:30 to 9 p.m. on weekends or holidays, and within 50 yards of any residential or noise-sensitive area.
And what code is that, by the way?
That is section 4642 of the administrative code.
42 admin code. Okay. All righty. All right. Thank you very much. And I know you guys are happy to hear that I'm done.
Thank you, Commissioner Carasone. Seeing that everybody had their first round of questions, I'll go ahead and just get taken care of. I'm going to start with the things that I believe it was the applicant who had mentioned about the appraisals and various developments that have similar undertakings as this development. And they gave the 5 examples. Holiday Park, Dollar General, Watercress, which is in Venice, the property behind Lowe's across the canal, and then something about Laurel Hollow in Nokomis. So I have to ask, do any of these examples presented, are they open 24 hours a day?
Hello.
Hello.
Yes.
Could you please state your name?
Hi, this is Bobby Fletcher, the appraiser. I have been sworn.
Thank you.
With regards to most of those examples, I do not know if they've been, I don't know if they have 24-hour operations.
Okay.
I suspect most of the examples do not, since examples 1, 2, 3, and 4 are all highway fronting commercial with sort of general purpose retail, typically not open 24 hours in any event. Number 5, the Hess station along Laurel or adjacent to the Laurel Hollow neighborhood. I suspect they are open 24 hours, but I do not know that for a fact.
Thank you very much. So my next question has to do with
Commissioner McDowell, just we can confirm that the Hess station is open 24/7.
Okay, so Hess is the only one that's open 24/7. The other not. They don't have any.
No, ma'am. The only one we know for sure at this time, therefore that we can confirm.
So he also, my other question regarding those same properties that he referenced is, I know Holiday Park has a buffer wall between the properties and the residential. I know that Dollar General has a buffer wall. I know that Watercress has a buffer wall, but it might be like a berm. There's a separation. Lowe's has, does anybody know how much space is between Lowe's property, then the easement driveway, then the canal, then the easement to those properties? Does anybody know how big of a span that is, especially that huge canal that separates them? And then the 2 buffer areas on either side?
Well, I do know that the canal right-of-way is roughly 150 feet from property line to property line. That's inclusive of the water and the adjacent growth. So it's probably approximately 250 feet from the back of the building for Lowe's to the back of the building of the homes.
Thank you.
That seems to be the measure, just to make it try and make it an apples to apples comparison with what's proposed here.
Ms. Nicole,
I was going to say pretty much the same thing. From the back of the building to the edge of the property line of the single family homes, it's about 210 feet. And if you go to the back of the home, it's about 260, 270 for a rough estimate. So
thank you. Appreciate that. It's very difficult to use those 5 examples comparing apples to what is actually here, but I do appreciate the conversation and thank you very much. Moving on to my next one. The gentleman that spoke, Mr. Boone, to your traffic study, I thought I heard him say that the traffic study that was conducted was based on 4 lanes of price widening. And I just want to make sure, because Price Boulevard is being widened to 5 lanes, and does that change the traffic study that was conducted?
Let's ask our expert traffic engineer who performed the study to answer that question.
Appreciate that.
For the record, again, Michael Razor, and I have been sworn. My statement regarding a 4-lane section was a general statement. The plans that I've seen in this vicinity show a 4-lane road with a divided median. There are portions that are a 5-lane road with a 2-way left turn lane within the middle, but those are the same plans that the study was based on.
So having it a 5-lane with a center dual turn lane does not change the study in any way?
Adjacent to this particular site, it's technically a 4-lane road with a divided median and turn lanes. A 5-lane cross section is one where you have 2 travel lanes in each direction and a center bi-directional lane, which is present west of this, I believe it's Visconti, the street immediately, the local street to our west. Between that street and the intersection at Cranberry, there's 2 lanes in each direction, and there's an eastbound to northbound left turn lane approaching Cranberry with a physical divided median.
Okay. Now I think I understand what the discrepancy is. So your traffic study did not take into account the widening of Price Boulevard.
Oh, it does, and it's in our report, and I can show you on my computer here, just to give you an illustrative example. Actually, it's Waconia Street.
Waconia.
These plans right here. You'll notice that from Waconia over to Cranberry, there are 2 lanes eastbound. There are 2 lanes westbound, and there's a left turn lane that begins in the vicinity of Waconia and commences all the way to Cranberry. So technically, it's a 4-lane road with a divided median and turn lane, and that's why I've made that statement.
Okay.
To west of Waconia, it's a 5-lane cross section with a bidirectional turn lane within the center.
Got it now. Thank you. It's crystal clear now. I'm glad we just got that cleared up. I appreciate it.
Glad to help.
So now going on to the to Exhibit D, which is the economic development fiscal impact. And it was stated that over 30 years, there would be over roughly $2 million, in excess of $2 million revenue benefit. Is that $2 million, is that based on the entire 4.2 acres, or is that based on the 1.9 acres of the commercial development being proposed?
That is based on the entirety of the site, with the 2.24 being parkland and the remainder being commercial.
Okay, so
Commissioner McDowell, as you likely are aware, an additional fiscal impact analysis was conducted without including that area as a park. And we had discussed this in the May 26th meeting. The additional fiscal impact analysis that was performed actually showed a greater surplus to the city in the 5-year and after the 30-year period. So again, the additional fiscal impact analysis conducted by city staff without the park showed a greater net surplus to the city after 5 years, as well as a 30-year period.
okay, so what is that financial impact if all 4.2 acres was developed as commercial property?
That analysis has not been conducted.
I'm sorry?
That analysis has not been conducted. We don't, when a petition like this comes forward, we don't evaluate different scenarios. We evaluate the scenario that's being presented.
Thank you for that. So I appreciate that clarity that a fiscal analysis was not conducted as if all 4.2 acres was developed. So thank you for that. Somebody had mentioned, don't know who it was. I need clarity on this. Something about park impact fees are being used for what? Because commercial development does not pay park impact fees.
So it has been discussed and not been decided at this point. But if a park were to be constructed by the developer, there has been talk of it being funded out of park impact fees. It's not a reimbursement of fees that they pay, but reimbursement of the costs of constructing a park. And again, that's down the road. It would be pursuant to another agreement. That possibility is there if we are going to try to construct a passive park there, for those costs to be funded from park impact fees.
Thank you. All right, so moving on to my other questions outside of what was discussed right here in preparing for this meeting. In the resolution 2020 R-11, in the last whereas clause on page 1, it is not accurately reflect what PZAB had voted on to approve. And I think that that is important to make sure that there's a distinction as to what PZAB did vote on that specific special exception, which was voted 5-1 to approve 14 fuel pumps. And I just wanted to check with city attorney to see if that can be corrected to properly reflect what the recommendation was of our land planning or.
Yes, ma'am, that absolutely can be part of the commission's motion if there is a motion to approve the resolution.
Okay. Thank you for that. I already talked about the fiscal analysis. So help me understand this conservation, because this is when I didn't hear this. So I think there's some clarity that needs to be brought forward. If this is going to be a conservation easement, so currently the applicant owns all 4.2 acres. The development is only going to take 1.9 acres. Who would own the other 2.2 acres if there's a conservation easement?
The property owner, the applicant, would retain ownership of that area. However, it would have a conservation easement placed over it and would not be eligible for development in the future.
Would that be into perpetuity?
Yeah. Mayor, this is Jeff Boone. Yes, ma'am. That's in perpetuity. Basically, what that conservation easement would do would be to remove all development rights from the over half of the property.
All right. So since this is new, it changes the development basically, because now I don't know what the fiscal impact is going to be. Do you pay commercial taxes on that conservation easement? You know, the rate of commercial property, is it reduced? Could somebody help me understand what that impact could have, being it's a conservation easement?
So I believe.
First of all, go ahead, Nicole. I'm sorry.
I was going to say, I believe when the fiscal impact is conducted, and I was going to try to pull up my spreadsheet to confirm this, I believe the parks category that we used for the analysis, property values for the site. I believe the conservation easement might actually increase that slightly because I don't think it takes the full value of the property away, but it's usually like, I want to say maybe 90% that it's reduced. It doesn't reduce the full property value from there. So it would likely increase the net.
And Mayor McDowell, what I was going to, this is Jeff Boone, what I was going to add to that, first of all, Nicole said what I was going to say. Secondly, if you look at the overall fiscal impact, if you consider that the property values of the homes along the two streets that back up to what would be in essence an over 250-foot buffer, or not quite, I'm sorry, over 200-foot buffer, as opposed to other types of commercial development, which would perhaps have a 30-foot buffer, which is what the code requires. That's the code minimum. Probably you would have, those lots would have increased value going forward in the future, and that would generate more taxes for the city. So it's you know, that's what's tricky about these kind of analysis. You know, it's oftentimes not just the property itself, but the impact on the property around it.
Thank you. So let's look at if somebody could share the screen that has the picture of the site plan. I got a question, and it probably would be best if we brought it up so that everybody could see it. So if you look at the drive entrance down on Price Boulevard, obviously you're not going to have any type of buffer between the property line of the incompatible residential and this driveway. What protections are being put in place for that? And I'm guessing maybe 40 or 50 feet from south to north, so that those property owners are not seeing all of the traffic coming in and out, and those headlights at nighttime shade going into their home. What protections are in place? Because this would require a buffer wall up to that point, up to that property line.
Ma'am, it's Matthew Gillespie. The driveway location off of Price was set at the location per the request of the city staff. Right now, we just have as most woods as we can preserve is in the plan that we can physically do. The driveway being where it is and the close proximity is as far as to the west as we could build it, or as far as east as we could build it per C's request. We would agree, however, to a limited wall to like prevent headlights from cars, driving in the driveways. So that would be something that we could agree to by the applicant.
Well, that wall would have to also include the 30-foot buffer, easement, 20-foot landscape buffer, and the wall, which then brings you right smack into your driveway.
No, ma'am. We have the driveway is basically about 50 feet from the property line, is as close as it gets. The straight section is 56 feet. The closest at the very narrowest spot, like right at the property line, is 45 feet. And we would gladly move the driveway further to the east if we are allowed to help accommodate whatever the city would recommend.
Mayor McDowell, this is Jeff Boone. I want to apologize. I obviously confused you when I mentioned the 30-foot buffer. I was referring to a normal commercial type development that would occur on this property, instead of a gas station where you would have the driveways and the buildings would be 30 feet. In other words, closer than this to the properties that back up to the site there. I apologize if I confused you there. I didn't mean to.
Sorry, we have a responsibility to make sure that property owner, whoever it may be, is protected from this development, because the way I'm seeing it right now, there is absolutely zero. And I just had to get that out on the record. Thank you.
Yes, ma'am.
So neighborhood commercial does not allow for any outside storage. And I know from using 7-Eleven gas stations and all the gas stations around town, there are propane tanks that are stored outside, because obviously you can't bring a propane tank inside of a building. I am wondering if they are going to be sold at this location, given the code that does not allow any outside storage.
Commissioner McDowell, is that overnight outside storage or outside storage period that you're referring to?
Ms. Nicole?
So the Unified Land Development Code allows for propane tanks as an accessory use to the fuel, and allows for these to be outdoors as it is unsafe for these to be stored indoors. So if they were proposing the sale of these, they could have them.
And where is that in the code, ma'am?
It's in section 53-239.BB section 8.
Did you say B like Baker, B like Baker?
Mm-hmm.
Oh, thank you. Thank you. I appreciate that.
Commissioner McDowell, that would obviously, we didn't mention that, but since you brought it up, that's obviously another advantage to having a gas station in this location instead of a mile and a half away. As everybody recognizes, transporting propane tanks in people's vehicles can be dangerous if there's an accident. And here that means there's much less travel time on the road for anyone who would pick up a propane tank at this location to transport to their home in the neighborhood. So we believe that's a positive for safety.
So since there is not going to be a wall being built around this for buffering, could you give me, or staff give me, an idea of how much vegetative buffer is going to be remaining in place? I know you have to clear for your pond. I know you have to clear for that, God help us if we put a sidewalk there, and then be able to access the pond for maintenance. So how much are we actually talking about for buffering that is going to remain, not replanted, but remain for the vegetative buffering?
Ma'am, it's Matthew Gillespie again. The approximately right now, it's about that the narrowest about 50 feet, but the final design has to be agreed upon by city staff and Elizabeth Wong. So right now we have the narrowest, the full vegetated is 50 feet, but it could get a little more than that. It's the final parameters, with originally in the DMP, the sidewalk was added around, so that takes up some space. If that sidewalk were to be removed, there could be additional buffer space added there as well. So the final dimension has yet to be determined, which will be normally determined at the design MAS stage of the project.
Thank you.
And if the city would not desire the sidewalk in that location, that could be removed as well.
Yes, ma'am.
Thank you. So seeing that this development that was presented to us started this morning with having a pond that overlapped possible deeded property for this buffer area, and is now morphed into where the applicant will take complete ownership of all 4.2, turning over 2.2 to conservation. How does that look for the, I'm sorry, I wasn't prepared for them to, I just want to make sure that if this is going to be turned over as conservation easement, they're still maintaining that pond.
Before Mayor McDowell, before Mr. Gillespie responds to that, I just want to point out that nothing has morphed today. Remember, it was determined at the beginning of the meeting that what happened, we're starting all over again. And despite my objection, it was determined that we're starting all over again today. So anything about the park or the conservation easement or the sidewalk or the pond at the last meeting was what happened at the last meeting. We started off today with the proposal being, we understand the city is not interested in a park, and we are going to place a conservation easement over the area that's going to remain undeveloped. So nothing has morphed at all during from when we started at 9 o'clock or after we finished with the technical difficulties at the beginning of the meeting. Nothing has morphed since then. And I'll let Mr. Gillespie respond to the other part of your question.
And regarding the conservation and the stormwater maintenance and everything, that would be maintained by 7-Eleven. So any concerns of any fuel spillage or anything like that, that's all going to be under 7-Eleven's maintenance now. So there will be no special agreement or anything for the city for the shared maintenance costs.
Thank you. So speaking of those gas spills, because I understand that while there's a lot of guidelines for fuel delivery and special precautions for fuel delivery, we all know that people like to make sure they get every last drop of gas in their pump and get it to the nearest dollar, which then creates overspills that goes down their car onto their feet and then onto the concrete. And then when it rains, it gets washed into the stormwater pond. So I know that it was touched upon during somebody's presentation. I think it was Mr. Boone's, maybe it was staff's, on what protections are in place to protect the well water aquifers from these chemical spills prior to them getting into the stormwater pond.
Yes, ma'am. It's Matthew Gillespie again. It was my my statements in discussions with city staff, Elizabeth Long, and hearing concerns. We're investigating adding a perimeter trench drain system around the fuel tanks and the fuel canopy, which will then collect any fuel spillage at the surface and be routed to a oil water containment device, which would basically trap and separate any oil or hydrocarbons from the stormwater. And then that device is routinely cleaned out, just the same as you have like a grease trap for restaurants or a oil water separator for the car wash has one as well, the same components there. So we're also doing the secondary recovery that I'd mentioned earlier, as far as the vapor in the actual pump handles themselves. So to try to help recover that off-gassing when the vehicles are being refueled themselves.
Thank you, Mr. Gillespie.
Mayor McDowell, if I, this is Jeff Boone, if I could just add to that, I remember when Elizabeth Wong, in fact, I think I was at the very first meeting she had with the developer in the city of Northport. And one thing I think everybody can agree about Elizabeth is she is very thorough and detailed. And obviously, whatever gets worked out here is going to have to, she's going to have to sign off on it in order for any development of this property to move forward.
Commissioner McDowell?
Yes.
Can you hear me? This is Elizabeth Wong.
Miss Elizabeth, were you sworn?
Yes, I swore silently. I was muted out, but I did swear. Swear initially. I just want to put some clarification and perhaps ease your concerns a little bit on a couple of questions you just asked. The first one you asked about the maintenance of the pond. I had specifically discussed with the engineer, Matt, that we do not want to maintain that stormwater pond. It is entirely the development's responsibility, and during the later MAS detailed review, I will be asking for a detailed operation and maintenance plan with the maintenance entity named, and this was also will be filed with SwiftMud. They will have that operation maintenance entity, and it will not be the city of Northport. I had insisted that they pull the dividing line out of the pond, completely out of the pond, so that we, even if we take over, should we decide to take over any part of that other area, it will not include the pond nor the sidewalk. I had also suggested to the engineer that the pond, in order to make sure that there's no adverse effect to the neighborhood, that the pond be sized to perhaps contain the 100-year storm instead of the 25-year storm, which is normal. That way, they're surrounded by Price, which is already permitted, and only a certain amount of flow can go into Price. That is permitted by the Price Boulevard permit. So majority of the flow will have to go to Cranberry, and we had many discussions with the engineer that Cranberry must not flood. It must not see any more water than in pre-development. So the pond may need to be a little bit bigger than what you see in the footprint, which is why in the development plans, there's a note that says the size of the pond is subject to change based on detailed design. With respect to the pollutants that may spill out from the gas pumps, I had discussed with engineer, and he has agreed that he would put trench drains which will capture any spills. And the trench drain, during the detailed design, I'll be looking very carefully to make sure that most of the trench drain is under the canopy so that it will not see that much stormwater. Okay, so if there's a spill, it'll be captured in trench drain, which is directed to an oil water separator, a fuel separator, instead of putting into the ground as in the previous initial meeting with the engineer indicated that's how that was going to be handled. I said, absolutely no, you cannot put any spill fuel into the dirt. It has to be into a fuel water separator. So I'm hoping that will alleviate some of your concerns. And then, of course, with the off-gassing, when you pump gas into a tank, I had suggested that they put that recovery system. It's like a rubber hose on the fuel pump itself that sucks the air out while fuel goes into the tank. This is a requirement to be used in cities such as LA, where I used to live. Every single gas station had that, and they recover the fumes. And it's actually quite pleasant pumping gas into a car. You don't get hit by this wall of fumes coming out at you. So the engineer has talked with his developers, and they are planning, hopefully, to put all that in. It's not a requirement in Florida, but I suggested as a good neighbor that this should be implemented. In addition, they are putting controls on the vent stack from the fuel tank. The vent stack from fuel tank could sometime off-gas some fuels in air, and they're going to have a recovery system there too. So just want to share these environmental concerns with you.
Thank you, Ms. Elizabeth. I do appreciate that.
And just to be clear, Ms. Gillespie, we're in agreement with Elizabeth's statements that she just made as well. So
thank you, Mr. Gillespie. So it was also stated that there's no guarantee a spill cannot be prevented 100% of the time, which is obvious because there's human error that can happen with everything. But then it was stated that it would be monitored electronically. What if there is no electricity to do this monitoring? Is there a backup system? Is there a third system? If there's no power, how is that monitoring taking place? Because I know this area during Irma, we had no power for at least 5 days.
The the site itself has a transfer switch that basically generators can be brought in and hooked up. Some of them has a program where they bring mobile generators to their stations during power outages. So it would be, the station would be on backup power in the event of a power loss.
So are those generators on site, or will they have to be found if there's no electricity for days? And we know if there's a hurricane, no generators are found anyways.
For this specific design as it stands right now, there is no permanent generator fixed on the property. We have hurricane preparedness plans, 7-Eleven does as a corporation, and they have established generators already on property scattered around for them to mobilize. So it's not like they have to go to the store and buy one, and then they don't have to source one. They already have a supply chain for them already in their product lines. So it's just a matter of getting them mobilized to the store itself.
All right, so if there's no generator and there's no electricity, how do you monitor if there's a spill? Because we don't know what happens with hurricanes, and we don't know how that could possibly affect the tanks or anything else. How do we know with certainty that there's protections, there won't be an unintended spill?
There's measures before and after storm events. So measures the volume before power loss, measures the volume after power loss. So it's just a comparison between the two volumes.
Mayor McDowell, this is Jeff Boone. Just for clarification, what we had been talking up until now were spills where people were putting gas into their car. I think you even said, under your foot and onto the ground. Obviously, when there's no power after hurricane, the gas stations aren't operational. So those kind of spills wouldn't be occurring in a storm situation.
I understand that, but if there's nobody there, how are they monitoring if there is a spill caused? The pumps go down and there's gas spilling out. I don't know, and I'm not an expert with gasoline stations. So if we see the canopies going down all the time, we see debris flying around all the time, we see trees down all the time. What if those fueling stations get knocked out? Will they spill fuel all over?
Commissioner McDowell, we'll bring on Neil Campbell to address this.
Thank you. Mr. Campbell, if you're there, if you could please just unmute before you start speaking, because we can't hear you.
There we go. Sorry, I had a different view on my screen. Yeah, well, if you have something like a dispenser is uprooted, there's a breakaway valve underneath and then a containment, and the valves snap. It allows the piping to separate, and then there's a ball valve, a check valve that immediately closes. And it's called a breakaway. Actually, there's a breakaway on the hose, and then there's a shear valve. It's called a shear valve. And these terms are pretty dramatic, but they're designed for the events that occur. And that snaps and it immediately shuts the fuel off. And anything that is in the piping upward above that, gravitationally, goes into the sump that's underneath the dispensers. They're called under dispenser containment sumps. So that is the thing. The rest of the piping and the other materials are underground in concrete and not near, don't have a vertical alignment to allow them to be torn out.
Thank you for that. I appreciate it, for the little bit of an education on how this all works.
Yeah, and I want to add the point about the generators. They have, I help service those, or help service the plan when it is put in place for the emergency response. They have deals with electrical companies and through insurance backup generators. There are generators in warehouses waiting, reserved by 7-Eleven to go to these facilities, because this is part of the state requirement for evacuation. They don't have to have them on the property, but they have to have them in place within 36 hours. So it is a requirement so that they can bring the station back up. But while it's dormant, no electricity means no pumping fuel, which is usually the safest place it could be.
Thank you. Appreciate it. I'm almost done, guys. So in chapter 53-179, it says that a package store
needs a special exception to sell alcohol. However, there is no package store definition in our code book. So I am wondering, I don't think Dollar General sells alcohol because I have never seen anybody leaving with that alcohol in their hands.
Yes, it does.
I'm sorry?
It does.
It does?
Yes.
Okay. So it's a non-issue.
Yes, a package store by general definition. So when our code doesn't specifically put out a definition, our practice would be to go to just, a general like Webster's dictionary, something along that lines. And a package store is a liquor store. So you're talking about, a standalone liquor store. It does not include accessory alcohol sales to like a grocery store or a convenience store.
Thank you. Yeah, I've never been in Dollar General, so I wouldn't know that they sell it or not. So thank you for that. A citizen during public comment mentioned check cashing. I don't know if 7-Eleven offers check cashing like he stated, if that's going to be allowed. Is that common practice at 7-Eleven or not?
So check cashing is not permitted in this zoning district. I'll let the applicant speak to whether or not they provide that service, but from a quick Google search with my own, it does not appear that they do.
Simply, if it's not a permitted use, we can't conduct that use at the site. So there would be no check cashing at that location, no ma'am.
Is that common practice at other 7-Elevens?
We'll have to check with our client.
Okay.
When I looked at their website, it showed money services. It showed like a transact machine that you put a check in and it goes onto a card. And I would not consider that a check cashing operation.
We have been informed it's not a common practice at 7-Eleven.
Thank you very much for that clarification. So where is the lift station located? Because it's not going to have regular sewer that you guys are going to have to do your lift station. So where is that located?
It's Matthew Gillespie again. It's at the northeast corner of the building. If you go at the northeast corner and go north, you'll see a little circle in the curve next to the pond. It says private grinder pump station. That is the sanitary sewer lift station. Grinder is just the terminology for the type of pump that it is.
Thank you very much. Now, I don't know if anybody will have this information. What is the code separating a lift station from residential property? Current code.
I'm not sure.
This is Daryl.
Daryl.
There's no separation requirement. We have lift stations, I mean, literally right next to houses in the developments in West Villages. It's a concrete wet well with a pipe that comes out with pumps, but there's no limitations on how far away. We have many lift stations in town that you probably don't even see because we try to hide them well, that are right next to residential homes.
But Mr. Smith, do those residential homes, are they serviced by city water or are they serviced by wells? Because to me, there is a difference when it comes to a lift station. If it fails and that goes into the ground drinking water.
I understand. I don't know of any separation. I know that septic tanks have to be 80 foot away from a well. I don't know if there's a separation distance. I can look into that for you, but I don't know that off the top of my head.
Yeah, this is Matthew Gillespie again too. Additionally, any lift station is air tested. It's coated with a watertight epoxy on the interior of the station, as well as we have to vacuum test the manhole to make sure there's no air leaks. So a leakage at a new lift station with modern technology is pretty rare these days. A lot of the leakage you see at lift stations are the older concrete stations where they didn't put liners in and the sewage can seep in the cracks of the station.
Thank you. Delivery.
Mayor McDowell, if I may.
sorry, go ahead, Mr. Booth.
Obviously, any commercial development of this property will have a lift station with it. However, taking account of our site design, we're pulling it farther away from the residences as if somebody were to build a commercial plaza closer to the residential lots adjacent to this parcel.
So you're moving the lift station that you just showed me where it's at?
No, ma'am. The lift station could be located closer to the residential lots adjacent to the parcel if a development plan was proposed closer to those residential lots. So actually part of our development design we have before you today actually has a lift station located farther away from the lots than it could be.
Thank you. Delivery trucks. I'm not looking for access onto the property itself. I'm looking for how will the fuel be delivered to this site? And I think Commissioner Carrison started to touch on this when I was having technical difficulties, when I realized the technical difficulties and the degree of it. So if you could please indulge me and re-answer the question, how will the deliveries of the fuel trucks be made to this site?
Go ahead.
I was gonna say that they would have to use the routes that are approved in our code, which I believe are Toledo Blade, Sumter, and Price. If that's, I'm not sure if that's answering your question or not, but they use those routes.
Mayor McDowell, it's my understanding that the city controls the delivery routes. So I would just echo Nicole's statements.
All right, and I did hear where we could condition, and correct me if I'm wrong, I may have wrote it down incorrectly. We could condition the hours of that delivery so that if it's school bus time, if it's heavy traffic time, we can, will deliveries be made at night? Can we condition it for no night deliveries?
I do believe you could condition the hours for deliveries. As far as what those were, I think they would need to be consistent and stable. So, you know, high traffic times might be difficult unless you know that those are always going to be a certain time, but I do believe you could condition those, yes.
Mr. Boone, do you guys know if your 7-Eleven person that's off in limbo, do they deliver fuel in the evenings, like, you know, from 9 p.m. to 6 a.m.?
We will check with our 7-Eleven client.
We're checking right now.
Thank you. All right, so the last question while he's checking on that, this is something for staff. We had conversation back, I think it was February, I know it was pre-COVID, where we said, hey, we as a commission gave direction to bring back to the commission as soon as possible, not waiting for the ULDC rewrite, to change the neighborhood commercial to not allow gas stations. We already don't allow 24 hours a day. And I was wondering, how does that come into play? Because that direction's already sitting out there in limbo, and it's been out there since February-ish. How does that play into what we're discussing today? Because we've already made it clear we do not want gas stations in neighborhood commercial.
So these applications were received prior to that direction being given to staff. So they would have to be evaluated based on the current code that is in force right now.
Okay. Do you have any idea when we're going to be seeing that?
I do. We actually, the legal request for it, it should be going up to legal for review this week. And then going forward from there.
Thank you very much. Mr. Boone, did you by chance get the answer?
Yes, thank you, Mr. Mayor McDowell, Jeff Boone. The delivery trucks always try and deliver during daylight hours because it's just it's significantly easier for the truck driver to both navigate the store as well as, you know, do the refueling operation, if you will. So I suppose if there's a crash on the interstate and traffic gets delayed, something like that, there might be, you know, in the wintertime, you might have some gas delivered at 6 o'clock, you know, when it's dark, 6 o'clock p.m. But that's not the goal. We understand it's not the goal. The gas is always tried to be delivered in daylight hours.
Thank you. I'm sure it's easier to see that stick you guys always are putting in there.
Madam Mayor, if I may?
Go ahead.
Based on the individuals that we interviewed at the 7-Eleven.
Madam Mayor, wait, this is improper. This is improper.
Hold on.
Objection.
Mr. Boone?
Objection. This is improper. This is exactly what I tried to do earlier and was told that was part of my rebuttal. So any comments that any aggrieved party would have at this point.
I'm answering your question.
The question wasn't posed. There was no question. This was a question directed towards us. It was not directed towards Ms. Tracy.
Well, I just have the list of the times.
And I would request, we would request the same treatment be given to all parties that was given to us. And that is that this can be addressed during closing argument.
But if I'm asking a question of you and staff, the aggrieved party is entitled to be able to answer questions also at this time. Just because you, Boone, the applicant, and staff are answering questions does not deprive the aggrieved party from answering questions also.
So in other words,
the attorney, could you please weigh in?
Do you have a question for the aggrieved party?
I was asking about delivery times, and Mr. Boone answered it on behalf of the, I guess, applicant, Ms. 7-Eleven, and staff answered it too, based on the codes. And I believe Ms. Tracy wants to weigh in and answer the question also.
But Ms. Slayton, the question was directed towards the applicant about their delivery times. And unless Ms. Tracy has direct knowledge from our client of what they do, which is where she should start before she gives the answer, just because she talked to somebody, the question was never directed at Ms. Tracy about what she thinks.
We have written documentation.
Is that documentation?
We have actual photographs.
Has that been presented? Has that been presented as part of the 5 days ahead of time? Because to me, that's a rebuttal exhibit, which we're not allowed to present.
Ms. Tracy,
sir, I'm trying to answer the questions that several of the commissioners are curious in regards to the times that are actually fuel service is being delivered, and they're all over the place. It's 8 p.m., 12 noon, 2:30 in the afternoon, 3:30, 7:50.
Tracy,
we object.
Did you, Mr. Boone, could you please, I hear your objection. I'm trying to dismiss the objection in a correct manner, so please bear with me. Ms. Tracy, the documents that you are using and the photographs that you are using, did you submit them to the city clerk as the evidence prior to the 5-day notice?
Let me check one moment, Madam Mayor.
Thank you.
It says who is the staff that provides her this data. We want this information verified. Majority of those times are daylight hours.
Did we submit it as far as into? From what I understand, they were not, because they were verbal interviews.
Thank
you.
And then the document. If you could please save that for your closing argument. Thank you very much.
Yes, ma'am.
Madam Mayor, just to clarify, evidence from documentary or testimony from documents that are not in evidence would not be proper.
Correct, and that's, thank you for that. So my last question has to do with the crime. I have had and submitted the crime thing that I had gotten from the police department. And I agree that there are some crimes that happens regardless if it's a gas station. But this is not just a gas station, it's also a convenience store. And we have already got documentation, possibly 6 months worth of data that the police department provided to me, which I provided to the backup materials that was already mentioned. And I know that a lot of the things that are listed on there don't quantify as being directly related to a gas station or a convenience store. A lot of times the officer will say, hey, meet us at the Dollar General. Hey, meet us at the gas station at the corner of. So that becomes like a focal meeting point. But there are quite a few things that are listed on here. For example, suspicious in person, disturbances, trespassing, theft. There's also a drug case where I guess it happened right there at the location. And I just want to ask, how are you going to protect the neighborhoods without a wall when you have only a 50-foot buffer, landscape kind of buffer from people going into those neighborhoods? The Dollar General has a wall separating them. So they have to like go around the wall if they really wanted to go in the neighborhood. What protections are going to be in place to keep the unwanteds from going into somebody else's property?
Mayor McDowell, let me start off. First, I do agree with you that according to the data submitted into the record, there really is no difference between whether it's the gas stations that have been identified or the Dollar General. In fact, if you look at the gas stations that are listed that have had a theft call, each of them that do have theft calls only have one. The Dollar General itself has one theft call as well, and so on. It follows with other calls of similar crimes in that nature. If you will recall, I know you mentioned the February workshop you all had on the neighborhood commercial high intensity zoning. And during that workshop, Nicole Galehouse gave testimony that actually a planning principle that is being implemented now is that they have found that walls actually are conducive to crime. And I believe she said that New York City has actually done studies, and they're now actually looking at not requiring walls or even removing walls in order to remediate any criminal activity that may be encouraged by a wall in that area. So we believe not having a wall actually follows with the current trend and actually better serves the adjacent residential lots.
The other thing, Mayor McDowell, this is Jeff Boone, that I would add to this as well, is that if you look at the different types of police calls to the gas stations, many of them are not criminal in nature at all. But those that are, almost all of them have to do with people in a vehicle, and as opposed to somebody walking into a store. So the car is on the street without the convenience store there. You've got a criminal in a car in a neighborhood that is not in some well-lit area that gets pulled over. So if a criminal is already in a car in the neighborhood driving down the street, the chances of the criminal escaping the police at the gas station would probably be less than a criminal escaping the police on the side of the road. Or even if they're the same, it makes no difference in the crime in the neighborhood. There's very few of these crimes are actually crimes that aren't people in cars that the police pull over, and they pull over instead of the side of the road, they just pull over into the gas station.
Thank you.
And we also have, and I'm being reminded here by Mr. Collins, that in this instance, the criminals would also have to swim across the pond to get to the adjoining lots.
They would have to swim across the pond. The pond doesn't go the entire length and width of your property. It's only a smaller segment of it. I don't understand that, but that's okay.
Well, what it would do is it would aid the police in their apprehension, because it would basically funnel the criminals. I mean, the chances of this happening, if you just look at the statistics, are it's probably 10 times more likely for someone just to burglarize a house in the neighborhood than it is for a criminal to escape the police at the gas station. But to the extent that would ever happen, the fact of the pond would help funnel the criminal down into a smaller area, so that the police would be better able to apprehend the criminal.
Thank you, Mr. Boone. All right, I at this point don't have any other questions. Does anybody else have another round of questions or follow-up questions? Last minute questions? Last chance? Seeing none, I will go ahead and we'll start the clock. And this time the aggrieved parties get to go first for their closing arguments. The aggrieved parties get 15 minutes along with the applicant and staff for their closing argument. I'm setting my little timer. Bear with me while I get that ready. And we are going to start with Mr. and Mrs. Leslie. If you could make sure you unmute yourselves. Mrs. Leslie? Can you hear me, ma'am?
Yes, ma'am.
Fantastic. Ma'am, you have 15 minutes for your closing argument.
All right.
Go ahead, please.
So these special exemptions are put in place to protect the surrounding residents. To again quote the Unified Land Development Code, the neighborhood commercial districts are intended to provide for the customary and traditional conduct of limited trade, retail sales, and commerce in a manner convenient to and yet not disruptive to adjacent residential areas. Additionally, it provides a mechanism to attract and encourage employers to locate appropriate uses within neighborhood settings and contribute to the diversification of the economic base and quality of life. The entire neighborhood will suffer if this plan goes through. This will, without a doubt, disrupt adjacent residential areas. All of the gas stations and car washes on Sumter and Toledo Blade, close to I-75, are in far more appropriate areas with direct access to 75. Fueling vehicles that would be traveling through residential neighborhoods at all hours is highly inappropriate and will add an unnecessary abundance of noise pollution, which would already be a nuisance 24/7. My family's home in particular will be severely negatively impacted, more so than the other abutting properties. We would receive half the buffer that everyone else is allotted. We would have a high traffic driveway very close to our home, the only property that this particular driveway affects. The high risks already associated with this plan are even greater for my family. My family has every right to all of the other protections, buffers, whatever that every other abutting property is granted. This and all residential neighborhoods deserves to prosper and have the best quality of life that their city is able to provide. With the current proposal in place, too much is at risk where the nearby residents are concerned. Every single neighbor's livelihood is at stake. The community has spoken, and we don't want you to gamble with human lives and the city's integrity. The law firm can downplay and make all of the excuses that they want, disregarding the residents' very valid fears and concerns is very unhelpful. Just because you can doesn't mean that you should. Please appropriately place this plan elsewhere. Thank you.
Ms. Leslie, you do have time left. I just want to ensure that you are completely finished with your closing argument.
I am. I want to make sure I don't say anything inappropriate also.
Thank you, Ms. Leslie. I appreciate that. All righty, Ms. Tracy, I will set the timer. If you could make sure you unmute yourself. Ms. Tracy?
Yes, I'm sorry. So we didn't have interference. We had to.
Not a problem. I have your time set, ma'am, for your closing argument for 15 minutes.
Thank you, Madam Mayor. So we've gathered here now since 9 a.m. and listened and learned to the different issues that have come on hand. All of the uncertainty and holes in this project leave me even more disturbed than before we even began. Just because I am only considered in this panel a resident or an aggrieved party, by all means does not mean I have not spent weeks and months studying and doing solid factual research on what comes with this project. I have confirmed in my speech many issues and concerns that have come up. I've tried to sit quietly as to not be disrespectful in any way to the entire panel. But on some things, the facts just are being completely buried in the dirt. First and foremost, since now I have the actual opportunity without being rudely interrupted, fueling truck delivery times supplied to me from the local 7-Elevens here in Northport are as followed. 8 p.m., 12 o'clock noon, 12:30 p.m., 3:30 p.m., which may I add is during school times, 7:50 p.m., 5 a.m., 6 a.m., just to name a few. To reiterate some facts, thank you for confirming that there's not a generator on hand, because that means if there's no generator, and let's say a storm or hurricane, which we live in Florida, happens, those systems set into place for leak detection will not work. So can you imagine if undetected and it doesn't matter what period of time, it's done, it's there, it's present, then what? Then who fixes that problem? Oh, it's in the soil. Do you know it was in the soil? No, because your systems failed. Things happen, errors happen, which is why things like this, businesses like this, should not be adjacent to residential properties. Although there is a waiver for the special exception in regards to the 24 hours, as Ms. Galehouse has given solid information on, the fact still remains that noise and noise ordinances are set in place in residential zoning. And I'm pretty sure that the noise from a 24-hour gas station, a 24-hour car wash running, the noise from that with the blower and the cycles for a several-minute period of time, no matter how many times that service is run, cars have gone through, cars in and out from the actual convenience store itself. 756 extra vehicles, they claim, are only the amount that are going to be in this area. Only 756. But that's 756 in and outs, car doors opening, horns blowing, traffic even, yes, increased by only 756 though, but still, it creates noise, it creates impact, it creates a disturbance to all of us and those who live surrounding this property. There's no fluff that can be thrown at that, noise will come. The proposal is just disruptive. It's an unnecessary hardship on many levels, which I believe falls under special exceptions. I can assure you, if this project does go through, I will be the first one to call every single time my sleep is disrupted or any ordinance is broke in regards to what I can call as my own personal right as a property owner at this point next to this property. And I can assure you that I will not be the only one. So therefore, if the property goes in, I guess it's going to create a little bit of headache for a lot of people in more ways than one. Because if we have to live next to it and deal with it, other people are going to have to deal with what comes with it as well. Sorry, Madam Mayor, I have so many notes. It's just hard to keep up with everything. I do
All right.
apologize.
You have 8 minutes, ma'am. You're fine. Take your time.
Good. Just to wrap up, because honestly, this has been exhausting. If you can smell gas, you're breathing in toxic fumes, period. I mean, it's common sense. I don't need a degree or have gone to law school to be smart enough to know that. Land development should serve to immediately benefit surrounding residents and not pose any harm to them. Any business that's placed along the residential property should not be allowed to operate 24 hours a day. I don't understand that, no matter how many times you guys want to tell me that there's waivers and this and that. And yes, of course, it's allowed to be brought to the table, but it sure as hell does not mean that anything has to be passed on it. Residents deserve to enjoy peace during the late night hours and crucial sleep that can cause health conditions on so many different levels. Again, pretty sure that that's common knowledge. No amount of buffer will protect our residents from the dangers and harms. And certainly a pond where, I don't know, a criminal would have to swim across, or people would have to swim across to come into my backyard, whatever that was. I'm speechless on that one. It's been very much stated in the CEDS that if you set convenience stores up in areas where criminals have several routes to get away from the law, they will, which is why they don't recommend it in residential neighborhoods. And furthermore, it's not recommended within one being 500 feet from a residential neighborhood. Again, you know, I could go on, but I feel like regardless of the accurate credentials and solid information that I too have supplied from the EPA, CDES, and the Florida Administration for Environmental Protection, I don't know. I don't know if it just has to come out of Mr. Boone's ears for it to be taken serious, or one of his credential expert witnesses who have supplied, again, no written submitted documentation, only their own personal testimony at this point. So I have no ill will towards any of the commissioners. They have treated me with respect. They have answered questions. And on behalf of the 300 documented petition against opposing this, I would like to say thank you for taking the time and several hours out of your life to listen and consider these facts and not just look at the almighty greed dollar. That is all. Thank you, Madam Commissioner. I am finished.
Miss Stacy, I heard you say that you were finished. I just want to make sure you're finished with your closing arguments, correct?
Yes, ma'am, I am. Thank you very much for your time.
All righty, so now we will move on to staff for their 15 minutes for their closing arguments, and your time, Ms. Cohen, or is it going to be Ms. Galehouse?
It will be me.
Thank you. I just wanted to make sure somebody was unmuted before I press start. Ready? All right, and your time has begun.
Thank you. Good afternoon, Mayor and Commissioners. Again, Jennifer Cowan on behalf of City staff. I know it's been a long day, so I'll be brief. As discussed in our earlier presentation, the question before you is whether or not the evidence and testimony provided demonstrates that proper notice was provided and that the requests meet the Unified Land Development Code. So to the three main issues that I identified initially in our presentation and that have been gone over by both the applicant, the affected parties, and city staff. First, for the DMP and its waivers. The DMP and waivers may only be granted where there's a finding of that they are consistent with the comprehensive plan and the criteria made specifically applicable by the regulations and conditions of approval, and they would not adversely affect the public interest. Staff respectfully submits that the testimony provided to you today, as well as the written evidence provided by both the applicant and staff, support approval of the DMP 19-280 with the conditions 1 through 5 contained in the staff report and the concession that the petitioner, or that the applicant made to offer the colors meeting the design standards of the nearest activity center. Additionally, the testimony, both the applicant and staff support approval of waivers 1, which is to section 53-84B3, dealing with the signs, waiver 3 to section 53-182, dealing with the buffer area, and waiver 4 to section 25-7, dealing with the wheel stops. Staff also recommends that there is a denial to waiver 2, which is section 53-179. This is the 24-hour operation, as that is inconsistent with the purpose and intent, chapter 53 of the Land Development Code and or the comprehensive plan, and would adversely affect the public interest. As for the 2 special exceptions, the Uniform Land Development Code again states that granting a special exception by the commission must first determine that the special exception will not adversely affect the public interest, health, safety, and welfare, and that it meets the code criteria, including those 16 standards that have been discussed repeatedly today. Staff again respectfully submits that the testimony and the evidence provided by staff and the applicant support that proper notice was provided and that both special exceptions should be granted with conditions. Specifically, the testimony and evidence support approval of resolution 2020-R-11 relating to SPX 19-269 fuel pumps, with the condition that the major site and development plan have spill control release and cleanup plans submitted, which includes spill reporting criteria per FDEP requirements, and that the facility's contact person information on that spill release and limit to no more than 12 fuel pumps for the property. Also, that the testimony and evidence support approval of resolution 2020-R12 for SPX 19-270, the car wash, with conditions that the car wash be designed so that no pre-wash water, wash water, wash overspray, or other chemicals enter the stormwater system, and that the site layout be revised to move the car wash to either the south or east of the property. Should the commission deny the special exception for the fuel pump, then staff would recommend denial of waiver 1 with regard to the signage. I want to thank you for your time and consideration today. And with that, I am completely done with closing argument.
All righty, Ms. Cohen, you said you are completely done with closing arguments. I will take you at your word and we will move on to the applicant. Thank you very much.
Thank you.
All right, at this time, Mr. Boone, you have 15 minutes for your closing argument.
And if you could give us, let us pull up our first exhibit and we'll be ready to go. All right, we're ready.
Your time has begun, sir.
Thank you, ma'am. First, I want to say, Madam Mayor and all of the commissioners, we've been at this now almost 7.5 hours. If you take out the half an hour for lunch, we want to thank you very much for your patience. And we really do appreciate you giving everybody as full and fair a hearing as possible today. First, I'd like to start with our site design. I think this whole request, frankly, is about the site design. And if we did not have some of the features in the site design, then we would have a hard time making an argument that we comply with the criteria for the special exception and the waivers. But because of the site design, we firmly believe that we do. First of all, from the building to the north to the property line, not to the houses, but to the property lines of the properties to the north, is a 234-foot setback. From the car wash to the property lines, not to the backs of the houses, but to the property lines to the west, is 217-foot setback. Undisturbed, never to be developed property, with the exception of the pond, of course, that's in a portion there. We are willing to move the Price driveway further to the east and always have been, if staff would agree, even though now it's further away than a driveway or even a building would be if a normal, typical commercial development was placed on this 4-acre plus property. With respect to our request for the 24 hours operation, the fact that we have this massive buffer that will never be developed, we believe fully mitigates any impact of the 24-hour operation of the building here. Clearly, the concerns that have been expressed, we believe would apply if this was a typical commercial building built right up against with the 30-foot buffer to the properties that surround it. But because of our site plan here, we do not believe that the 24-hour operation would be any problem whatsoever. And in fact, there are benefits of the 24-hour operation. People do have to go out in the middle of the night for convenience store needs and for gas. And by having those services available in the neighborhood in the middle of the night would prevent those people from having to drive further in the middle of the night for those services. The crime statistics, we've heard an awful lot has been said about those to this point. Just to reiterate, at least 30% of the calls are public service calls, people that need directions, things like that. Many other calls are non-criminal calls. They just happen to be where a police officer pulls over someone in a car. And it's been shown by the statistics that, in fact, if this gas station is not built here, the normal, typical commercial development that would be built here instead would actually generate a higher number of actual police calls that are criminally related. We also agree very much with Ms. Tracy that it's ludicrous or crazy and sort of what was that all about to think that a criminal would try and run from the gas station around the pond or through the pond into the neighborhood. Again, there's probably 10 times better chance that if a criminal wants to invade their neighborhood today or at some point in the future, they would just walk there from somewhere else or drive a car there and just burglarize the neighborhood as it exists, perhaps not wanting to be somewhere where there might be a bunch of police cars if you put a gas station there to attract the police cars in the middle of the night. We want to talk about our alternative design because we think it is important. the alternative design that we showed you before. We heard staff's comments about perhaps the parking would need to be adjusted. So you could take this very same design, build a couple of out parcels along the streets, basically have the parking in the middle. But what it would mean would be that a large, the code would allow 54,000 square foot of development here. We're proposing 3,000. And I want to say those numbers again. The code would allow 54,000 square feet of commercial development. We're proposing 3,000, a little over 3,000. The rear of the building that's shown here would have deliveries. Same questions about times of deliveries and size of trucks would apply here, except there would be more because there would be more businesses operating here. There are the questions we had about the dumpsters would be the same questions here, except there would be more dumpsters. And typically those are picked up in most commercial centers earlier in the morning before the traffic for the center gets there. The fact that what we have here is too many bigger businesses per the code. I think staff said that. What that would mean is we could just have more businesses operating the same space. More businesses would then mean more, if businesses attract crime, then more businesses would end up attracting more crime. We're basically showing 3 businesses now. We probably could have 8 there instead, based on what staff had had mentioned. And again, the setback is 30 feet for any commercial building built on this site, with the potential for delivery trucks and dumpsters in the rear of the property. We've spent a lot of time already talking about traffic. I think it's been established by competent, substantial, and professional expert testimony that this gas station would largely capture traffic that's already on the road. At the peak AM hour, 23 cars in the entire hour. In the peak PM hour, 26 cars in the entire hour. The alternative design would attract traffic, not just capture the traffic that's already there. People would be coming to the businesses here that might not otherwise be on Price or Cranberry in this neighborhood. We obviously want any businesses in the city that would open to be successful, and you would obviously want them to attract as many customers as possible. That means there would be more traffic coming to a typical commercial development on this site than what we're proposing at this point in time. It is very important to note, we really haven't talked much about this today, but we've mentioned it. I want to reiterate that the 4 lots, the 4 parcels that are at this intersection were platted in 1960. That's 60 years ago. The property was zone CG when it was changed, sounds like about 15, 16, 17 years ago, to neighborhood commercial high intensity. It kept the gas station as a permitted use by special exception. It's clear to us that the emails that you've received shows fear, and this is understandable, that if a gas station can be located at this site, then any residential neighborhood in Northport could have a gas station built there. Well, not only does it sound like your code may be about to change to prevent that, it would have to be in property that's already zoned for the potential of a gas station, which this one is. And 99% of the residential neighborhoods in Northport don't have any zoning within the neighborhoods that would allow for any type of commercial development to occur. The other thing we haven't, sometimes it's interesting to remember what we haven't heard today. And as you all are very experienced commissioners and have been through dozens and dozens and dozens of public hearings, the one thing you didn't hear today was, well, this property, it was never, ever intentioned for commercial development. Well, actually, it's been intentioned for commercial development since 1960. Very briefly, we thought Mr. Leslie, in his rebuttal testimony, confirmed that we are within the market statistics for the need for a gas station in this area. Ms. Tracy testified about her conversations with an unnamed appraiser. That is not expert testimony. It's simply her telling you about what some unnamed person told her. It's not expert testimony. In fact, if we were in a court of law, and if you ask Ms. Slayton, she'll confirm this with you. If we were in a court of law, that type of testimony is what is known as hearsay testimony. It's what somebody told somebody out of court, and that testimony is not allowed in a court of law. Now, in quasi-judicial proceedings, expert testimony can be, hearsay testimony can be allowed, but that doesn't make it expert testimony. And I'll get to why that's important in just a few minutes. We also had a great deal of testimony today about crime statistics, probably more than you've ever wanted to hear. It's interesting, though, once again, something else that we didn't hear. Despite all the statistics about crime, we never heard any statistics, data, or examples about any toxic chemical emergencies at any gas stations in Northport. We've heard there are a lot of gas stations in Northport, but we haven't heard any statistics or data at all about toxic chemical emergencies at gas stations in Northport. And I think everyone recognizes that at this point, had there been any such incidences or statistics or data about that, we would have heard about it, and we've heard none. Ms. Stacy's testimony that the Planning and Zoning Advisory Board denied the 24-hour operation. Now, when she stated that, she was clearly wrong, but we don't believe that she was intentionally being untruthful, especially since she was under oath. But it does call into question her ability to correctly understand what she hears and reads, since almost all of her testimony and evidence is based on what she has heard from talking to somebody or has read on the internet. And of course, we all know everything you read on the internet's truth is the truth. It has to call into question, and it certainly would in a court of law, it has to call into question the accuracy, even if unintentional, the accuracy of her testimony. Just checking on the amount of time I have left. I know all of you commissioners are very well aware of the law in Florida. That's been the law in Florida since the Snyder case in 1986, that in quasi-judicial hearings, the issues that are in play have to be proven or disproven by competent substantial evidence. And if the applicant proves by competent substantial evidence that their application should be approved, it's up to the opposition, if you will, to prove by competent substantial evidence that the applicant does not meet the criteria. In this instance, commissioners, the applicant has presented expert testimony from a licensed professional appraiser, real estate property appraiser, a licensed professional traffic engineer, a licensed professional civil engineer, and a professional fuel system gas tank safety expert, all experts providing expert testimony. And although we did not present city staff member Elizabeth Wong as an expert to testify, her expert testimony, because she is clearly an expert, her expert testimony supported our expert's testimony 100%. And in fact, even evidenced the fact that our client is willing to go above and beyond, well above and beyond in several and many instances on the fuel system safety issues. Commissioners, the testimony and evidence before you today, along with the application materials and all the documents that are in the record that you've had a chance to review before the hearing today, all of them together show that we have shown by competent substantial evidence that that our applications, all of our applications, our special exceptions and the waiver requests.
You have 1 minute.
Thank you. Thank you, ma'am. Thank you, ma'am. It is clear. And I should say, and there was no competent substantial evidence whatsoever, none. There was plenty of testimony but no competent substantial evidence to rebut what our experts have testified. The record before you today, and if this record was reviewed in a court of law, there was clearly no evidence contrary, expert evidence contrary to ours, any competent substantial evidence. We are consistent with the city's, all of our requests are consistent with the city's comprehensive plan, consistent with the city's land development regulations or zoning code, and also consistent, as your staff has confirmed, with the special exception criteria that are part of the land development regulations. We again thank you very much for spending all day with us today, and we respectfully request your vote of approval on all of our requests. Thank you.
You have 10 seconds left. Are you finished, sir?
Yes, ma'am. I don't even think I can talk 10 more seconds. Thank you.
All righty. All right. So that concludes our public hearing for the two special exceptions, the DMP. The quasi-judicial procedure is now officially closed. It is also 5:05. We still have to get through motions, commission comments on this development, and I feel that maybe a 10-minute break would be warranted because we don't know how long that process will take. So at this time, seeing that it's 5:05, we'll reconvene in 10 minutes at 5:15 sharp. 5:15, we will be back to wrap this up. City Attorney.
Yes, ma'am.
I see that your hand is up, and yes, I do plan to do roll call and to make sure there was no ex parte communication.
Okay, I would like to speak to the commission when you come back about motions before you get started.
Thank you very much, ma'am. I'll make sure we hear from you. All righty, we have less than a minute, I see. City Clerk, are we ready to begin, please?
Yes, we are.
Thank you very much. Okay, guys, it's 5:15 and we're back. And you know the drill by now, so we will go ahead and take roll, and also please state if you've had any ex parte communication or any communication on this matter during this quick 10-minute break. So we will start with Commissioner Emmerich.
I am here and I have not.
Commissioner Hanks.
No, ma'am, I have not.
Commissioner Caruso.
No.
Thank you. Vice Mayor.
Present and none. Thank you.
Thank you. And myself, I'm present, and I also had none. So at this time, we do have all 5 commissioners present and accounted for. Let's go on to the charter officers and City Clerk.
Yes, I'm here.
City Attorney.
Present.
And City Manager.
I'm here.
Fantastic. All righty. City Attorney, you're first. I see your hand up, so we're going to turn it over to you.
Thank you, Mayor. As the board moves into the action portion of the quasi-judicial process, there are a couple of things I wanted to point out to you about motions. The board has some suggested motions before you, and there is one correction that needs to be made in the motions that relate to the 2 resolutions. It is required, as you've heard all the lawyers say today, that you make certain findings, and the code provision that is listed in your suggested motions is incorrect. So I'd like to give you the correct one. That code provision is section 53-259 of subsection 3 of the Unified Land Development Code, 53-259. And so that's whether you want to move to approve or deny for each resolution. That change needs to be made. The second item that I'd like to mention about the motions is if it is the will of the board, if the motion maker wants to present an approval with conditions or with waivers, then it is important in the motion that you explain the condition or the waiver. I do not recommend simply stating something like condition number 1 that was in the staff report or waiver number 2. but actually identifying those so that there's complete clarity in the motion. Thank you, Mayor.
Thank you, City Attorney. All righty, so Commissioner Carrison, I see your light on.
Yes, I'd like to attempt these motions. All right, starting with resolution number 2020-R11, pursuant to the City of Northport Unified Land Development Code, Section 53-259, providing for findings, granting the special exception with the following conditions. Number one, as stated by the staff, would be the allowable flow from the site that can be discharged into Price Boulevard cannot exceed the flow permitted in the drainage model that was approved by SWIPMUD and permit 4304411.000 issued February 13th, 2020, as well as limiting no more than 14 pumps and to limit the delivery of products and gas to no deliveries during the school bus offloading times of 2:30 p.m. to 5:30 p.m. during the school year while school is in session. And in addition, times that comply with section 4642 in the administration code, which is nothing prior to 7 a.m. and nothing after 10 p.m. And I believe that is all that is needed for this particular one.
No, ma'am. Commissioner Carrison, there are additional findings that need to be made. And you'll see those in your the draft motions.
I don't have a draft one.
So additionally, the commission needs to find that proper notice was provided.
Oh, I'm sorry. I thought it was clarified. Yes.
That granting the exception will not affect the public interest, health, safety, and general welfare. And that the specific requirements in section specific requirements in the schedule of district regulations governing the individual special exception have been met, and the 16 standards listed in section 53-259, subsection 3 of the ULDC have been met.
And that is as stated. Thank you for detailing that. Hopefully I don't have to reiterate that.
So would you like to add all that language to your?
Please. Yeah, I don't have a.
Are you finished with your motion?
That would be, yeah, that.
Hang on, guys.
I need a second in order to discuss.
I'm asking you if you are finished with your motion, ma'am.
I believe that is it, yes.
Thank you. Have a motion on the floor, please. Do I have a second? Hearing none, motion fails.
Do the hours of operation have to be included in that? See, I thought they only had to be specific to the gas pump issue. Okay.
Commissioner Luke, I see your hand is on.
I'd like to move to deny resolution number 2020-R11 and find that based on the testimony and evidence provided, granting the special exception will adversely affect the public interest, health, safety, and general welfare. All of the 16 standards listed in section 53-259 of the Unified Land Development Code have not been met and the competent substantial evidence does not show in items A, B, C, D, reasons primarily in each of those being that the intent and intensity of the development is contrary to it, but the remaining of the standards were met.
And that,
Vice Mayor, would you mind clarifying your motion when you say sec A, B, C, and D? You're referring to sections of ULDC 53-259.
Would you like me to read what A, B, C, and D are?
I would prefer that, yes, ma'am.
Okay, the proposed use shall be consistent with the intent, goals, objectives, policies, and programs of the City of Northport Comprehensive Plan and the intent of the zoning district as defined in this Unified Land Development Code for the area in which the property is located. B, the density or intensity of the proposed use shall be consistent with the intended future use of the designated land use area in which the property is located in accordance with the provisions of the future land use plan map contained in the comprehensive plan. C, the proposed use singularly or in combination with other previously approved special exceptions must not be detrimental to the health, safety, welfare, morals, orders, comfort, convenience, appearance, or prosperity of the neighborhood or adjacent uses, and shall be an economic benefit to the economy of the city. D, the intensity of the proposed use shall be harmonious with the character of the other uses in the neighborhood.
and as the seconder, I agree to what she had added to the record. All right. So as motion maker, Commissioner Vice Mayor Luke, would you like to speak to the motion?
I would. Though the project, I think, is one that they have worked very hard on, and in an activity or center area would be, in my opinion, a great place for something like that, because the activity centers are designed for more of an industrial, heavier, lighter commercial footprint. But in the neighborhood commercial, it is that lighter footprint. And I see gas stations as more of an industrial type of heavy commercial. So the goal is to serve the neighborhood with that light commercial and be convenient. And I don't see that being so. Actually, A, B, C, and D are quite subjective into how we view it. So I see in intensity and the density within B being the same way, that the intent for neighborhood commercial is to be a less heavy footprint of the commercial. I see it in the same manner. C, again, the health, safety, welfare. On one side, you've got some saying, you know, it's safe. On others, it's not. And I have to look at that again in a heavy or a light commercial footprint. In D, again, the intensity, the intent for neighborhood commercial is for lighter intensity. And so that is why I believe it does not fit A, B, C, or D. Thank you.
Thank you, Vice Mayor. As the seconder, when you speak about A, and it says that it is meets the goals and objectives and policies of the comp plan, I have to immediately go to the fact that this is neighborhood commercial, and all 4.2 acres are neighborhood commercial. And by having half of it be conservation, which means it's not paying the same amount of taxes
that an entire 4.2 acre parcel will pay, that immediately goes against the comp plan. And the intent of what that comp plan is to make it economically viable for the city. As far as with B, shall be consistent with the intended future use of the plan map. If this was going to be I'm going to leave that one alone. Neighborhood commercial is to offer limited trade. And to me, limited trade is to bring something to the neighborhood that is not generally found immediately outside. There are gas stations every single which way you leave this neighborhood. Whether you're heading north towards Toledo Blade and 75, there's a gas station. Whether you're heading east, there's a gas station. Whether you're heading south, there's a gas station. Whether you're heading west, there are multiple gas stations all around us. In order to leave the area to get gas, you have to travel out there. That is where you're traveling anyways. It's pass-through traffic. To say that people are going to be coming to this gas station to get gas is not the intent of neighborhood commercial. Neighborhood commercial is not to attract vehicular traffic to the neighborhood. And that's exactly what they were saying when they said something about 23 or 26 additional people, things will be stopping there. 77% is, I guess, pass through. 23% is going to be coming there to get gas. That's not the intent of what neighborhood commercial is. Consumers stop at gas stations for a variety of reasons, but it is not harmonious because it's going to be all day long, people in and out, traffic in and out, traffic. It's not harmonious to the neighborhood. So for those reasons, I agree with the motion that is being made. Do I have any other hands up? Commissioner Carasone, I do see yours now.
Thank you. As the only person who was actually here when the neighborhood commercial zones and areas were developed, it was specifically for items like this. You know, the first intent was that there would be a walkability, and I believe that be it the parkland or the conservation overlay would absolutely work with what our intent was, as well as provisions like a convenience store. And then the high intensity was always to allow added services that would require vehicular traffic, similar to what is being presented here. Now, much of the definitions and intent has been bastardized over the last decade, but the ULDC and the comp plan continues to hold true. You know, impacts to neighbors and the neighborhoods would have been heavily, well, they've been heavily mitigated by most of the proffered conditions by the applicant, but added conditions, which I had listed, would have lessened impacts, but remaining consistent with the code and the comp plan. I was very specific in the, I took great strides in addressing all 16 criteria. When I did my questions, I went through them one by one, those that were not addressed by staff. So to say that this is inconsistent is just, in my opinion, inaccurate. Furthermore, at this point, this property has been undeveloped for many, many years, this and the other three corners, and it's most likely for reasons that we're seeing here today and the last meeting. You know, and with some of the things that have taken place, like the removal of a lot of our incredible planning for commercial properties, like, you know, some of the West Village District exemptions and the orange hammock being removed, and there's a few other things, but the point is that we need the economic development in order to sustain a reasonable tax base for our citizens. And I think that by adding several conditions, like limiting the time, limiting the times that they could deliver their product, to making sure that there was a design standard, to making sure that the Cranberry access point was a right in and left, or right in and out, as well as a left in and out. I think that you could have and reducing the pumps. I think you could have absolutely mitigated those items that neighbors are concerned about, not necessarily that they are an actual issue. And I can say that because I live very, very, very close to I-75. And if there's ever a place that has a constant amount of noise and traffic and emergency lights or in sirens, and I can see the lights from City Hall sometimes. It's amazing. But I see this as a very, very lessened impact compared to something like that. And again, I think that with all the mitigations and conditions, I think it would definitely have, it would have been worked out. And I think that it would have been very beneficial to the city. Very sad.
Are you finished, Commissioner Carson?
You want me to keep talking? I can.
No, I just see your hand still up. I might have had a second thought.
Oh, I got all kinds of thoughts, but I'm going to keep them to myself.
Thank you.
Bye.
So I forgot to mention when I gave my reason, seeing that there's no other hands up, I'm going to state something else. Health and safety is very, very important, no matter where this development goes. And like Vice Mayor Luke had said, where you have one side is saying it's safe and we have all these precautions. I also heard that those precautions could fail because of human error, and humans deliver the gas. Humans put the gas inside those tanks. Humans pump the gas. And I cannot take a chance with the safety of the petroleum products being delivered in a neighborhood and possible effects on wells. The noise is absolutely detrimental. Safety, there is proven evidence of what happens at these kind of commercial entities, whether it be a Dollar General or a gas station, that safety could become a factor. So, yeah, it's convenient. Yeah, there's a convenience store there. You could stop and pick up a hot dog. You could stop and pick up some beer. You could stop and pick up a soda and stop and get gas. But there's a convenience store right across the street too. And there's a gas station less than a mile or two down the road. So for those, I'm done talking. All right, seeing no other hands up, we will go ahead and take a vote on resolution number 2020 R-11, and that is to deny the special exception for the fuel pumps, as the motion was stated by Vice Mayor. City Attorney, just for my own peace of mind, is that motion and stuff okay the way that it was stated?
Yes, ma'am.
Thank you very much. We'll go ahead and take the vote, and we have to do it by voice vote as the motion maker, Vice Mayor Luke.
Yes.
Yes, I am in favor of denying. And then we have Commissioner Carrison.
No.
Commissioner Emmerich.
Yes.
Commissioner Hanks.
Yes.
I'm sorry, sir, for the record, could you please speak up? I didn't hear you.
Yes.
Yes, all right. So that motion passed, denying special exception for the fuel pump. And that passed 4-1 with Commissioner Carasone dissenting. Commissioner Carasone, did you want to state a reason?
As I said, I took great strides in the 16 criterion. I believe that they are all met. I do believe that the intent, being the only one that was here, is also being met. And I think that it could have been mitigated by a reduction in pumps as well as other conditions. Thank you.
Thank you, Commissioner Carasone. All righty, so now we have to move on to the special exception for resolution number 2020 R12, and that is for the car wash. I need a motion, please. Commissioner, Vice Mayor Luke, I see your hand up. Are you ready to make a motion?
Yes, ma'am.
Go ahead, please.
I move to deny resolution number 2020 R12 and find that based on the testimony and evidence provided, granting the special exception will adversely affect the public interest, health, safety, and general welfare. All of the 16 standards listed in section 53-259 of the Unified Land Development Code have not been met, and the competent substantial evidence does not show A, the proposed use shall be consistent with the intent, goals, and objectives, policies, and programs of the City of Northport Comprehensive Plan and the intent of the zoning district as defined in this Unified Land Development Code for the area in which the property is located. B, the density or intensity of the proposed use shall be consistent with the intended future use of the designated land use area in which the property is located in accordance with the provisions of the future land use plan map contained in the comprehensive plan. The proposed use singularly or in combination with other previously approved special exceptions must not be detrimental to the health, safety, welfare, morals, order, comfort, convenience, appearance, or prosperity of the neighborhood or adjacent uses, and shall be an economic benefit to the economy of the city. And D, the intensity in the proposed use shall be harmonious with the character of the other uses in the neighborhood. The remainder are compliant.
So we have a motion on the floor. Do I hear a second? Hearing no second.
I'll second.
Okay, I'll give it to Commissioner Emmerich. I got a motion on the floor by Vice Mayor, seconded by Commissioner Emmerich. Anything to that, Vice Mayor?
My comments on this one are the same as the other. I believe this is more of a industrial type that goes along with gas stations. And I mean, within the definition of the neighborhood commercial, you're not supposed to be having drive-through and that type of activity. And that's what a car wash pretty much would be without a gas station. So I don't find it being consistent to the intent then of what should be within that neighborhood commercial area. Thank you.
Thank you, Vice Mayor. Is the seconder Commissioner Emmerich?
Yeah, I believe that it does adversarially affect the public interest, health, and safety and welfare. And I agree with Commissioner Luke on those statements. That's it.
Thank you very much. Commissioner Carasone, I see your hand is up. Did you want to weigh in or make a comment?
Yep, just a comment. Yet again, the only one that was here when we were actually being the decision-making authority and going through the decision-making process of the intent. I do believe that this was one of the many intents for high intensity neighborhood commercial, and that the drive-through portion was in the lower intensity, things like over on Ponce and Biscayne. So yet again, I believe that we could have mitigated some of the concerns through the neighbors and considering some of the proffered conditions that both city and staff and the applicant had made. I believe it would have been a benefit, and it in my my opinion, yet again, it most definitely meets the 16 criterion. And yes, I'm done.
Thank you. Alrighty, at this point, seeing no other hands up, I'm just going to weigh in again about the comp plan and the economic benefit that neighborhood commercial is to bring, and that half of this property is going to be placed in conservation easement. Also too, once you remove the fuel pumps, then you're bringing in vehicles for a drive-through activity like Vice Mayor had already alluded to. And those car washes are extremely loud and not harmonious with the neighborhood. So for those reasons, I agree with the motion and the seconder. So Commissioner Carrison, your hand is up. Did you want to weigh in again?
Yeah, I just want to state for the record that one of the conditions I was going to propose was that the hours of operations would have been much different than what's being presented. And that would have lessened the impact of the car wash. And I think that the applicant went through great strides to make sure that the runoff is being recirculated versus, you know, going out to the streets like the normal car wash. I just wanted to make sure that you know, the intent was limiting some of the desires for this use, but yet that won't be part of this motion. So thank you.
Thank you. Seeing no other hands up, we'll go ahead and entertain the vote, starting with the motion maker, Vice Mayor.
Yes.
And that is to deny. Commissioner Emmerich?
Yes.
Commissioner Carrison?
No.
And Commissioner Hanks?
Yes.
I'm sorry, again, Commissioner Hanks, I don't know.
Yes.
Yes, thank you. And I too am a yes to deny the car wash. That passed 4-1 with Commissioner Carrison dissenting. Commissioner Carrison, did you want to give a reason for your dissension?
Just to reiterate, I do believe that it meets all 16 criterion, as well as the intent of high-intensity neighborhood commercial. Thank you.
Thank you. All right, so at this point, we will move on to the DMP, which is the Development Master Plan for the actual development. Entertain a motion, please. Vice Mayor, I see your hand is up.
I will move to deny DMP 19-280 and find that based on the competent substantial evidence. B, the proposed development master plan does not comply with the City of Northport Comprehensive Plan, the zoning regulations, or other sections of the Unified Land Development Code and other laws, ordinances, and regulations. That is, I will state specifically because of the 24-hour waiver. I cannot see anything with a 24/7 hours of operation working within neighborhood commercial when it is stated that they aren't, it's not warranted in that area. Thank you.
So I have a motion on the floor. I'm sorry, before we go any further, I do have a motion on the floor, but before we hear us, do we have a second on this? I'll go ahead and second it. So we have a motion on the floor as stated by a Vice Mayor, seconded by myself. Ms. Amber, I do see your hand up. Go ahead, please.
Thank you, Mayor. I'm not understanding in the motion. I don't believe the motion is clear with respect to what law or section of the comp plan the DMP does not comply with. Remember that the DMP comes before you with suggested waivers, but they're only approved if you approve them. So that needs to be specified in the motion for the motion to be sufficient.
Okay, I'm questioning a little bit here. I'm going to need a little more information because I do not see the 24-hour waiver that's being asked. But, so are you just saying what they have proposed? I'm not understanding.
So as I understand it, and certainly we can let the city staff or the applicant's lawyer weigh in for any clarification if that's necessary, but my understanding is that they're requesting a waiver for hours of operation to allow 24 hours. And you can still approve or deny the development master plan with or without that waiver. So for the sufficiency of the motion, there are two different bases under the code why you can deny the DMP. And the first is that it's not specifically adapted and designed for the uses anticipated, including an element of lot configuration, access, and internal circulation. The second, which you selected for the motion, is that it doesn't comply with the comp plan or the zoning regs or other sections of the ULDC or other laws. But you need to identify what it doesn't comply with. So you can still grant the development master plan without granting a 24-hour waiver for the hours of operation for 24 hours. So that in and of itself is not a violation of a regulation or a law. Does that make sense, Vice Mayor? If not, I'm happy to say it a different way.
It makes a little more sense to me. The master plan brings forward special exceptions that were just turned down. So with that master plan then showing special exceptions that were denied, I don't see how I can accept a master plan as presented now. So,
Mayor?
Should that be reworded?
Hang on 1 second, Commissioner Carrison.
Well, I'm trying to clarify. Doesn't it then go right back to being a convenience store, essentially?
See, that, and when I seconded this, I seconded it for discussion because like Vice Mayor said, the DMP that is before us includes a car wash and includes gas stations, both of which were just denied. So now that, and what Commissioner Carrison had said was now it just reverts back to a convenience store with my understanding of them wanting 4 waivers. Waiver for the monument sign, which at this point is irrelevant because there's no gas station. A waiver for increasing the hours of operation, a waiver for the buffer zone, and a waiver for dimensional standards for the bollards instead of curb stops. So is that now what the DMP is that we would either be approving or denying?
Mayor, if I may.
I can't hear you, Commissioner Hanks.
If I may, the way I understand this is that if we approve it, then it is a convenience store. If we approve it with waivers, those waivers, we have to list the conditions, and City Attorney, tell me if I'm right, we would have to list those conditions of 24 hours. We would have to list those waivers or those special exceptions that we are allowing, correct? The waivers?
Those are waivers, and if you were going to grant the DMP with the waivers, that would be part of the motion, is to move to approve it with waivers.
Right.
Now, whether or not this DMP would now have to be redone because it anticipates fuel pumps and car washes.
The way I would understand is if we approve the motion as it stands, it would be a convenience store, a place that you can go shop. There would be no car wash, there would be no gas pumps, and there would be no 24 hours if we just approve it the way it is.
I don't know if that's true based on the development master plan. First of all, in the development master plan motion, you cannot grant those zoning uses that you just denied in the special exception. But I don't know if the development master plan is tailored for just a convenience store, you know, on its face. I'm trying to look through it here on the computer and it's hard to see very much on it.
That was the point I was getting to. I didn't know how I could approve a DMP that's not the same anymore.
So, I mean, if the submission is showing the uses that have been, you know, denied, you know, then the two reasons that you can move to deny it are that the plan is not specifically adapted.
Exactly, it's A.
And the zoning fees is anticipated. You know, it's up to you whether or not it would be B as well due to zoning regulations.
But I can attempt to.
Well, we have a motion and a second on the floor. Hang on one second, Commissioner Carrasone. Based on the conversation, Vice Mayor, I'm willing to remove my second. If you would like to remove your motion, that's your call, but I will be happy to remove my second.
I'll go ahead and remove that motion. Also, the discussion was very enlightening and I see where it should be A as the reasoning. So after you get your questions answered, if you need a motion, I'm happy to do so. Thank you.
Thank you. Commissioner Carrasone, you had a question?
No question. I want to make a motion.
Okay, hold on. I got other lights on. Hang on. Miss Nicole?
Hello. I just wanted to clarify from a staff perspective on the development master plan. You know, we would recommend that it would be that a motion, if you were to approve it, would be to approval with removal of the car wash and the fuel pumps. I don't know that this site, as was stated, would, you know, really would work as exactly designed for just a convenience store. It may need to be modified from there, but that a motion being worded in such that kind of way would work from a staff perspective.
Thank you.
Commissioner Hanks?
Oh, no, man, that was from before, sorry.
That's all right. I do have a follow-up question. How can we approve a DMP as it's being presented, even though the special exceptions have been removed, when it hasn't gone through the DMP process for just a convenience store then?
So the major issues here that a DMP approves are circulation of this site, access, stormwater management. Those are the key issues, utility provisions, and all of those are addressed with this plan. At this point, they would be oversized and would likely be downsized during the major site and development review. But all of those issues have been addressed with this development master plan.
All right, so with that said, this based on the proposal that is before us with the conservation easement and the now convenience store, that is basically the DMP then, correct? Ms. Nicole, you're muted. I can't hear you.
Sorry, I was trying to hit the button. It wasn't working. Yes, that's correct. So you would have the stormwater pond, the convenience store, the general layout of it would be what you would be approving.
Thank you. All right, seeing no other hands up for questions except Commissioner Carrasone, who I think is still wanting to make a motion unless she has a question.
I want to make a motion.
Go ahead, please.
All right, move to approve Development Master Plan 711 with the special exceptions as previously stated being removed, specifically the gas station and the car wash, and the additional conditions, and addressing the waivers. Waiver 1, that the applicant request as per the monument sign is allowed. However, it will meet the nearest activity center design standards while keeping with the 7-Eleven trademark or any other trademark it deems necessary. waiver number 2 to not allow a 24/7 operation, but to allow a limited 5 a.m. to 11 p.m. operation 7 days a week. Condition number 3, to allow a buffer zone only. Condition number 4, as presented. And I believe that's, or I'm sorry, those were waivers, not conditions. Sorry, guys. But those waivers, waiver number 4 about the dimensional standards to be as presented. Waiver number 3 to have the only the buffer zone, and just to be clear. And waiver number 2 being the principal use, allowing for the hours of operation stated, and waiver number 1 being the monument sign to be the design standards as stated and proffered. And I believe that is it, other than the fact that it does meet all of the criteria.
Miss, got a motion on the floor. Do I hear a second? I do see the light on for Miss Amber and Miss Jennifer, but I got a motion on the floor. Do I have a second? Hearing.
Second.
I'm sorry, Commissioner Hanks seconded that motion. Before we get into discussion on that, I'd like to hear from City Attorney and then to Ms. Cohen.
Mayor, with all due respect, I'd like to defer to Ms. Cowan first.
Thank you very much, Ms. Cowan.
I just wanted to bring it to your attention that in the waiver, there was, or in the discussion and in the motion, there was a waiver number 1 to be allowed, and that was for the signage was directly related to that being a fuel service, so it being a gas station. And if it's not a gas station, there would be no justification for the waiver.
Thank you. Is there anything else, Ms. Cowan?
No, that's all.
Thank you very much. Ms. Amber?
Yes, ma'am. I think it might be interesting to hear from staff to see if staff believes that they have the authority under the code to approve modifications of this type to the DMP after the commission approves it.
Do we have to reopen the hearing?
Or would we have to reopen this hearing because what you're looking at is not a finished product, and we're talking about modifications to a DMP that the final decision maker, the commission, can't currently see.
Ms. Nicole?
So Amber brings up a very interesting point. Our code does have a process for administrative development master plan approvals, which generally speaks to it being a lesser intensity. And we've very sparingly implemented that procedure. Again, I think being that this has the maximum, what's shown as the maximum that could be done based on what our staff has reviewed, I'm not entirely sure on it may be something that you want to bring back and see the final product before final approval.
The evidence.
And Mayor, I think if we are going to take testimony on this point, then we need to talk to the party about reopening the hearing.
I agree.
Testimony has been closed at this point. So if we're going to go into that, then we need to get back to the hearing. At this point, the hearing has been closed. There's no testimony on record related to this type of modification.
Thank you. Before we do that, Commissioner Emmerich, your hand is up, please.
Yeah, I just had one question probably for staff under the code. What's the normal business operation hours for a convenience store out there? I know there's a modification from 5 a.m. till 10 p.m. What's normal hours supposed to be out there according to code?
It's 5 a.m. to 10 p.m. in neighborhood commercial.
So it is 5 a.m. to 10 p.m.
Yes,
Okay.
I believe.
Okay, that's all I wanted to know. Thank you.
But the motion is stating from 5 a.m. to 11 p.m. is what is in the motion. All right, so not only do we have to bring this up for the applicant, but we have the two aggrieved parties that we need to bring back into the loop on this too. Is that correct, City Attorney?
Well, I think the board needs to vote on whether or not to reopen the public hearing. And if you, then you can take testimony from the parties and then, close the public hearing again.
And seeing that we have a motion on the floor, are we able to reopen the hearing, or do we need to pull that motion and second to reopen the hearing?
Give me a second to see if the code addresses that, if you don't mind.
Thank you very much. And while you're doing that, while the sun is setting, it's right in my eyes. If you don't mind, I'm going to close my blinds.
Can I ask a question while we're waiting for the attorney?
Go ahead, Commissioner Carousel.
Yeah, just when it was discussed that the monument sign wasn't needed because of the fuel prices, I think, my intent was just to make sure that a sign, be it monument or otherwise, meets a strict standard or criteria of design standards. So I had assumed we had addressed, well, in the past, we've always had to address them throughout the waivers. And since the waiver was only about a prohibited sign in the neighborhood commercial district, I thought that you could then in turn allow the condition that was proffered to be the, design standard, but yet allow a monument sign, kind of as we've done in the past for the Walmart neighborhood center, and also the racetrack, and some others that we actually allowed monument signs. So I was not looking at that waiver request as specific to the gas station portion of it, is what I'm trying to get at.
With that said, I have to ask Ms. Nicole, are monument signs allowed in neighborhood commercial at all?
Mayor, we can't take testimony without reopening the hearing, and I'm ready with the.
Oh, you have that? Okay, thank you. Go ahead.
Yes, ma'am. So in section 2-835C, it addresses this very question. The code provides that if during deliberations, which is what you're doing, deliberating on a motion, a question arises which the quasi-judicial body desires to ask, it shall reopen the public hearing, pose the question or questions, and allow each party the opportunity to respond to each question posed prior to then closing the public hearing and resuming deliberations. So no, you do not need to pull the motion or the second off the table. However, whatever questions you all want to ask, you will need to ask one at a time and allow each of the four parties the opportunity to answer. Before doing that, you'll need to reopen the public hearing and do that by motion, pose the questions one at a time, and then close the public hearing.
Thank you, Ms. Amber. Can I get a motion to reopen the hearing, please?
I'll second it, but I had my hand up because even though she said that we don't have to remove the motion, I think to keep it cleaner, to go back in for the questions and then come back out and form a motion with more understanding, I think would be for the best.
City Attorney.
That's certainly an option.
As the original motion maker was Commissioner Carasone. Who was the original seconder, City Clerk?
It was Commissioner Hanks.
Thank you very much.
Mayor, I'm okay leaving the motion there.
Thank you. As the seconder, you're okay leaving the motion as the main motion maker, Commissioner Carasone?
I'm absolutely leaving the motion there.
Thank you very much. Okay, so we will leave the motion on the table, but we need to have a new motion to open the hearing to discuss the DMP and ask questions.
So moved.
And I seconded.
Motion on the floor to reopen the public hearing by Commissioner Hanks, seconded by Commissioner Luke. Anything to that? Seeing none, we'll go ahead and, I'm sorry, Commissioner Armich, your hand is up.
No, it was up from before. I'm sorry.
Okay, thank you. I didn't see it before, so I thought it was new. Thank you. All righty, seeing no deliberation on that, we'll go ahead and do voice vote. Commissioner Hanks to reopen.
Yes.
Commissioner, Vice Mayor Luke,
Yes.
Commissioner Emmerich,
Yes.
Commissioner Carasone,
Yes.
and myself, yes. So we are now reopening the public hearing to ask questions regarding this DMP. As the motion maker, did you have any questions for any of the parties? Commissioner Carasone?
I did, and what was it? The monument sign. I kind of alluded to it earlier. The monument sign is not allowed in neighborhood commercial, from what I understand, and we've had to do waivers in the past, which is why I essentially thought that this particular waiver was in addressing that function. And we've approved them in the past. So I didn't know that it was specific to a gas station. Only you would have that application, but can I get an answer on that?
In regards to the monument sign,
Your name, please, ma'am.
Nicole Galehouse, for the record, planning manager, and I have been sworn.
Thank you.
For the neighborhood commercial zoning district, it's not just that monument signs are not permitted, they're actually listed as a prohibited sign. So we cannot give a waiver to something that is prohibited by our code. The only reason that it would be allowed in the proposal that was initially presented to the commission today is because Florida statutes preempt us as it relates to gas station signage and signage for fuel prices. So without the fuel pumps, we cannot, we don't recommend approval of this waiver.
So in the past, how is it that others have been allowed to have monument signs? Because I know they have.
They're in different zoning districts. The neighborhood commercial zoning district specifically does not allow monument signs.
I could have sworn there was. It may not have been built, but I'm pretty certain we allowed it, even though it did not go through and come to fruition. But okay. Any other conditions here that you saw an issue with that I had addressed?
No, ma'am.
Thank you.
Seeing no other questions, I'm going to raise it. I guess not, because it had to do with the monument sign. All right. Would the applicant like to weigh in on that question?
For the record, Jeffrey Boone, representing the applicant. No, ma'am, we're satisfied with the record the way it is, so we have no further testimony or evidence.
Thank you very much. And our aggrieved parties, Ms. Tracy, regarding the monument sign and the code requirements.
Could I get a little bit of clarification, please, on a few questions?
As long as it has to do with the monument sign, that's what we're discussing right now.
Okay, so this is just in regards to the monument sign, correct? Yes, Madam Mayor, this is just asking approval of the monument sign. Is that correct?
No, we were asking if a monument sign is allowed in neighborhood commercial, and staff has already weighed in that our code does not allow it. The applicant had nothing to add, and I'm asking if you wanted to weigh in with any testimony to this, or if you were going to.
No, I have no testimony to add.
Thank you so much. Moving on to Ms. Leslie, do you have anything to add regarding the code and monument signs?
No, ma'am.
Thank you very much. Is there any other questions?
Yes, Mayor. I believe that by opening it back up, I think that you're supposed to allow any testimony. Maybe Ms. Slayton can, confer or deny that, because we're opening the testimony back up. It's not limited to those items. No.
No, ma'am.
Only for questions, but we'll get the city attorney.
If there's a question in which the body desires to ask, it shall reopen the hearing, pose the question, allow each party to answer. It does not reopen for presentations in general, general evidence and testimony.
Okay, I wanted to make, because that's not how that it is done in the past or in other government entities. That's why I was trying to get it clear. Thank you.
The only other question that I have is based on the conversation that we had with the applicant during our question and answer time, when we had discussed adding the buffer wall with the landscape buffering along the two entrances to shield the properties that are directly affected of the headlights coming into their property. I just want to ensure that the applicant still has that on the table, and if we could, or that was, I believe, agreed to, but I just want to make sure for clarity.
Could you, just to make sure?
I can't hear you, sir.
Can you hear me now?
A little bit better.
Okay. Yes, ma'am. So it's been a long day. Could you please repeat? I want to make sure I would answer your question the way you ask it. Could you ask that again, please?
So we have the two homes that are right next to the entrances, exits of the property. And earlier, your testimony was that you would be willing to put up a barrier wall and the landscape buffering. So that way then those properties are shielded from the impact of the cars coming in and out of the property.
And that is not presently shown on the DMP as it exists now, correct?
It is not. That's why I'm asking the question. And
now we request a vote up or down on the DMP. Again, we're satisfied with the record the way it exists right now, and we have no further testimony or evidence.
Thank you. Vice Mayor, your hand.
Yes, ma'am. Thank you. My question is in regards to the motion. She addressed the waivers in the motion, but there are 5 conditions also for the DMP. So are they supposed to be addressed now too?
Yes, those should be addressed with the motion as well.
Thank you.
Yeah. And does anybody else have any questions to add to the testimony? Hearing none at this time, we will go ahead and reclose the public hearing and go back to the motion that is on the floor. Commissioner Carrison, do you want to restate it, or do you want me to see if the city clerk could reread it, please?
Was trying to get to the conditions that were just stated. I'm sorry, before you closed it, but I can't hit my button fast enough. My point, I'm trying to get to the 5 conditions because I thought the majority of them had to do with as presented, and now that we have a completely different viewpoint of it, I'm not sure if many of those conditions even are applicable. So before we close it, can we get an idea by staff which ones are still applicable. If I can ever open this thing.
City Attorney, since I officially closed the public hearing, do I need to revote to bring it back open again? Or
Yes,
a procedural question?
Yes, ma'am.
I'm sorry, I didn't hear you.
Yes, ma'am.
I move to open the hearing again.
Second. Got a motion on the floor to reopen the public hearing to ask this question by Vice Mayor, seconded by myself. Ms. Cohen?
Huh?
Yes, I was just, I'm sorry, I had a question for the board that may help in clarifying this, and it's actually directed towards the applicant as to whether or not
on the motion to open.
We had, hold on one second. Hang on one second, guys. Because I officially closed the first round of reopening, and then Commissioner Carusone has a question regarding conditions, I have to reopen the public hearing. That's what the motion is that's on the floor, is to reopen for round 2 of questions. That was made by Vice Mayor, seconded by myself. Ms. Cowan, does your questions relate to the motion that's on the floor?
No, ma'am.
Thank you very much. All right. Commissioner Carusone, do you have a question about the motion that's on the floor to reopen so you can ask your question?
My concern was that we didn't take the motion before hearing public, but reopening, but go ahead. Just want to vote on it.
That's what I'm trying to do, ma'am. Vice Mayor, you have a motion on the floor. I seconded it.
Yes.
Hang on one second. I see hands up, so I don't know if you have a question about this motion on the floor. If you do not, please remove your hand.
Love to, if it work.
Ms. Cowan, do you have a question with the motion that's on the floor? Thank you very much. Okay, we are going to take a voice vote to reopen this public hearing for additional questions. Vice Mayor is the motion maker.
Yes.
Myself, yes. Commissioner Carusone.
Yes.
Commissioner Hanks.
Yes.
Commissioner Emmerich.
Yes.
Okay, so now we are back into quasi-judicial proceeding that has been reopened for round 2. And I do believe Commissioner, I'm sorry, hold on before you begin, Commissioner Carusone. Ms. Cowan has a question now that we're reopened, or a statement, not sure.
It was just a question based on what the applicant had last stated with regard to the DMP. My question was just whether or not they're wanting to proceed with the DMP, given that the special exceptions have been denied.
That's a great question.
Yes, Madam Mayor and Commissioners, for the record, Jeffrey Boone representing the applicant. And as stated before, we're satisfied with the record the way it exists at this time. We have no further testimony or evidence. And whatever the board wishes to do with respect to the DMP is whatever the board will do. Thank you.
Not sure if that answered your question, Ms. Cowan. It's only for you to decide.
Not really, but that is the answer they provided.
Thank you very much. All right, Commissioner Carusone, your questions, please.
Yeah, I'm actually trying to pull up those conditions.
Page 30 of the staff report.
It'd be great if I could actually get the staff report up because, you know, you got 2 computers here. So the question to staff was, out of those conditions, do they all apply, or are they certain ones that you need to be applied?
For the record, Nicole Galehouse, Planning Division Manager. I have been sworn. All 5 conditions still apply with or without the special exceptions being granted.
And including those amendments that I had stated, the additional conditions to the waivers.
I'm not sure what you mean.
Never mind. Okay.
Ms. Amber, you have your hand up, please.
Yes, ma'am, Mayor. The motion before the commission relates to modifying the DMP that's been presented by the applicant. I think it would be worthwhile to also inquire of the applicant whether they concur with these changes to the DMP or not.
Thank you. Mr. Boone, you can tell I'm not an attorney and I have to rely on ours quite heavily on this matter because this is quite unusual, I think, for everybody involved. So Mr. Boone, based on the city attorney's recommendation, would you like to weigh in on these motion that is on the floor?
I want to proceed very cautiously here because a record has been made. Almost 6:30 and we started at 9. I don't think I'm being asked to comment on a motion. I think that would be improper. I think a motion is made and seconded and then it's debated and decided by the board. I don't think in a quasi-judicial hearing any of the parties can engage in debate about a motion once it's made.
And Mr. Boone, I agree with you wholeheartedly, but because we had questions that were outside of the realm without having to open up the public hearing, and that's why we were asking questions, we need to give all parties an opportunity to weigh in on the answers at the advice of our city attorney. City attorney, I can't hear you.
I suspect that Mr. Boone's response had a little bit to do with the wording of the question that was posed to him. And what I would suggest that the board ask the applicant is, does the applicant agree to modify their DMP to remove the car wash and the fuel stations?
Okay. So Mr. Boone, seeing that the special exceptions that you had requested were denied, and now your DMP has changed considerably, are you wanting to go forward with this DMP as it is now standing before us today?
No, ma'am, that's not the question. The DMP has not changed. The DMP is still standing with the board. The board is discussing, whether or not the DMP should be changed. So my question is, does the applicant want to change their DMP or not?
But the DMP has changed because there's no gas stations and there's no car wash.
The DMP is still before you as is. It has not changed. It doesn't automatically change because of something that happened before it.
Okay.
And the applicant submits the DMP. So if the applicant would like to change their DMP to remove these two elements, all elements that are related to one, the car wash, and two, the fuel pumps, then that's something I think the commission needs to know.
Mr. Boone?
So the question is, Madam Mayor, and again, I apologize, but we've created a very lengthy record, and I don't want to misanswer a question. So could someone please state, I heard what Ms. Slayton asked. If someone could please restate that on the record, then I'll be pleased to answer it.
Mr. Boone, are you willing to change your DMP? Is that the question that we're asking, City Attorney?
Yes, ma'am.
Madam Mayor, maybe I can help. If what you are asking me is if the applicant is willing to modify the DMP at this late stage in the game, my client's answer, we've checked with him, our client's answer is seeing as though staff has recommended approval of the DMP, they did not recommend approval of one of the waivers and basically said one of the other waivers is really out of their control because of state law, but otherwise staff has recommended approval of the DMP, then, excuse me, then our client does not agree to any modifications to the DMP.
Thank you. I'm trying to formulate this next question. So if we have a DMP, if let's say this motion is passed, that means there's a DMP on this property that was approved based on the motion. Is that correct, Ms. Nicole?
Yes, I would believe so.
But the special exceptions are not approved.
Correct.
Okay.
Those portions of the site would essentially not be permitted to be built? I'm not sure.
Mayor, I can just, I just remove my motion. Can I do that now?
I will remove my second.
Yeah.
All righty, so we are still in public hearing. Can you guys hang on with that motion removal and stuff like that? Does anybody else have any questions for the applicant or anybody else or staff or any of the aggrieved parties while we are in our quasi-judicial hearing?
Mayor, it sounds like to me that that it's all over because the applicant's not willing to make any changes. So I don't know whether there'd be any other questions to ask.
Thank you. All right, so now I am going to, for the second time, and this is only just so that we can keep the record clean that I'm saying it for the second time, we are officially closing public hearing of this quasi-judicial proceeding. We have a motion on the floor still officially. If you would like to have that removed, I need to hear that now, please.
Mayor, I want to change it, so I'm removing it.
Thank you. Commissioner Haynes, is it okay to remove? Thank you. So we do not have a motion on the floor at this point.
I will move to approve the DMP as presented with the conditions by staff recommended.
Do I second?
Yeah, hold on, Mayor. I'm just thinking real quick. I'm looking at something. 1 second for me.
So I have a motion on the floor to approve as presented with the conditions presented by staff 1 through 5 by Commissioner Carusone. Do I hear a second?
Yes, ma'am. Hold on 1 second. I'm just trying to look up something really quick.
You can second it and then vote it down.
Okay. Yeah, I second it.
The motion is not sufficient because it doesn't make findings. The motion needs to include, as presented in your motion sheet, that based on the competent substantial evidence, the development master plan meets the standards in section 53-7 of the Unified Land Development Code.
And that was why I was waiting really quick. I was trying to pull it up. My computer shut off.
So as is, your motion does not have any findings which are required.
So I removed my second because I was looking for that.
Commissioner Carusone, I need you to please move your motion since it is not sufficient.
Yes, and I will restate it.
Do you have your motion sheets, ma'am?
No, I don't have a motion sheet. I already said that 3 times. I
was hoping you might have found it in between.
No, not when you're trying to look for other things. Move to approve the development master plan based on competent and substantial evidence. And there was something else. Hold on. pursuant to the City of Northport's ULDC code 53-259, no?
It needs to include a finding that it meets the standards in 53-7.
53-7. And that it meets the standards of 53-7. I believe that is what was said, right? And including all of the waivers and conditions thereof by staff. Excluding waiver number 1, which is no longer necessary. Would that be correct?
That's your motion, Commissioner Carrasone. I don't want to interrupt you if you're still thinking.
I'm actually looking to the city attorney to see if that was phrased correctly, because it sure sounded like a cluster to me. Yes, it was, Commissioner, or I'm sorry, Mayor McDowell. Thank you.
A motion on the floor to approve the DMP based on the substantial competent evidence. The development master plan meets the standards in 53-7 of the ULDC that was and approving waivers and the conditions 1 through 5 by removing waiver number 1 related to the sign. Is that a correct statement of your motion, Commissioner?
Thank you. That sounds so much nicer. Yes.
Do I hear a second? Hearing no second, motion failed.
Sorry, Commissioner Carrison, does that include the 24-hour waiver?
Yes, it does.
Okay, I can't.
No, staff denied the waiver. 24 hours. It's with all staff conditions and waivers.
Commissioner Carrison, you did not say staff waivers, you said waivers. That's why I restated it that way. You did not say staff approved waivers. Staff does not make. All right.
My God.
Commissioner Hanks, did you second that motion or not? Because you started.
I will only second the motion without the 24-hour waiver.
Mayor, I'll try a motion.
I have a second and a motion already on the floor, Commissioner, Vice Mayor Luke.
Okay, I didn't know he seconded it.
No, I didn't second this one.
Oh, I thought you said you did. I'm sorry. This is one of the biggest drawbacks to virtual.
Mayor, I don't know if this matters, but her motion did say including all waivers and conditions by staff excluding waiver 1, which is no longer necessary. I don't know if that applies to what you're saying.
Someone who's paying attention.
Sorry, you broke up. Heather, you broke up.
Her motion was to approve based on competent and substantial evidence pursuant to ULDC 53-7, including all waivers and conditions by staff, excluding waiver 1, which is no longer necessary.
Okay, I can second that.
I have a motion on the floor as stated by Commissioner Carrison, reread by the city clerk, seconded by Commissioner Hanks. Anything to that, Commissioner Carrison?
No.
Commissioner Hanks? Commissioner Hanks, if you need to speak, could you please unmute?
No, I don't have anything to that.
Thank you very much. Vice Mayor, you have your hand up.
Yeah, I was going to make a motion, and I don't know if it was necessary to put in that the special exceptions of the DMP were denied so that it doesn't stay the same, but agreeing with the 5 conditions and then 2 of the 4 waivers. So as long as the special exceptions are known not to be part of the DMP, I'm okay with it, but I need to make sure that the motion wasn't supposed to state removing the special exceptions. Because to me, it kind of leaves the DMP the way it is. So just, I need a little bit more clarity before I can vote.
And Vice Mayor, I agree with you too. I don't know exactly what is being voted on with this DMP regarding the special exceptions, which waivers and stuff. There was also a waiver regarding the buffer area. There was also the conservation easement. There was also the buffer wall being built by the two entrances with the landscape buffer to help shield the access and ingress and egress to the property for those residents. So I need to have absolute clarity as to what I am voting on with this DMP. And right now, I'm sorry, I don't have it. Commissioner Emmerich?
Yeah, I have a question for the clerk mainly, because I'm still a little bit confused. But with this motion that's on the table right now, is it including the 24-hour operation, or does it take it out with this motion? I'm confused. You know, we've talked about it, but I know it was presented by staff to deny it, but I don't think it specifically said in the motion that it's being denied. So I'm confused on that right now. That's where I'm at. That's all. So if I can get a clarity on that, I'd be happy.
As presented by staff, which means it's denied.
City Attorney, is that?
Mayor, if you all don't know what you're voting on, that means the motion needs clarification.
Absolutely. So we have a motion on the floor. I don't see any other questions, but I've heard a lot of commissioners not too sure exactly what is being voted on. So we will go ahead and take the voice vote to clear this motion once and for all and see where it goes from there. As the motion maker, Commissioner Carasone. Your vote, please?
I just want to reiterate that the resolution, let's see here, the approving of the 4 waivers with the conditions and those that were denied by the staff, of which was the, let me pull them up. One, because the other special exceptions were denied, it will no longer apply. So, as I understand it, the 7-Eleven would be built. It would have the walking path, and the park would be dedicated to the city, and the staff responses are all going to be adhered to. So for instance, waiver number 2, staff did not support, therefore that would not be part of it. Number 3, which is the zone, staff supported it with a passive park replacing the standard buffer. Waiver number 4, staff supported that waiver. That is what would be voted on. Just for clarification prior to the vote.
So again, I was calling the question. Commissioner Carasone is the motion maker. Your vote, please. Oh.
Yes.
hang on with that. Ms. Cohen, I see your hand is up. Did you have a question or comment?
I had a brief comment, which was if the board is interested in hearing what staff's recommendation would be in light of the denial of the special exceptions, I'm not sure that you have that, you've been provided that information.
And I am, we have a motion on the floor. Commissioner Carrison, would you mind if we hold off on the vote to hear from?
Honestly, Mayor, if this is going to drag on more, I'm going to pull my second. I mean, it doesn't sound like this is going anywhere.
Thank you. So are you officially pulling your second, Commissioner Hanks?
I'm ready to take the vote. If we don't take the vote now, yes, I will pull my second.
Oh, the question was called, so essentially the vote should be taken.
Thank you. Commissioner Carrison was a yes. Commissioner Hanks?
And I'm a yes.
Commissioner Emmerich?
I'm still not clarified on that 24/7. I'm a no at this point.
Thank you. Vice Mayor?
I have to say no because it's too unclear.
And I am also a no for the exact same reason. It is unclear. The motion is not clear enough for me to be able to vote confidently. So the motion failed for reasons stated by myself. Commissioner, Vice Mayor Luke, did you want to state your reason?
I did because it wasn't clear enough. I don't have enough information on the DMP. As Ms. Cowan said, we haven't heard from staff to know what it would look like. And we just, in my opinion, I just need more information on what this DMP is looking like that I'm supposed to be approving today or not approving.
All right. Commissioner Hanks, your hand is up, please.
Yes, ma'am. Yeah, the motion was clear to me that that what we were approving was a small store, which perfectly fits everything, without the waiver of 24 hours. There would be no 24 hours. It would go with what the code states, which would be 5 to 10. Thank you.
Thank you.
That's why I voted yes for it, because I believe it fits everything. Thank you.
Commissioner Emmerich, did you want to weigh into your dissension vote?
Well, and it may have been clear to Commissioner Hanks, but at the point it was not clear to me. But I would have voted yes if it was more specific and clear. And I would have voted for the 5 to 10 and not the 24/7 as what the code states. So that's where I was at.
Thank you. All right. Commissioner, I'm sorry, Ms. Cowan, your hand is up, please.
I apologize, that's left up.
Thank you very much. Ms. Amber, your light is up.
Thanks, Mayor. Just because I'm anticipate there will be another motion coming, just a reminder, and I know that it has been a long day, but the motion language is very important with respect to fulfilling the requirements of the quasi-judicial hearing. And I would remind the commission of two things, and one, point you back to your suggested motion script that has the finding that must be made if you're approving or denying. And again, if you want to approve with any conditions or waivers, to specifically read those into your motion rather than referring back to waiver 3 and condition 4 from the staff report. It doesn't give us a very clean record, and it lacks definition for the commission to potentially be able to vote knowingly and understandably. So if you just think of those two things when you're crafting the language, even though it's late, it is still very key.
Thank you very much for that reminder, City Attorney. Commissioner Hanks, I see your light is on. Did you want, okay, I guess not. And if nobody else is ready to make a motion, I will be happy to pass the gap. I'm sorry, go ahead, Vice Mayor.
I'll go ahead and attempt a motion.
Thank you.
Move to approve with conditions. I move to approve DMP 19280 without or with taking out the special exceptions with the following conditions. One, allowing flow from the site that can be discharged into Price Boulevard cannot exceed the flow permitted in the drainage model that was approved by Swift Mud in permit 430-44411.000 issued February 13th of 2020. Two, the allowable flow from the site that can be discharged into Cranberry Boulevard cannot exceed the existing condition flow into Cranberry Boulevard. Three, the driveway connections to Price Boulevard and Cranberry Boulevard shall have structural channeling devices to limit to right in, right out access. Four, the Price Boulevard driveway connection and the storm drainage discharge connectivity may need to be revised to existing conditions of Price Boulevard if the proposed development is constructed before the Price Boulevard widening project construction phase is completed. Refer to stormwater manager comments regarding stormwater discharge volume and flow rate in condition 1. And then 5, the construction phase of the Price Boulevard widening project is anticipated to last several years from start to finish, and the development shall expect associated business impacts. Based on the competent and substantial evidence, the developed master plan meets the standards in sections 53-7 of the Unified Land Development Code, having those 5 conditions and approving waiver 3, waiver 4, denying waiver 1 and 2.
And for the record, Vice Mayor, did you want to state what waiver 3 and waiver 4 was?
Waiver 3 is buffer only. Per the presentation today, they removed the park. They described it as the buffer or the conservation area. And then waiver 4 are the wheel stops.
I'll second.
I have a motion on the floor by Vice Mayor as stated, seconded by Commissioner Emmerich. Vice Mayor, anything to that?
No, I believe per what the city attorney was stating, I think that should encompass everything. If not, if she would please tell me, I would appreciate it.
That is a sufficient motion, Vice Mayor.
Thank you. And for clarity, Vice Mayor, did you mean in waiver 4 was to allow bollards instead of wheel stops? Is that what you were referring to with your waiver?
Yes, ma'am. Yes, ma'am. The two being denied, of course, were the monument sign in the 24-hour.
Thank you. Commissioner Emmerich as the seconder, did you have anything to that?
Perfect. I'm good with that one.
Thank you. Anything else? Seeing no others, I think we need to make an amendment to the motion to include the design standards for the nearest activity center and also the buffer wall for the adjacent properties for the entrances for a buffer wall and a landscape, what is that called? A landscape buffering along that entrances that the applicant spoke about during the quasi-judicial hearing. So at this point, I will go ahead and pass the gavel to add that amendment to ensure clarity that those two things are taken care of.
What was the first one, please?
I'll make a clean motion. I was
okay. Go ahead, Mayor.
All righty. So I'd like to make an amendment to the motion that the 7-Eleven design standards would be for the nearest activity center, keeping the 7-Eleven coloring and brand, and also the buffer wall adjacent to the 2 entrances, ingress and egress, on the one on Price and the one on Cranberry, to include a buffer wall and landscape buffer for both of those residents.
All right, so there is a motion for an amendment on the floor. that the 7-Eleven convenience store would need to follow suit with the nearest activity center design standard, and a wall be built at both entrances to block the lights going into the residence. Is there a second? For lack of a second, that amendment fails, and I'm giving the gavel back to the mayor.
I was gonna second.
Okay, I know this thing is really hard to get these things to come up. So we have an amendment and we have second. We'll go ahead and allow mayor to speak to that.
I think it's important for the 7-Eleven to be able to use their colors for whatever designing that they're going to be doing. I also think it's very important that the two residents on the nearest to the entrances and egresses have protections from the lights coming off of the property and the sound. So thank you for the second, Commissioner Carrison. That's all I have to say to it.
Commissioner Carrison, would you like to speak to it?
No, ma'am.
Does anybody else have anything to state before we take the vote? Seeing none, Mayor, your vote?
Yes.
Commissioner Carrison?
Yes.
Commissioner Hanks?
Yes.
Commissioner Emmerich?
Yes.
I'm a yes also. The amendment to the motion passes 5-0. Going on to the main motion now. Or do you want me to pass the gavel back to you, Mayor?
Go ahead. You're on a roll.
Okay. Mayor, your vote to the motion as amended.
Yes.
Commissioner Carrison?
Yes.
Commissioner Hanks?
Yes.
Commissioner Emmerich?
Yes.
I am a yes also. The motion with the amendment passed 5-0, and gavel is back with the mayor. Thank you.
Thank you very much. I believe that that is all we have regarding the DMP, the two resolutions. So at this time, seeing no other comments, we will go ahead and do the final public comment portion of this meeting. Is there any public comment, City Clerk?
No, there is not.
Thank you very much. Before I adjourn, I want to thank the applicant. I want to thank the staff. I want to thank our two aggrieved parties. This was a very long meeting, and I understand the importance of everybody's participation to ensure that everything was done according to Hoyle. And I appreciate everybody's empathy with the problems that technology can create. And I also want to thank my fellow commissioners. This was a big meeting, and I think it went well, and I want to thank everybody for their time and consideration. And if anybody else has anything to add, please raise your hand. Seeing none, it is now 6:55, and we are officially adjourned. Thank you.